in the name of another advocate. Lordship, I have obtained it. Should Lordship kindly be pleased to grant us the leave.
Leave granted to use the
Grateful, Lordship. Grateful.
My lord, with my lord's leave, I'm mentioning a commercial suit. In this matter, my lord had, by order dated 11th June 2025, had appointed a special referee to decide the question of mean profit, my lord, and had directed the special referee to file a report within 4 months, my lord. The 4-month time period is going to expire in the puja vacation, my lord, and the proceeding won't get over by that time, my lord. My lord, seeking extension of time.
Let them come after puja vacation. If complete after puja, let come after puja vacation. Mention the matter, then we'll see to that.
Very well.
I seek my lord's kind leave to mention a matter, my lord. In my application for seeking extension to file my written statement, my lord was pleased to extend the time to file my written statement subject to payment of a cost of 5,000 within a week, my lord. My lord, the week got over on Tuesday, my lord. Because of the incessant rain, I could not come and take any steps, my lord.
No. Once the grant written statement, there is no leniency. Once the court has passed an order, you should be in the.
My lord, the written statement is already on record, my lord. It has already been filed, my lord.
You pay the cost. Go and pay.
My lord, my check is ready, my lord. The time is required to be extended, my lord.
What extended? When the order was passed?
My lord, the order was passed on 15th. It was uploaded on 16th of September. It was supposed to be deposited within a week, my lord. My lord, which got over on Tuesday. My lord, because of the heavy rain, I could not come to the court and take any step, my lord. My lord, simply an extension of today's time. My check is ready. I will deposit it today.
So leave is granted to deposit a check today.
Lordship, may I permitted to mention the matter?
Lordship, obliged, my lord.
Lordship, mentioning upon notice, Lordship kindly extension for time for witness action.
Extension of time for witness action.
Yes, Lordship.
What?
Lordship, let the matter appear on fixed on 4th November 2025 for filing report by the commissioner.
Let come on 4th. We'll see to that. If it is not, then we'll see to that. Come on 4th. For judgment non-commercial. 11.
Item number 1 and 2. Item number 1 and 2, I appear for the pro forma defendant.
Lordship not had. How does not file the written statement?
Yes.
I think there's some note.
Huh?
There's a mistake not in the CA number.
G4 and G5.
Our G4 and 5.
57 4 hai.
The order has gone and got in 3.
0 5. The matter is listed as to be mentioned for correction in the order dated 18 September 2025. It is submitted that in the cost title of the order dated 18 September 2025, GA number in connection with CS-Com 667 is wrongly recorded as GA-Com 3 of 2025 instead of GA-Com 4 of 2025. Simultaneously, GA number in connection with GA-Com 680 of 2024. It is
CS-Com.
GA-Com 680 of 2024. No, CS-Com 680 of 2024. The GA number is wrongly recorded as GA-Com 3 of 2025 and GA-Com 4 of 2025 instead of GA-Com 5 of 2025. Consider the submission made by the counsel for the parties, peruse the record in the order dated 18 September 2025 in connection with CS-Com 667 2024. GA shall be read as GA number shall be read as GA-Com 4 of 2025 instead of GA-Com 3 of 2025. Similarly, in connection with CS-Com 680 of 2024, GA shall be GA-Com GA number shall be read as GA-Com 5 of 2025 instead of GA-Com 3 of 2025 and GA-Com 4 of 2025. This order may be incorporated
Only
with
one
the
thing,
order
my
dated
check, my check was ready, my lord, because of this mistake, my lord. I kindly not extend the time till tomorrow, my lord, to pay.
September 2025. उसमें एक्शन दे दो.
But just
Leave,
extend it, not
leave is granted to the defendant to pay the cost by tomorrow
by two. I'm grateful.
in the department.
Fine.
But the service authority, na?
Yes, my lord. Yes, my lord. They are saying that it should be legal services committee, my lord.
Legal service. High
So
Court
we'll make it committee, my lord. We'll notify.
Gratefully. May it please your lordship, my lord.
Yes.
I'm appearing on behalf of the plaintiff in this undefended suit, my lord. But this your lordship, my lord, was pleased to pass an order appointing a commissioner to conclude the witness action. We had 4 witnesses. 2 witness actions is already complete. My lord, further 2 witnesses would be required. We are sure to complete it within 1 day itself. And may we be permitted to file our affidavit of evidence of the 2 witnesses? Your lordship can extend the mandate of the commissioner till 15th of
I'll be
November.
for the commissioner.
As your lordship kindly grants us this leave, my lord, we'll do that.
So today is fixed for filing report.
Yes.
So you want extension of time?
Till 15th November, we'll complete definitely.
The matter is listed as to be mentioned for filing report by the advocate commissioner. So the counsel for the plaintiff submitted. 2 witness examined.
2 witnesses have already
2 witnesses of the plaintiff are already examined, and remaining 2 witnesses are yet to be examined, and accordingly, he prays for extension of time to file report by the commissioner. Consider the submission made by the counsel for the plaintiff. Time to file report by the commissioner is extended. How much time you required?
Milord, till 10th or 15th of November, Milord,
For
we'll
a further
certainly
period of 4 weeks after Puja vacation. The commissioner director filed the report by 2nd December 2025.
kindly, Milord, grants us leave to file the affidavit of evidence of Archana Paul and Bani Paul.
The plaintiff has a liberty to file the affidavit of evidence
Of Archana Paul and Bani
of
Paul.
2 witnesses, namely Archana Paul and
Bani Paul.
Bani Paul, before the commissioner at the time of examination of the witness on commission.
I'm deeply obliged.
Next.
Your Lordship, I am appearing for the plaintiff. Your Lordship had given us liberty to correct the defects, Your Lordship. Your Lordship, however, the plaintiff, the authorized representative, Your Lordship, his mother is not well, and that's why he had to travel out of station, because of which we could not cure the defects, Your Lordship, within 2 weeks. Lordship, I'm just seeking an extension of time to cure the defects, Your Lordship.
As for the prayer made by the counsel for the plaintiff, time to cure the defects in the plaint is extended for a further period of 2 weeks after Puja vacation. Immediate after rectification of the defects, the plaintiff shall re-verify and reaffirm the affidavit within a week thereafter, and to take appropriate steps for lodging writ of support.
So grateful, Your Lordship.
In item number 7, Mr. Shayantan Basu is appearing for the plaintiff. My lord is stuck somewhere in the traffic. Your lordship, kindly allow me a short passover.
Not today. Next.
Your lordship, I appear on behalf of the plaintiff, sued for recovery of money lent and advanced. So for once, my client has advanced money and not taken it. Your lordship, very short matter. Your lordship had already passed an order. There was a suit filed. Your lordship was pleased to dismiss it only on the ground that this should have been a commercial suit instead of a non-commercial suit. Your lordship's order is at 13th, is at page 111, dated 13th of November 2024, volume 2. If your lordship kindly takes up. Annexure M at page 111. Now, may I?
Yes. So what has happened now?
Your lordship, thereafter, Your Lordship, we've undergone mediation process. No settlement arrived at. We have filed a suit. We have complied with 12A. Now, Your Lordship, this injunction application to secure. Lordship kindly takes up page 115. There's no dispute that they have received the money. In fact, Your Lordship, I've also brought their affidavit in opposition and record to show that. Kindly sees Your Lordship's noting at page 115, paragraph 11. The defendant, Mr. Biswas, submits that whatever the money advanced to the defendant was done by the plaintiff for their own business interest. This is their allegation, so they admit that they have received the money. Thereafter, Your Lordship kindly comes to paragraph 16 at page 116. This is Your Lordship's finding. Lordship, this was with regard to the commercial point. And Your Lordship will find page 122, right out below the set out. Your Lordship has again taken note of the fact that the defendant has admitted that the money was received by the defendant.
122.
122, yes, Your Lordship. In the affidavit in opposition, the defendant has taken a specific stand. Whatever money have been actually advanced to me were done so by the plaintiff for their own business interest. So Your Lordship has taken note of the admission made by them. Nothing on merits, Your Lordship. They were only contesting on commercial, non-commercial and Bengal Money Lenders Act. With regard to commercial, non-commercial, Your Lordship was pleased to come to a finding at paragraph 21.
Yes.
Paragraph 21 at page 123 that the suit appears to be commercial. Paragraph 21, Your Lordship holds, in the present case, initially there was no document which was entered between the parties with regard to the first loan, but subsequently 3 agreements were entered between the plaintiff and the defendant with respect to the loan, and the plaintiff has relied upon the said agreement in the present suit. Considering the above, this court finds that dispute involved in the institute satisfied the definition of a commercial dispute. Thereafter, Your Lordship, paragraph 22 onwards deals with the legal point of Bengal Money Lenders Act, where Your Lordship has come to a specific conclusion in paragraph 25 at page 127.
Yes.
Paragraph 25 at page 127. Considering the above, this court did not find any merit on submissions made by the learned counsel for the defendant that the Bengal Money Lenders Act is applicable in the present suit. So, Lordship, these 2 legal points were raised. Commercial, Your Lordship was pleased to hold against me. Bengal Money Lenders, Your Lordship was pleased to hold against them. And Your Lordship has taken note of the admissions made by them in their affidavit of in opposition that they have received the money. If Your Lordship wants, I can point out the specific paragraph in their affidavit in opposition as well. Your Lordship kindly takes up page 98.
Yes.
Volume 2.
Yes.
So paragraph B, last line. I say that whatever money have been actually advanced to me were done so by the petitioner for their own business interest. The suit has also this application cannot be filed in the manner petitioner has done. So he admits that he's received money. Again, Your Lordship, at page 100. Again at page 100, Your Lordship, the first paragraph, last line. The money were paid in my account by the petitioner at their own wishes, as the petitioner fully knew my bank account number, etc. for a long time. So there's no dispute as regards to the merits. The earlier suit, Your Lordship, was...
So what you prayed for here?
Your Lordship, I'm praying for attaching the money, Your Lordship.
Huh?
Your Lordship, money lent in advance. There's no denial that they have received the money. There's no denial to the merits of the dispute.
Not
Lordship,
denial the injunction or not denial some other things?
No, Your Lordship, only the bank account. Kindly seize my press.
Correct. If it's not denied, if it's admitted,
Lordship.
so injunction will serve the purpose or
But Your Lordship kindly sees his intention not to pay. If Your Lordship kindly comes to the non-starter report issued by the mediation center at page 129. Lordship, 2 sittings, a retired judge could not have compelled him to pay. Admitted amount, we had offered that we are ready to settle with the principal. You pay in 4 years, still he is not agreeable. Page 129. Lordship, the intention not to pay is clear.
Yes. How the injunction? Okay, admission. How the injunction? What is the case made out by prima facie?
Your Lordship kindly appreciates Your Lordship, may I then show the default in the check dishonor?
That is
Lordship?
That is 2 years before.
Yes, Your Lordship. Thereafter, Your Lordship, even in the mediation, he is not agreeable to pay anything to me. The injunction, the previous injunction application, Your Lordship will see he never denies that he's received the money. Nor does he not, but the intention not to pay is clear. Lordship, the dishonor of the check. Thereafter, subsequently, your lordship, not the before your lordship also they say that yes, I have received money, but I have not paid. Your lordship was pleased to dismiss it. We went to mediation. Even in the mediation, your lordship, he is not willing to pay. I filed the suit again after complying with 12A. Now, your lordship, if he dissipates with the intention not to pay is clear, and if he alienates his assets, your lordship, any decree passed in this suit will be nothing but a paper decree. Lordship will kindly take into account the conduct of the respondent. Kindly takes page 65, your lordship. And your lordship, they cannot improve or resile from the stand already taken in their affidavit in opposition earlier.
The check is of which date? October 23.
Yes, your lordship.
Then
At that point of time, they had issued that. Payment stopped by drawer. Kindly seize the return reason.
where is the document that they are siphoning off and our thing? Because the money, your attachment you are paying for. There are
Lordship will
conditions.
injunct them at least not from alienating the
Let
assets.
the so-called file the affidavit.
Very well, lordship. But you're very well, lordship. I cannot persuade more. So if the conduct of the respondent is such that
Appreciate.
and no defense on the merit.
The plaintiff has filed the present application being GA Com 2 of 2025, praying for an interim order directing the defendant to furnish security to the extent of rupees 3, 44, 95, 551. 551. The plaintiff submit that initially the plaintiff has filed a suit before the non-commercial division. Subsequently, the defendant has filed an application praying for dismissal of the suit on the ground that the transaction between the plaintiff and the defendant was commercial in nature. Accordingly, this court allowed the application filed by the defendant holding that the dispute between the plaintiff and the defendant is commercial in nature. After the order passed by this court, the plaintiff has initiated pre-institution mediation. Though the defendant has appeared before the mediation but failed to settle the dispute. Thereafter, the plaintiff has filed the present suit. Plaintiff submit that in the affidavit in opposition or written statement?
Affidavit in opposition.
In the affidavit in opposition, the defendant has categorically admitted by saying that whatever money have been actually advanced to the defendant were done by the plaintiff for their own business interest. By referring this statement made by the defendant in the affidavit in opposition in the earlier round of litigation, the plaintiff submits that the defendant has admitted the claim. He further relied upon the check issued by the defendant, which was subsequently dishonored with the endorsement funds stop payment. Stop payment. Full stop. Counsel for the plaintiff submit that the act of the defendant proves that the defendant is neglected to pay the admitted amount to the plaintiff. He further submitted the plaintiff came to know that the defendant is going to siphon off the amount and if at this stage an interim order is not passed by attaching the account of the defendant, the suit filed by the plaintiff will become infractious. Had the learned counsel for the plaintiff peruse the materials on record. It is found that in the affidavit in opposition on the earlier round of litigation, the defendant has stated in one paragraph that whatever the money has been actually advanced to the defendant were done by the plaintiff of their own business interest. Subsequently, the defendant had also issued the check, but the check were dishonored with the endorsement funds insufficient. This court at the time of disposing of the application filed by the defendant on the earlier suit, this court find that the dispute between the plaintiff and the defendant is commercial in nature. Accordingly, the plaintiff has initiated the pre-institution litigation process, but the defendant failed to settle the dispute. Considering it is a specific case made out by the plaintiff that the defendant is going to siphon off the amount, and if at this stage an interim order is not passed, if any decree is passed in future, the same will be in paper only, and the plaintiff will not be in a position to execute the decree. Considering the above, this court find that the plaintiff has made out a 5-5 case, balance of convenience and inconvenience and fear of the plaintiff, and it at this stage an interim order is not granted, the plaintiff will suffer irreparable loss and injury. Accordingly, the defendant is directed not to operate the bank account connected with PAN number AWOPS 0656G without keeping aside an amount of rupees 3,44,95,551. What is the principal
Your
amount?
Lordship, the principal amount is 2,75 lakhs.
Where is that?
Your Lordship will find that in paragraph 49 at page 22.
Okay, then 2 crore 75 lakhs till 6th of November 2025. The plaintiff is directed to serve the copy of the application, documents, and the copy of the print to the defendant or defendants?
Your Lordship, sole defendant.
Defendant immediately, and to file affidavit of service on the returnable date.
Grateful.
Let the matter appear on 6th of November 2025 under the heading new.
Just one indulgence. The second time Your Lordship has recorded the dishonor of the check, Your Lordship has recorded the reason as funds is insufficient, whereas it will be stop payment.
Stop payment. Can be hoga na stop payment.
Oblige, Your Lordship.
I appear for the petitioner, my lord. Lord, this is the matter where my lordship was kind enough to, my lord, admit the plaint after, my lord, granting the dispensation.
Yes.
Only one thing, my lord, I did not find the, my lord, order uploaded in the server. We checked in the morning also, because that has recorded, my lord, the entire facts. It would be easier for your lordship, my lord, if lordship has a copy, my lord.
Upload nahi hua. Retype hua.
No, my lord, I'll just, my lord, for a quick recapitulation, kindly takes, my lord, the injunction application and comes to, my lord, the agreement under which, my lord, I have been inducted. My lord, one more, my lord, thing, my lord, since we were moving it ex parte, now the department has not accepted the notice of motion, though it's, my lord, otherwise ready. My lord, kindly grants us leave to file it here, my lord.
What?
My lord, notice of motion. Because I'm not required to, my lord, serve them because I was moving it ex parte and my averment is there.
The plaintiff has filed the present application praying for interim order. Praying for interim order. As per the case on the praying for interim order, the Mr. Datta Lanna, advocate appearing for the plaintiff, submit that on 25th of January 1988, a tenancy agreement was entered between the plaintiff and the defendant, wherein the plaintiff is inducted as a tenant in respect of the suit property. As per the agreement, it is clarified that the tenant is entitled to sublet the tenancy on such rent and on such terms and conditions as the tenant may deem fit and proper, but the tenant shall always be liable to make the payment of rent regularly to the defendant, being the landlord. As per the agreement, it is further in the agreement, it is further mentioned that the landlord can terminate the tenancy of the plaintiff if the tenant willfully breach any of the terms and conditions of the agreement. Full stop. Number next. Mr. Datta submits that as per the agreement provides that the tenant can sublease or sublet the premises in question, and accordingly in the month of May 2025, the plaintiff has subleased the premises to third party, and the same was with the knowledge of the defendant. After, when the plaintiff has subleased the premises to the third party, subsequently the defendant has filed a suit before the London City Civil Court and also obtained an order of ad interim injunction. The plaintiff, being agreed with the ad interim injunction, has preferred an appeal. In the appeal, the Honorable Appellate Court has modified the order by, where is the order?
My lord, the lordship is looking at the ad interim order. Or
No, Appellate Court.
my lord, appeal is, my lord, at page 73.
Modified the order.
'73, my lord.
Modified the order to the extent that the plaintiff, being tenant, shall not act in derogation of the agreement dated 25th of January 1988 till the disposal of the injunction application. Number next. The Honorable Appellate Court has modified the order on 20th of August 2025. Immediately on the subsequent date, on 22nd of August 2025, the defendant has issued notice of termination. Notice of termination against the plaintiff. And after issuance of the termination notice, the defendant has also sent his men and agents for evicting the plaintiff from the said premises.
My lord had recorded yesterday that there was no willful breach alleged even in the notice.
That I mean, has sent his that thereafter. Evicting the plaintiff from the suit premises. Full stop. As the plaintiff, full stop, being agreed with the act of the defendant, the plaintiff has made the complaint to the police station, which was duly received by the concerned police station. Mr. Datta submit that though the defendant has issued the notice of the termination, but in the notice there is no averment that the plaintiff has violated any terms and conditions of the agreement. He submits that though he has initially obtained an order from this London City Civil Court, but after the modification of the order by the appellate court and being frustrated by the modified order, the defendant has taken the law in hand and has sent his men and agent for evicting the plaintiff from the suit premises illegally. Full stop. Then Mr. Datta submits that there is no allegation that the plaintiff has violated any terms and conditions of the agreement dated
well, 25th of January
1988, and the defendant has already initiated a suit, and the appellate court has passed an order that the injunction order shall continue till the disposal of the injunction application, and the injunction application is still pending. Mr. Datta submits that the defendant and the plaintiff cannot take appropriate steps in the suit, as the suit filed by the plaintiff before the London City Civil Court is not maintainable. As such, the plaintiff has filed the present suit before this court. Considering the above, this court finds that the plaintiff has made out the prima facie case, balance of convenience and inconvenience in favor of the plaintiff. This court also finds that if at this stage an interim order is not passed, and if the defendant is allowed to take the law in hand by evicting the plaintiff from the premises illegally, the plaintiff will suffer irreparable loss and injury. Accordingly, the defendants are
prayer A at page 13, my lord, ad interim order in terms of prayer A.
accordingly, prayer
Page 13, my lord. Prayer.
Accordingly, the defendants, their men, agents, servants, assigns are restrained from interfering and disturbing the possession of the plaintiff or the suit premises till 7th of November 2020.
My lord, plaintiff and or my lord, it's sub lessee because I have inducted, my lord, he is in possession.
Restraining the plaintiff or his sublessee or his tenant. Sublessee or subtenant? Subtenant. All his subtenants from the suit premises till
I'm very grateful, my lord.
the plaintiff is directed to take appropriate steps for sending the plaintiff is directed to immediately send the copy of the application, documents and the plaint to the defendant and to file the affidavit of service on the returnable date. Let the matter appear on 6th of November 2025 under the heading new motion.
Well, though it's immaterial, but just to my lord,
7th of November.
Keep your lordship informed. The city civil court proceeding is also fixed today. We will inform the court, my lord, about the suit and my lord, and we'll also serve my lord the plaint and injunction petition. I'm very grateful, my lord.
Yes. Garavani.
For judgment item number 1.
Plaintiff respondent.
Huh?
I'm Millard plaintiff respondent. The application. This is Millard.
Your lordship, my application.
Application is dismissed.
Much of it.
And I appear on behalf of my lord, the applicant in my lord GA3.
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, there was a, I do not know, my lord, what my learned friend is referring to because nothing has been served so far, my lord. And I had, my lord, concluded, in fact, my lord, argued on merits also. And in fact, I had submitted also, my lord, on the last occasion that after publication of the Gazette notification, my lord, I'll be, my lord, handing up my lord, written notes, my lord.
Yeah.
My lord, may I, my lord, find my written notes, my lord? My lord.
I am told by my advocate on record that the service, my lord, was done and the affidavit of service has been filed in.
Well, my advocate on record is here, my lord. Nothing has been written.
Inquire from your lordship.
I want in any application, my lord.
GA3 is my application, my lord.
Publication is made.
Yes. Publication has been made, my lord, on the 8th day of September, my lord.
Yes.
I would have an application, my lord. And that I did mention, my lord. I have an application. My lord, I had made the application, my lord, and as a matter of fact, my lord.
What is your application number?
GA4, my lord.
My application is GA3.
Yes, it's on a
What is your J3? What is the J3?
My lord, GA3 is my lord for my lord permitting, my lord, recalling my lord the order of my lord undefended suit and permitting to contest in view of the changed circumstances caused by reason of my lord the death of the my lord respondent number 1. Because in terms of my lord, according to me, my lord, that's my understanding in terms of my lord section 116 of the my lord 1951 Act. My lord, if my lord the two ingredients my lord recorded or my lord recognized in that my lord section are triggered, my lord, I get my lord a chance to my lord contest the proceeding because at the end of the day it's an election petition and my lord courts have.
Who are you?
I am my lord the respondent number 6 in this proceeding.
So why you are not appeared on the issuance of the notice on the first occasions?
My lord, first occasion I cannot offer an explanation, my lord. I did not appear. My lord, it was declared by your lordship undefended. My lord, today, my lord, after my lord the death of the respondent number 1, my lord, kindly takes my lord 1161, my lord, section 1161.
You the
of the my lord.
My lord, kindly take my book.
I'll give up.
Yes.
Abatement or substitution on death of respondent. If before the conclusion of the trial of an election petition, the sole respondent dies or gives notice that he does not intend to oppose the petition, that's not my case, or any of the respondents die or give such notice and there is no other respondent who is opposing the petition, the High Court shall cause notice of such event to be published in the official gazette, and thereupon any person who might have been a petitioner may within 14 days of such publication apply to be substituted in place of such respondent to oppose the petition, and shall be entitled to continue the proceeding upon such terms as the High Court may think fit. My lord, the test, my lord, as I understand from section 116 is twofold. My lord, to my lord apply this provision. That, my lord, any one of the respondent, my lord, dies and there is no other respondent who is opposing the petition. Now, my lord, kindly considers the situation here. One of the respondent, my lord, the returned candidate, my lord, respondent number 1 dies. And my lord, since it's an undefended, there is no other respondent, my lord, who is contesting. My lord, had the respondent number 1 been alive, there was a contest to the EP.
No, there are so many respondents, but the respondent choose not to appear. Now, after the publication, whether circumstances change.
My lord, after the publication,
whether circumstances change, if you are the person was on the board, but you choose not to appear after the notice.
My
you are
lord,
satisfied on that
yes,
point.
My lord, there are two rights according to me.
Because this court has allowed.
I understand.
That
Lordship
only,
need not, my lord, express any further. I understand that. This court has allowed summons received. I get notice. I choose not to appear. Lordship was right in recording that it will be proceeding. The proceeding will go on as undefended so far as the other respondents are concerned. Respondent numbers 15 and 16, my lord, from the record, my lord, appears that they were expunged. Respondent number 1 was contesting. My lord, had this situation continued, my lord, possibly I would have no right to come before your lordship's court and seek, my lord, this order. Now, my lord, the situation according to me has changed and the law permits that the EP now has to be, my lord, contested. My lord, I am, my lord, trying to, my lord, persuade your lordship to look at it or visualize the situation from a different angle, considering, my lord, the event that has happened subsequently, which is, my lord, the death of the respondent number 1. My lord, the death of the respondent number 1 and, my lord, the fact that there is no other person opposing presupposes that now there has to be, my lord, some opposition to the EP. Otherwise, it's, my lord, unopposed petition. My lord, it was not unopposed. Otherwise,
now your return officer has opposed, filed affidavit, but subsequently withdrawn. That is also be taken note of that. Your return officer has filed return statement. And at the end, he has withdrawn. That is also be taken into consideration.
My lord, I personally am not aware of this fact, my lord, but so far as, my lord, the respondent number 1 is concerned.
And this court has given chance to cross-examine. They have not cross-examined, filed an application for deletion of the name.
My lord,
I know the court was kept in mind this will happen. That's why the order was passed, giving an opportunity to cross-examine. The specific question was put to the date has been fixed to take instruction whether you will cross-examine. The returning officer came. No, I will not cross-examine. I will withdraw the application. I want to. My name should be deleted from the case. What is the answer on that?
My cause, my lord, here is different from, my lord, what is the conduct of the returning officer. I am not, my lord, either, my lord, drawing support, my lord, from that, my lord, conduct of the returning officer. My lord, I am only trying to, my lord, place before your lordship 116 and
who
its
are you?
applicability.
Only one
I am
person?
respondent number 6. No, only one.
Who?
R6, my lord.
R6. Return. What is the name?
His name is, my lord, Miraz Molla.
Miraz
Molla. Now, my lord, I am saying, my lord, if the written statement of respondent number 1 had been, my lord, on record, my lord, he died before filing the written statement. He was not undefended.
Who?
R1. R1 was not undefended. Lordship.
No, R1 never appeared. He received and within after 2 days or 3 days he died.
Yes, so, my lord, he, my lord, did not even get a chance to, my lord, contest. He could have, my lord, subsequently, I did not find any provision which requires or which specifies a timeline for a written statement to be filed in EP, though, my lord, provisions of CPC governs, my lord, the proceedings of, my lord, the election, my lord, petitions. Now, my lord, he could have, my lord, had he, my lord, been there, he could have, or I don't know what he would have done, but there was a chance that he would have contested. Then the EP would have been, my lord, contested by at least one of the, my lord, candidates, and in this case it would have been the return candidate. Now, my lord, since the death has occurred now, I am saying, my lord, there has been an alteration in the, my lord, circumstances. And this alteration in the circumstances gives me a second right to, my lord, oppose the election petition.
Where is the publication?
Publication. I have a copy. Kindly take one.
আমার কাছে থাকবে।
Yes, kindly go to the notification.
My lord, I don't have a copy of it.
But for people, my lord, like us, my lord, who practice in the appellate side, our training was, my lord, to go and find out notifications, because at that point of time there was not so much of computerization. It's just below the new secretariat building, the city civil court. We used to walk down. There is an office where the gazette publications are available, and we used to find out there from. In fact, upon our enrollment also with the bar council, my lord, that is where from, my lord, we got the notification, the gazette notification.
Gazette notification.
So that is how, my lord,
after payment of receipt.
that is exactly how, my lord, gazette notifications are to be searched. It is possibly, my lord, a procedure unknown, my lord, to most of my learned friends, my lord, practicing primarily in the original side.
May I have the privilege of, my lord?
Yes, go
looking
through.
at it, my lord?
It's a public document. You go through.
It's a public document.
वहाँ से notification आया नहीं, register दिया नहीं, कहाँ है notification? Notification कहाँ है? उनको दिखाओ.
And any person who might have been a Yes, my lord. So, my lord, in terms of 116, there is also a right recognized for any person who could have otherwise filed a petition under section 81 to be substituted. So, my lord, I have that right.
Very right. You have not choose. That's why it's
My
wrong
lord,
here.
that is a right.
Yes. And with regard to notification for substitution, it is not a substitution. You came with a substitution. You tell me, I will allow you.
No, that right. My lord, I get what is, my lord, possibly, my lord, playing through my lord's mind. My lord, that right happens or comes in, my lord, only when there is a death first. Then, my lord, the question is whether, my lord, I could have otherwise filed a election petition under section 81. If I could have, then I get a right to be substituted in place of the respondent number 1 and contest. My lord, I satisfy these conditions. There has been a death.
Okay, argue. I will dispose of it. No problem. Satisfy this court.
I'll get a copy of the petition.
Yeah.
Great.
My lord, kindly comes to the application page 21. This is the order, my lord, by which
Page 21 of?
My lord, my application GA3.
Yeah, 21 is something else.
Lordship is looking at GA number 3.
3.
Page 21 is the order of 13th of August.
No, statement and address of the respondent number 1.
Even if we go by my learned friend's argument, my lord, I find, my lord, from the case status of our High Court, but both the GAs, GA3 and GA4, they have been both filed on the 24th of September 2025. My lord, kindly, my lord, I'll beseech my lord to take Rule 42, my lord, of the election rules. Now, these rules are framed, my lord, pursuant to, my lord, the powers conferred. The powers, you will have your opportunity. At least I am the petitioner. I am just answering.
You took my petition number. That's
I do not have your petition. You have not yet served it. I have found it from the computerized system. I have a carriage of proceedings at least.
Okay, let it say. I will allow you all.
My learned friend, my lord, gets very agitated.
Allow
when
all persons.
my
no
learned
problem.
friend, I will not say gets very agitated, pretends to get very agitated when he knows that he has not a very good case, my lord. No. My lord, kindly takes rule 42. 42, these rules are framed, my lord, pursuant to the powers conferred to the High Courts, my lord, under Article 25 of the Constitution of India.
Notification था ना rule वाला.
My lord, kindly takes my rule, my lord.
कहाँ रख देते आप लोग? सब फाइल में रहता फिर रहते हैं हियरिंग के समय क्यों नहीं मिलता है? Rule 44.
Rule 42, my lord.
42.
Yes. Rule 42, read with rule section 116. Both states that they have to apply within 14 days of publication.
Yes.
And both the matters, my lord, I find from the computerized case status, my lord, both have been filed on 24th. The gazette was published, my lord, on the 8th of September. 14 days from the 8th of September, my lord, ends on 21st, my lord, in my reading, because it says within 14 days.
Okay, whatever it may be.
So even if, my lord, not on 21st, then on 22nd, they have filed it on 24th. My lord, I will just, my lord, refer to, my lord, an order passed by my lord only, my lord, in these proceedings only. When, my lord, this matter was being argued regarding my lord, deletion of names. So this is an order dated 13th of August 2025.
Yes.
Paragraph number 29, 30 and 31. Where my lord has held it is of a special nature. Timeline is mandatory.
Yes, correct.
There cannot be, my lord, when the law prescribes a certain act to be done within a certain period of time, that timeline has to be complied with.
Yes.
But I'll be relying on.
I don't know.
It's part on the face of it.
I was having a copy of GA3.
Yes.
Page
page
21 was the order I was referring to. This is the same order, 13th August, which Mr. Bhattacharya just now referred to.
Correct.
My lord, first comes to paragraph 15, which is at page 30.
Yes.
My lord, this is regarding the expunging of, my lord, respondent number 15 and 16.
Yes.
Now, lordship comes to, my lord, page 37, paragraph 32.
37. Order
Yes, sir.
Yes.
Considering the above, this court finds that after death of the respondent number 1, provisions of section 116 read with rule 41 has not been complied with by publication in the Calcutta Gazette. Petitioner is directed to take steps by publishing in the Gazette in compliance of the provisions of section 116 of the Act of 1951 read with rule 41 of the 67 rules within a period of 3 weeks from date. Now, this is, my lord, that publication in terms of, my lord, lordship's order. Now, after this, my lord, in terms of section 116, my lord, once this publication is made, the publication also says, my lord, that the respondent number 1, namely Sheikh Nurul Islam, expired on 24th September 24, and any person who might have been a petitioner, I could have been a petitioner otherwise, may, within 14 days of the publication of this notification, apply to be substituted in place of respondent number 1. So I can be substituted in place of respondent number 1, and that, my lord, observation that it is undefended so far as others are concerned would no longer apply when I am substituted in place of R1.
So that's why I'm asking. Your application is for substitution.
My lord, the prayer, my lord, kindly comes to the prayer once, my lord.
Once you are already a defendant or the respondent in the suit, So can you say that you can be you can substitute it?
My lord, I can because of the my lord provision in the my lord EP Act.
If you are already on record as a respondent,
My lord,
if you're not a respondent, he not met the party, you came and you may be substituted. So contest, that is different thing.
My lord, that is that can be one way of looking at it. But my lord, the submission which I am making, that though I am a party and my right was my lord closed because of your lordship's order, once the death occurs, I can step into this substitution means my lord stepping into the shoes of R1. Whether I was a party or whether I am not a party, my lord, the law recognizes that if I could have been a petitioner, I have the right of stepping into the shoes of R1. My lord, what's the object behind this? The object is that the petitioner, the petitioner in the election petition has, my lord, somebody to object that petition, to contest that petition. That's, my lord, the primary object. And that is why, my lord, even after death, my lord, the law recognizes that there can be a substitution. My lord, this otherwise would have, my lord, the legislature would have, my lord, been conscious enough to, my lord, also add that, my lord, if you are already a party to a proceeding, you cannot, and choose not to, my lord, contest, you cannot participate. That's not provided in section 116. Section 116 only uses the expression substitution. And, my lord, this substitution would be, my lord, as I said, my lord, to contest the election petition by stepping into the shoes of the deceased, my lord, candidate. This is, my lord, my first submission. Now, my lord, so far as prayers are concerned, my lord, kindly comes
Yes,
to
Mr. Bhattacharya, you will file affidavit.
My lord, what my learned friend is submitting, my lord.
No, if you file affidavit, then I will give direction.
I say, my lord, on the face of it, the applications
no,
are
it's
not
correct.
reasonable.
It's correct. If you want to file affidavit, I will
But
give
they
direction.
want to, my lord, basically procrastinate the proceedings.
No,
somehow or the
No,
other.
that's why I will give the short direction, because the election petition, it is a burden upon the court to dispose
But
of.
kindly, before that, my lord, kindly takes pain to, my lord, consider section 97 of the Representation of People's Act. What my learned friend is submitting,
No,
my
I am
lord,
asking, but that's why.
yes, what my learned friend is submitting was available to him under section 97. It had to be done, my lord, it had to be complied with within 14 days from the date of commencement of the trial, recrimination proceeding, my lord. But now he's trying to short circuit the procedure, import some procedure alien to, my lord, the election laws, and trying to develop a case which he has not made out, though he says that the prayer is essentially for recalling. In the form of recalling, he is seeking substitution. Though, my lord, remedy of recrimination was available to him, which he did not admittedly avail, my lord, under section 97.
Yes.
Well, kindly comes to the prayers. Well, prayer A. Dilam tomake. Oh, sorry. Sorry.
Yes.
My lord, prayer A is, my lord, recalling of that order by which lordship had declared the proceedings ex parte so far as the other respondents are concerned, which includes me. Prayer B, my lord, is, my lord, specific prayer to enter appearance and file written statement. This is, my lord, the prayer for, my lord, stepping into the shoes of, my lord, the deceased respondent number 1. My lord, I am, my lord, relying upon a coordinate bench decision where in a similar situation, where one of the respondent was a party to the proceeding, my lord, he got substituted after the death. My lord, kindly takes, my lord, this. Copy.
To citation. Thank you.
My lord, this is an order of 22nd February 2023. Second para, Mr. Chaudhary, Learned Counsel representing the respondent number 3 submits that as follows. On 16th August 21, present election petition was admitted, notices were issued, adjournments were prayed for on behalf of R1, who was the return candidate from the assembly, as he was suffering from ailments. In fact, he went into coma and passed away on 20th February 22. All these along, the petitioner did not object to the prayers for adjournments made on behalf of the respondent. On 20th July, petitioner made his intention clear that he would continue with the prosecution. Thereafter, this court issued a notice under section 116. Same was published. Pursuant to the publication of the notice, respondent number 3 entered appearance and decided to contest the petition. He prayed for leave to file written statement. If the original respondent number 1 would have been alive, prayer C and would have depended on prayer A and B. But after his death, the entire complexion changed. Now prayer C is to be independently decided. On the other hand, petitioner's intention is to non-contest. This is contrary to the spirit of the Representation of People's Act. Here, contested adjudication should be preferred. In the interest of justice, any delay occasioned in making such prayer for filing written statement may be condoned. Mr. Ray, Learned Counsel, appearing on behalf of the respondent number 8, submits as follows. Section 116 of the Representation of People Act was very much applicable in the instant case. As per provision, after a notice is issued in terms of section 116, it shall be open to anyone, even an existing respondent, to decide to contest the petition. Reference be also made to section 87 of the Act. It is always open to the present petitioner who had contested the allegation to enter appearance and seek leave to file written statement. Although the time for filing written statement may be termed as mandatory in commercial suits, but in regular suits, the same is essentially directory. On this, reliance is placed. Well, I need not trouble your lordship with this immediately. Respondent number 8 had inadvertently misplaced the original notice. This was not disputed in the opposition. He is interested in the petitioner's prayer that the latter should be declared a winner. Rule 101 states that this court can declare any person as a winner. This can best be decided on contest. Respondent number 8 saw the subsequent notice and decided to come. After death of respondent number 1, the rights of the respondent number 8 have crystallized more. Now he too can fairly be declared a winner. On the question of bona fide, as the respondent number 1 is there no more, there is no question of any collusion. Petitioner has also made allegations against independent candidates, as would be apparent from paragraphs 32 and 33 of the petition. It is pertinent to state that no ex parte hearing was even directed. Only intention of the petitioner to move ex parte was recorded. On facts, delay does not affect trial if taken from the action under Rule 116. Delay is of 3 days. Then, my lord, kindly comes to the next page. My lord, this is the argument of, my lord, the person, my lord, the learned counsel representing the petitioner. My lord, second line at page 4. Respondent, first line. Respondent number 3 and 8 were already there in the list of the respondents as having contested in the said election. My lord, I am reading from page 4. They had chosen not to appear in the matter despite notice. Therefore, it is not open to them to claim that they would contest the petition hereafter pursuant to the notice given under section 116 of the Act. First, the notice is meant for those others, including anyone among the public, to come and contest the petition, but it would not include an existing respondent who had chosen not to appear thus far. Well, this was specifically the submission. Then he relies upon section 116. Such explanation is not available in the application. There is lack of bona fide. Now, my lord, the finding of the court, my lord, internal page 4, last 2 lines onwards. This is an exceptional case where proceedings in an election petition had to be adjourned for days together because of serious ill health of the winning candidate. After several months of struggle, the respondent succumbed to his ailment. During this period,
Finally, come to the paragraph, page 7, paragraph 3.
The whole purpose of section 116 of the Act is to have the proceeding continued and contested on merit so that the real truth comes out after hearing the parties. Juxtaposed with the above, the purported delay in praying for extension of time to file written statements pales into insignificance. I am drawing in view of the above and in the interest of justice, I find respondent numbers 3 and 8 have made out a good case for condoning the delay and allowing their applications for filing written statements.
That's why the first question I asked, what is the explanation when you receive the first notice? Where is your explanation?
In the application. This is at the cost of repetition. I'll definitely look into it. I got that explanation.
Para 5 and 6.
Are you gone through?
Para 5 and 6. My lord gives me one more. This one. Well, at that point of time, 5 and 6, my lord, if your lordship sees the explanation, my lord, the returned candidate who had, my lord, who was successful in that, my lord, process, my lord, was contesting. He was there, he was alive. And there was no occasion for me to realize then that he would not file a written statement had he been alive. So, my lord,
that is
situation,
not the case you made out. 5. Respondent must receive the copy of the petition, found himself not in any manner being affected at the very point of time and referent contesting the application.
also, my lord,
Yes, taken a legal advice and
legal
informed that.
advice and informed
Yes.
that the main respondent was the returned candidate.
Yes.
And respondent number 6 had no role to play.
Correct.
Accordingly, the respondent number 6 have had not taken any step in opposing the said application.
Correct.
Because it was, my lord, the main respondent was then alive. Now the situation has changed.
So
In view of the changed
when
situation,
the respondent died.
R1.
Yes.
Yes, R1 died on 25th of September 20. My lord, I cannot take any steps unless, my lord, there is a publication in terms of 116. My lord, only are there.
If you are taking this plea paragraph 5 and 6, you're telling you're referring because he's contesting. And you could have been come on that day because for filing written statement for recalling of order 116 is not required. 116 only with regard to any person objection. You are on record. You are on record. You admitted that you had choose not to appear in the case because respondent number 1 appeared and respondent number died 2019 itself. And you choose not to come with the written statement and you're taking the benefit of 116. How far the 116 will benefit to? Because
there are two situations
which you're relying upon of the coordinate bench. This is the good cause has been condoning the delay is allowed. Where is that?
Why the court ultimately came to this conclusion? Because of the fact that the court wanted a contest in the election petition. My lord, I'm trying to, my lord, convince your lordship to give me this opportunity so that this election petition is not uncontested. My lord, by reason of, my lord, section 116, this is...
Okay, how much cost to pay? I will allow, I will give 1 month, only I will take this case and you come written statement, I will fix day-to-day hearing, evidence will...
I cannot bargain with court. I am at the court's, my lord.
So you pay the 5 lakh rupees? After 3 years, you are coming before this court for fair trial of the matter.
Well, if the law gives me that right,
where is the right? Otherwise, I will
that
dispose
right,
of.
My lord, for cost, I will never bargain. I leave it to my lord. If lordship feels that my conduct is so bad that my lord cost has to be
allowed to play with the court.
No, if I will not bargain. My
Once you are admitting in your application that you have received the claim and you choose not to appear now, you are taking the another benefit of that.
My lord, I only wanted to, my lord, convince your lordship about an opportunity. If lordship feels
and even
that,
though
this petition should not be,
even the 116 is taken into consideration whether within the time 14 days, where is the explanation?
My lord, that I will. My lord, there also 3 days, my lord, delay was condoned in the coordinate bench decision. Lordship has recorded.
Maybe, but where is here?
My lord, here, my lord, I'll give your lordship the facts. My lord, what had happened?
You are telling that you came to know the publication.
I tell your lordship, if lordship is not convinced with my submission, my lord, I know the fate of this application. My lord, in this application...
Yes, Mr. Bhattacharya, you will file affidavit?
My lord, I was just relying on one decision, my lord, of the...
You will file affidavit, other I will hear you and I will dispose of the application here and now. You tell me that.
But I say, my lord, there is no scope, my lord, under 106.
So you will not file.
But I was having this, I was citing this particular judgment, my lord. This was not considered by the Honorable Single Bench, my lord. It's arising out of Civil Appeal number 8337 of 2018, my lord.
Copy দেবে?
Copy দিচ্ছি, soft copy দিয়ে দিচ্ছি। Soft copy একটা airdrop করে দাও, airdrop করে দাও।
রাজশ্রী iPad বলে আছে করে দাও।
But kindly take para 7. Eight, 9. This was dealing with the Haryana Panchayati Raj Act, which is a complete code. Limitation Act does not apply. আমি দেখালাম হচ্ছে 7, 8 and 9.
Yes.
This makes it amply clear, my lord, that when the timeline has been specified, if my lord kindly takes pain to, my lord, appreciate the provisions contained in section 86, my lord, subsection 4.
I did not get a chance to explain the conduct with regard to
Just a point of law.
Okay, if you're not filing the affidavit, I am fixing a date for hearing. And what is your application, Mr. Ray?
Date should be fixed for the file for this. Or if my lord is fixing a date, my lord, after the vacations, my lord, we'll come up with a
If
short
Lordship
affidavit.
had indicated this
We'll
earlier.
come up with, no, I thought it is, my lord, so abstruse, my lord. It's glaring on the face, my lord, the attempt, my lord, to juggle with, my lord, the process of law. I thought, my lord, that they will be meeting immediate dismissal.
That is Mr. Bhattacharya's understanding. I don't agree to that.
Who are you?
Application to
I'm a voter.
What?
I'm a voter of the constituency. Well, section says, and also the Act provides that any person who has an interest can apply. Well, that is of no question at the primary circumstance when I filed my application. But I made my application, and it has been affirmed on the 22nd. And Your Lordship, I would have liked to bring this on record, by a supplementary if allowed.
24th, not 22nd.
Affirmation,
24th.
My affirmation is 22nd.
Yes, I have been, my lord, just I have been handed over, my lord, with a copy. They could not have done it because yesterday it was mentioned and inspection was taken.
Your Lordship, kindly appreciate from 19th onwards, I have been before Your Lordship, trying to get at least a short costed leave. So, the intentions were obviously to file it within the time. I could not get a copy of this, the official gazette notification.
But he knows about the gazette.
I did not know. I came before Your Lordship saying that I need to get a copy. I do not know whether it is published because I've gone to several places. I could not get it. That has been my submission. After that, Your Lordship was very pleased to give me the scope of looking into the records, and then obviously I immediately filed. I'm sorry, I should have said 24. That it was wrong. The 22nd was going on. So, I came before Your Lordship, I filed my application. Now, the intention of my client, why is this so necessary? What my learned friends are seeking today before Your Lordship, is basically invocation of section 101, which basically allows, if I may use the colloquial term, a free will that it will be held ex parte that there was corrupt practice. Therefore, the votes of the elected candidate will be taken to be not to be recognized, and he will be declared. This is where I come and oppose. I say that I am going to be substituted to show that first there was no corrupt practice, and maybe that it was the other way around who was indulging in corrupt practice. Only I'll make applications to that extent if I'm allowed to be substituted. My prayer is for substitution. I say that I have an interest because the primary.
What about the limitation?
Well, the question of limitation, two things I would like to argue. Two things. One, the wording of the section, it says me. I'll point out why I'm saying this. This primarily, is an adjective law. This part at least, to the extent, it allows a person to come in and ask for a substitution. It's nothing to do with any substantive law as such per se, but like in written statement, Your Lordships are well aware. But because it has been made mandatory by the Commercial Codes Act, therefore Your Lordships have now become very strict on that.
Yes, Supreme Court has a mandatory one. The limitation is not applicable either the election petition or the trial.
But I'm not on the point of limitation. What I'm trying to say, whether this wording may, I have not seen the judgment because they're not being served with it. Whether the word may, will there be 160 into by the Supreme Court? I don't think so. As far as I understand, may not be the case. So I would beseech Your Lordship, considering the wordings of the section, and may, because Your Lordship, what is the primary importance is that, that the intention of the complete electorates are not done away with. So someone should be there.
So I think you have not read my judgment.
It was not on corrupt
But
practice.
judgment I have delivered for publication, you have not read all as a whole. What you are making the submission, you read the last five paragraphs.
But I am not.
So you filed the application without going through my judgment.
But I have not been able to. I have not.
Without going through my judgment, you filed an application for substitution.
Already 116 million.
Yes. Wherein this court has directed the petitioner to publish. Kindly go through the last four paragraphs.
In this matter.
Yes.
Yes, yes, Malad.
So you are repeating that only.
No,
that's why this court has passed an order for publication.
That is why I'm saying, Malad. Malad, why I'm saying this, Malad? I am saying this, therefore, the interpretation should be, Malad, to the extent that it subserves justice, ends of justice. Therefore, I say the word may, Malad, the word may, depending on the factual aspect, Malad, as to how I have been treating or what steps I have taken, Malad, should not be read as mandatory. It should be read as directive. And why I say this, because again, it's the word may. And as it is, Malad, I would have loved to bring on record a supplementary affidavit to show that even within that period, I've been approaching a lordship. My intentions were clear. I had no bad intentions. I did not, I wanted to file within time. Now, Malad, your lordship will also have to, Malad, with humility, I say, Malad, also consider, Malad, in some cases, Malad, the actual practical nature. It fell from Mr. Deportation himself that people have to know really from where to go and get this.
No, we know it.
I think your junior has not been properly advised you. No, advised you. This court has directed him what is to be done.
Yes, I was
on
there
the very first day. This court has already directed him how you will get the notification. Yes. I think he has not catch the very first day. This court has directed where you will get.
And I can show letters, Malad, where we had approached this. That's what I'm being told, Malad. Let me put this on affidavit. Why I could not, since it's fallen from your.
You already filed the affidavit. You can.
No, Malad.
It's an afterthought, Malad, if an affidavit comes down.
That extent, Malad. Where, Malad?
That's why I want, because this election petition already 2 years has been passed. Only because you are not appearing the state, and that's why 2 years is going to be passed. The other statutory authority appeared, then at the flag end they filed an application. Then this court only for the expedite, the application is taken into consideration along with the final.
I kindly appreciate this part of the submission. It is not to stop people. Now today, Malad, let us say I came 2 days before. Let us say I came.
If you are telling that you are the person from the same constituency and you don't know whether the election petition going on and the elected candidate died.
Malad, unless your lordship passes an order under 116, Malad, the question of substitution doesn't come.
Okay.
Your lordship has passed that order. I made my intentions clear. Malad, now I'm beseeching your lordship, Malad, kindly consider that I've come within the period. But then what is falling from your lordship, or what my learned friend is trying to say, is that because of 2 days period, I get a clean and easy route out.
Yes, that is the law.
Well, that is the law. I would like to submit, Malad. The word is may. The wording is may.
Okay, how soon you file?
But I'll file a short affidavit, Malad.
In both applications you file.
Both the applications, keeping the question of maintainability of the applications open, Malad. Malad fixes it, Malad, any time, Malad, after the long vacations.
If by today, Malad, I can bring on by a supplementary affidavit only that part, from 19 to 10.
After the query by the court, it's not. If you could have initially first, after the query made by the court, this is
beginning. I started off by saying that.
I'm sorry. After the court has made a query, then you wanted to supplement that by way of supplementary affidavit. This is the last court to allow that, sir.
At the very beginning, I said so.
Sorry.
Malad, grants me short direction, Malad.
Very beginning, I said so. I'm sorry, Malad, but
the 2 applications have been filed, being GA3 of 2025 and GA4 of 2025. Praying for.
May I have my lord's kind leave, my lord?
Yes. Get it in. The respondent number 6 has filed an application being GA4 of 2025. Praying for substitution. Praying for substitution. And to file substitution after the death, substitution upon the death of the respondent number 1, and to file return statement. Another application is filed GA4. No, file an application GA3, na? GA4 bola na? Another application is filed GA3 of 2025, praying for recalling of the order dated 19 December 2024 and to allow to file return statement. Though the parties to the proceedings have, though the learned advocates appearing for the parties have argued the matter but this court is of the view that both the applications is to be heard after the affidavit. Learned counsel appearing for the petitioner raised the question of maintainability of the both application. The maintainability of both the application is kept open. Let affidavit in opposition be filed by
the shortest possible time, my lord.
1 week after vacation?
Within a day after the vacation, my lord.
Affidavit in opposition.
Oh, my lord, court is reopening on a Friday. My lord, let us file it on Monday, my lord.
By 28. Affidavit in opposition filed by 28th of October 2025. A reply after serving the copy to the learned counsel for the advocate on counsel for the applicant of GA3 of 2025 and GA4 of 2025. Affidavit in reply, if any, be filed by 7th November 2025. List the matter on 10-11 तारीख को देखो कोई टाइम है 11-12 तारीख को कोई टाइम है
मतलब instead of 11th any other day
14 नवंबर उससे पहले 14 नवंबर 3 PM कहाँ से होगा फ्राइडे है अरे ऐसा दूसरा टाइम पूछता हम कोई 11:30 12:30 कब है 13th November at 11:30
may beseech my lord to grant us leave to inspect the affidavit of service that they have filed, because my learned advocate on record is here, my lord. Nothing has been served or received.
yes, but kindly records that I have given him a copy. I have given him a copy.
As an order for affidavit deemed.
And my lord, अरे ये तो फाइल हो
I just wanted me I get a copy of the official gazette publication from your lordships. If I can,
the office is directed counsel for the applicants of GA4 and GA5, GA3 and GA4 submit that they have not received the copy of the official gazette. According, office is directed to supply the official gazette to the petitioners by tomorrow.
Grateful.
And I have filed my written notes of argument.
Written notes of argument filed by the petitioner be kept with that.
To the main
of the main election petition be kept
the outcome of the GS.
I am doing something which was
Mr. These are second written notes of argument. Initially also Mr. Bhattacharya's was
the same thing. But it's an election petition, so it's your lordship is going to undertake the entire process. So, your lordship will decide whether your lordship will.
No, that's why. No, on the earlier occasion when the returning officer and election commission has withdrawn their name from the, they have been
allowed. They are not allowed.
They have been released. Yes. So subsequently, Mr. Bhattacharya has filed the written notes of argument on merit. But while passing the judgment, then
noticed
that.
Grateful, my lord.
Grateful, very grateful. Sorry, Mr. Kanochi, on this matter.
That's
one time.
This is the point of law.
It's a
pure question of law. Pure question
point of law. These are interesting questions, and this will not come every time.
And difficult for us.
This will not come every time.
That is why, I started doing election petitions. It's a completely different, Your Honor, learning from Mr. Bhattacharya.
Our exposure to public posts have at least taught me a lot.
It's also me.
I'm sure it's the same with my learned brother. working for the state.
I'm trying to learn staying in between.
I am really grateful to the central government. They thought that I will be competent at that point of time. A varied experience. Before that, I used to be extremely rickety or shaky to appear in criminal matters. But now it's the ED and the CBI
made you practicable.
I'm sure if that extent, then if they come to our house, we can shake hands with them. Hello.
Malad, may I take back the book? Malad?
But
The book.
But the department may not maybe directed may not to carry out the amendment regarding it was directed already regarding deletion of the names of the returning officer and the ECI, the election commission. They were previously directed.
Order mein likha hai?
13th August.
It was previously directed, Manoj, if not already done, because there was a delay of
The
1 day.
department is
by my learned
directed to
advocate
carry out
record
the order dated
13th of August. Manoj.
13th August 2025 by deleting the name of the respondent number 1 and respondent number
No, not 1.
15 and 16.
15 and 16.
then respondent number 1 also is to be deleted.
1 is also, yes.
1 as well as respondent number 16, 15 and 16 from the cost title of the
Grateful.
election petition.
Grateful. Extremely grateful. But I'll just avail the opportunity of wishing my lord a very happy puja and
Thank you all
holidays
of
in
you.
advance.
Thank you to all of you also.
We also take the same opportunity.
Not now, not now.
Not now. One day is there. One day is there. Mr. Ray will come here.
But I'm filing the notes of argument of the plaintiff. My lord, only. My lord, this is regarding the insurance undefended insurance claim. Undefended suit, my lord, insurance claim. Argument is argument is over. My lord, only.
We are also filing the written notes of argument.
And my lord, only 2 points I'll just indicate in a couple of minutes regarding the claim of interest, my lord. There are two heads of interest because my client, the plaintiff, runs his business with assistance from PNB, a commercial loan from PNB, where there is one rate of interest which is variable from 7.15 to 8.80. This is a variable during this period. And he also, the major part of his further liability which he has incurred to compensate the farmers is by taking money from a private institution. There the rate of interest is 12%. So the IRDA regulation mandates that interest should be paid 2% above the bank rate. So my lord, here there's a variable from 7.15 to 8.80. So 2% above that will be around 10.80%. And that would be the from the private institution, it would be 14%. So in between, I have paid for 12% of interest, which and I have annexed the IRD regulation with this notes of argument, my lord, that is page 52.
Okay.
I have mentioned it is clause number 1510 of IRDA regulations. 1510, sub-regulation 10. It is in page 52, my lord.
Yes. Not settled within 30 days to clear 2% above bank rate. Yes.
Yes. And my lord, one more aspect is that during our argument, our submissions, we missed out on 2 judgments on very basic principles of law. My lord, I have enclosed these 2 judgments with this notes of argument. I've given a copy to my learned friend also, but these are on basic propositions, my lord. One is a 2007 Supreme Court. My lord, I mentioned that in my notes of argument. It is in page 12 of my notes of argument, that is 2007 volume 4 Supreme Court cases 105. This is on the proposition that when the insurance company alleges that the claim falls within exclusion, the burden of proof that the circumstances bringing the claim within the ambit of exclusion is on the insurance company. It is on the burden of proof, my lord. And the other judgment, my lord. My lord, the judgment begins at page 27 of the notes of argument.
Yes, I have gone through.
Yes. And my lord, the other
first judgment.
That is the first judgment.
Yes, Ishar Das Mandal.
And the second judgment is, my lord, National Insurance versus Vedic Village. In this case, the proposition was that surveyor appointed by, if the surveyor appointed by the insurance company gives one particular finding of fact, insurance company may differ from that finding of fact, but for that they have to give a reason, give cogent reasons to depart from the findings of the surveyor. So,
Thank you. Yes. Anything further?
Lordship, I don't have anything to submit, but just one, it's a piece of information, Your Lordship. Although the suit is undefended, but there wasn't much to be provided from the defendant side except the surveyor's report, which is already exhibited. All our arguments, all our cross-examination are based on the exhibits produced by the petitioner, which shows the intention that there was ambiguity in what they're claiming, and what they're claiming, they have not supported it rightfully with the rightful documents, Your Lordship. That's it, Your Lordship.
my lord, I'm submitting my affidavit of costs also. Affidavit of costs, my cost budget sheet, my lord, by way of an affidavit. And my lord, I am also relying on
Both the parties have filed written notes of argument.
I'm
Plaintiff has also filed the affidavit of cost. Let the same be kept in the record. CAV.
And my lord, I'm also relying on a judgment regarding costs of your lordship's judgment. My lord, I have a soft copy in my tab. I'm giving the hard copy during the recess. My lord, it is a judgment of your lordship dated 9/8/2024 in Shining Vapor Private Limited versus Neelkanto Shaha. I'm giving this judgment, my lord. I'm giving a print of this judgment. 12 and 21, para 12 and 21. It was a money suit, my lord, and it was undefended as well. Para 12 says the suit is undefended, and para 21 is the.
Yes,
I'm deeply obliged, my lord.
Yes, next. Thank you.
My lord, I appear for the plaintiff petitioner. My lord, my application for judgment upon admission is
Your Lordship, I am appearing for the defendant. Your Lordship, on the last occasion, I had sought some time to file opposition to their application, Your Lordship. Your Lordship, I am out of time. I am seeking some more time, Your Lordship, since the authorized representative who will be signing is not available, Your Lordship. Your Lordship had given me 2 weeks' time, Your Lordship. I am seeking one last opportunity to file my opposition, Your Lordship.
2 weeks from date.
Your Lordship, after vacation.
2 weeks from date.
Your Lordship, 2 weeks after vacation.
but only one thing, in that case, let there be an interim order. But I did not press for any interim order because my learned friend sought for some time to take instructions. But admittedly, I'll just give you a lot. I had indicated on the last occasion, it was their defense that once they get money from Adhunik, they will remit the entire payment to me. Now, I have disclosed documents to show that the disputes with Adhunik have resolved and they have received money under the award. It is their written statement case. I was in that case, since an extension of time is prayed for, let there be an order in terms of prayer D of my petition.
Yes, madam. For 2 weeks, there is an order.
Lordship, I am just praying, Your Lordship, let me file my opposition. Lordship can hear and pass orders, Your Lordship.
You are not filing the affidavit inside of the.
Your Lordship, I apologize for it, Your Lordship.
Once the order, interim order is passed, your client will immediately will come to you and you can affirm the affidavit.
Your Lordship, I am just seeking
There
for
has
one
been
last
serious
opportunity.
non-compliance so far as the Commercial Codes Act provision is concerned. Suit was transferred to the Commercial Division in 2019. Directions were given in 2023 to comply with the provisions of the Commercial Codes Act 2015. That yet remains to be complied with. Even Your Lordship has recorded in the last order of September 1.
Yes, madam, you are not also compliant.
Your Lordship, because of the same thing, Your Lordship, since he is traveling, Your Lordship, he is not available.
Let it travel because the amount can be deposited online. So I am passing an order, let the amount be deposited online by traveling. Nowadays, the bank is on the mobile phone, he can do that.
Lordship, one last opportunity. I'm asking Your
Very
Lordship can
well.
pass orders after that. Your Lordship, that is my undertaking.
The order, madam. You are not complying with any of the order. Neither you are completing the procedure of the commercial code act, or nor you are filing the affidavit and taking time, and your client is roaming all around the world.
Lordship, Your Lordship, I admit, I apologize, Your Lordship. I am just seeking for one last extension. In case we don't file, Your Lordship may close the right and proceed with the hearing of the application as well as the Your Lordship suit.
Dated 1st September 2025, this court granted time to file affidavit in opposition and also directed the defendant to complete the process of comply with the provisions of the Commercial Court Act with respect of CS Com 61 of 2020 within 2 weeks from the date of the order. When the matter is called today, learned counsel for the defendant pays for extension of time to file affidavit in opposition as well as to comply with the provisions of the Commercial Court Act. Consider the submission made by the counsel for the defendant learned counsel for the plaintiff raised objection and submits that in one hand the defendant is neither filing the affidavit. Counsel for the plaintiff submits that the defendant has admitted the claim of the plaintiff, but in spite of the same, they have not made the payment. Accordingly, he prays for interim order in terms of prayer B of the present application. Small b. Had the learned counsel for the respective parties peruse the materials on record. Admittedly, the defendant has not filed the affidavit in opposition as per the direction passed by this court and also not comply with the provisions of the Commercial Court Act. But for giving one opportunity, time to file affidavit in opposition and to complete the process of complying with the provisions of is extended for a further period of 1 week after Puja vacation. It is made clear that by that time, if the defendant failed to file the affidavit in opposition and comply with the provisions of Commercial Court Act, the application filed by the plaintiff will be taken up for hearing without the affidavit. Let the matter appear on 7th November.
Grateful, Your Lordship. So grateful.
This is my suit, my lord. It's for recovery of possession. My lord, an application was taken out in terms of Order 7 Rule 11 for return of claim because, my lord, of the T. Thompson issue. 106 notice whether, my lord, it can be filed as a commercial dispute. Now, my lord, it's been resolved. I have indicated, my lord, the law as it stood on the date, my lord, would have no meaning because a declaration of law takes effect from the date of inception. So, my lord, accordingly, I made my submissions and, my lord, I've given the judgments, my lord. They were supposed to reply.
Lordship, if Your Lordship adjourns it today and keeps it after the vacation, Mr. Rupak Ghosh is leading me in this matter, Your Lordship.
Who?
Mr. Rupak Ghosh.
As per the prayer made by the counsel for the plaintiff.
Dependent, my lord.
Counsel for the defendant, the case is adjourned. Let the matter appear on.
Let it appear on 27th, my lord, which is the first Monday. But I want to do away with the matter, my lord, because it's been pending for.
On 28th.
Very well.
October.
Grateful.
I'm appearing for the plaintiff, Your Lordship.
Lordship, I am for the defendant. Lordship, this is my application. It's being heard. Order 7, Rule 11. I had completed my submissions. Thereafter, my learned senior friend, Mr. Mitro, had also
He's appearing virtually.
completed his submissions. Now I am to report.
Madam there.
Lordship, on the earlier occasion, it had fell from your lordship that since the documents are mentioned in the plaint, can those documents be taken into record and construed that the instant dispute is a commercial dispute or not? This was the short point. Because my argument was that they have no pleadings in the plaint to show that this was a commercial transaction as to why the loan that has been obtained, allegedly obtained, has been obtained, as to why. That reason has not been mentioned in the plaint. On which my learned senior friend had indicated that even if that is not mentioned in the plaint, he has the documents to substantiate his case.
And
You're for the
hence,
defendant.
I'm for the defendant.
Yes.
And hence his case was that since the documents are there on record, those will be construed to mean that this is a commercial dispute. Now, Lordship, I'm again citing.
What are the documents they are relying upon?
They are relying on alleged account confirmations.
And
I'll indicate the documents. Copy of the bank statement. Copy of the confirmation of account.
Promissory note.
Promissory note, that is there. Along with that confirmation of accounts and ledgers, statements, etc. Dishonor of chiefs. These are the documents. Now, exact facts. Lordship has passed a judgment. It is reported in 2024 SCC Online Cal 8699. Onwards, paragraph 18.
Paragraph 18.
18. I'll read it. The defendant raised the point that the impugned transaction does not fall under the ambit of the commercial dispute. As per the Commercial Courts Act, it is not denied that the plaintiff is a non-banking financial institution. As per the case of the plaintiff has lent and advanced the loan amount of rupees 15 lakhs carrying interest of 12% per annum. Defendant has also issued confirmation of accounts acknowledging the amount of rupees 15 lakhs. In the plaint, there is no averment to say why the defendant has borrowed the amount from the plaintiff. The plaintiff has only mentioned that the defendant has utilized the said amount and has reaped the benefits thereof. It is not the case of the plaintiff that the defendant has taken loan from the plaintiff for the purpose of any business and the defendant has utilized the said amount in this business. The plaintiff in the cause title of the plaint only mentioned that the defendant, namely Rita Kedia, carrying on business, but it is not clear that the defendant had taken the said amount for the purpose of its business. Now, Venkatesh Vincom has also been relied here, wherein Lordship held that this is admittedly a commercial dispute since it's the business of bar and restaurant. Now, paragraph 21 is the one. Only the plaintiff, being a non-banking financial institution, lent the advance money to the defendant and the defendant has issued account confirmation will not constitute a commercial transaction.
Have you gone through my latest judgment? एक कल परसों एक judgment दिया था ना? कल परसों एक judgment दिया था.
May I only
I held.
Lordship had held something against me. I'll have to come back.
But even I have not gone through that judgment. I have also not gone to the latest one. I don't know who's in his favor, but I have also not gone.
Happy.
Only thing, my Lordship will kindly keep this matter. If it is after vacation, then.
With a fresh application.
Dismissed. है 712. नहीं स्कीपर नहीं अभी उसने और एक देख लो उसको देखो 712 लास्ट में हो है रिटर्न स्टेटमेंट नहीं ये तो डिसमिस किया और एक था अभी 2 दिन पहले जजमेंट उसमें दैट आई हर्ड दैट कि दिस balance confirmation and one document treated as
I'll do my research again.
Commercial. Just 2 days before I pass judgment. You go through that. Mr. Mitra, also you go through this. Because in this I have but in that case
I will. Lordship will mark. Lordship will.
You also consider with regard to here the this promissory note.
Promissory
that you consider.
I will.
My lord will mark it parted. Will kindly parted. Extensively heard before, lords. Will kindly the request.
Counsel for the parties argued the matter at length. Counsel for the defendant prays for time to further argue the matter. According to case is adjourned. Let the matter appear on 11th November 2025 as parted.
But 11th November.
I'm grateful. Lordship, I wish Lordship are very happy.
Lordship was kept parted. I couldn't hear. I couldn't hear. Sorry.
Okay, next.
I couldn't hear. I'm sorry, my lord. I'm sorry.
That in item number 13.
Lordship, in this matter, I beg to appear on behalf of the petitioner.
Milord, may I point this out? Milord, I have instructions to appear in item number 13. Mr. Shonak Mukhopadhyay is appearing in this.
Item number?
13.
13.
And Mr. Shonak Mukhopadhyay is appearing in this matter. He's not in town today. If a day's accommodation.
Then kindly keep it after vacation, Your Lordship.
What does that mean?
As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on 13th November.
I'm so grateful to Your Lordship. Well, I have provided my appearance in the chat box, Your Lordship.
Okay.
Very grateful.
Item number 14, I appear on behalf of the defendant. Today is fixed for our reply, Lordship. I'm being led by Mr. Pratik Mujumdar. He is arguing in courtroom number 11, Lordship.
Judgments, they have to side. They have to distinguish.
Yes, Lordship. He will
pass it over for 10 minutes and take it up before 12:30.
Yes, Lordship.
Judgments, they have to distinguish. That's all.
Not today. Come after vacation.
Very well. Your Lordship will send it.
Counsel for the defendant.
Yes, Lordship. Defendant.
Rest for time. According to cases adjourned. Let the matter appear on 13th November. Next.
Your Lordship, item number 15, I am appearing on behalf of the defendant. Your Lordship, I am led by Mr. Obidipto Tarafdar. Your Lordship, he has some difficulties not come to the court. Your Lordship, I am praying for matter may be listed after the vacation, Your Lordship.
As per the prayer made by the counsel for the plaintiff.
Your Lordship, I am for the defendant, Your Lordship.
Case is adjourned. Let the matter appear on 14th November.
Your Lordship, I am grateful.
Item number 16, my lord, I am for the plaintiff, my lord. Two applications. One is GA3 of 2024. It is their Order 7, Rule 11. And the other is, my lord, GA4 of 2024, my lord, wherein they have, my lord, asked for deletion of the name of the two directors of the company. My lord, now, my lord, they are about to start, my lord, but we had waited for our turn for long. So, my lord, I have categorically pointed and noted the date on 21st April 2025 when my lord was taking the matter extensively. My lord was of the opinion that let that be made an issue with the when the issue would be framed, let that be one of the issues, and the matter can be kindly pass that order because they lordship wanted them to take the instruction and come back.
Where is the other party?
But the other party is
who is appearing for the defendant?
But defendant appear করছে? Oh,
Dhruv Chando.
Yes.
16, Your Lordship, is my application.
Yes. Have you taken instruction?
We've taken instruction, Your Lordship. Mr. Sudur Banerjee is leading me in this matter. Maybe come back after vacation.
Why?
Because, Your Lordship,
let the issue be remain in the
as a preliminary issue, no, Your Lordship.
Yes,
Perhaps
21st April, my lord, categorically everything now is on virtual. We cannot make a somersault.
My senior had appeared in this matter. He made a submission. He indicated
only the direction for affidavit was there.
The directions for affidavit was made with respect to the defendant number 4 and 5. They have also filed their affidavits and taken out an application under Order 1 Rule 10.
But let that issue, after all, our object is to adjudication of the issue. Let the issue remain.
No, Your Lordship, we'll come
But
back
let
after
us,
vacation.
yes, my lord, that is the defendant.
Because, Your Lordship, it will...
For issues.
No, Your Lordship.
Framing of issues.
No, Your Lordship, for hearing out this application, I have a senior. Otherwise, Your Lordship, usually I start off the matters. Your Lordship, I have faltered. I have been reprimanded by Your Lordship. Just Your Lordship, the embargo on my part is I have a senior.
I believe am I led by Mr. Mitra?
Then Your Lordship, he also.
No, he's there on virtual. I don't know.
Yes, sir.
It takes some time, Your Lordship.
Sorry,
Yes, my lord.
and I couldn't see him.
But it's only today all matters are getting called on. All matters are getting called on. Even item.
Long we had waited for our turn.
We have also not anticipated for the seniors, the vacations have begun.
Seniors?
But seniors' vacations are begun, my lord. But the court is still functioning.
No, for the
working.
senior, most the vacations are yet to commence. It has some time.
As per the prayer made by the counsel for the defendant, case is adjourned. Let the matter appear on.
It be peremptorily adjourned.
Let the matter appear on
Every time.
6th November.
First time we are seeking an accommodation.
But the problem is that at the time of taking money, but the same thing, but all process, everything, but all documents generated, admitted.
It's India.
It is
It's
only
India.
at the time of payment, when the payback time is come, all cross-section, dissection of law.
That's why there is a phrase. In the politics, the leaders come to you before election. After the election, you have to go.
But I saw in a debate, Mr. Joy Ponda.
And for taking money, they will come before you. And after taking a money, then you have to go behind them to recover the money.
But in a debate, I had heard one politician, Mr. Joy Ponda of Bhubaneswar, in a Calcutta Club debate. He was saying, what is the meaning of politics? Poly means many, and tics means so. But only one pleasure of your lordship, if the hearing on 6th may be made peremptory. May that be indicated?
Come on then.
Peremptory. First time we are seeking accommodation.
Come on then.
We'll come back to that.
Yes, next.
May please, Your Lordship. This is my application under Order 13A in a suit, my lord, for recovery of immovable property. The only defense taken is that the tenants are having a heritable right, but we have shown through documents that
Tenants are having heritage.
Yes, but our point is, my lord, that there is no connection under Section 2G of the West Bengal Premises Tenancy Act, and they are all trespassers. My lord, Mr. Anirban Kaur, my lord, was making his arguments, and my lord, I am led by Mr. Aniruddha Chatterjee, a senior advocate. We had, my lord, concluded our argument. Mr. Kaur, my lord, was advancing his arguments, and your lordship has substantially heard this matter. As I do not see Mr. Kaur over
No, my lord, he's on his way, my lord. My brief has not reached. That's why I was just praying for a short passover. Just short passover, my lord. We will conclude today itself, my lord. Short passover, my lord.
Passover.
Only one prayer. Item number 16, my lord, fixed it on 6th November. On a joint prayer, may it be on 7th instead of 6th. 7th number, deeply okay.
Number 18.
None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear in the combined monthly list of December 2025.
Number 19.
My lord, for the plaintiff respondent, there was a direction for affidavits. It was an undefended suit. Then the defendant made an application for recalling, saying that they were not being served. My lord had given directions for affidavits. We have served our affidavit upon them. My lord, may I file my opposition? We have not received any reply till now.
You
18th December 1.
You are appearing?
in 18, my lord. Previous item 18. I was just after the
Affidavit in opposition filed by the plaintiff be kept in the record. 19. Affidavit in opposition filed by the plaintiff be kept in the record. None appears on behalf of the defendant. Let the matter appear on 10th November.
Grateful, my lord. Deeply obliged.
Yeah, at matter 20, na?
This is item 19, my lord.
19.
19.
Item number 18. Only the documents has to be submitted, my lord.
Yes.
Item number 18, my lord. I was plenty.
Where is the other side? Other side left.
Not appearing, my lord. Item number 18. Only the documents has to be submitted. It was transformed commercial division, and only the commercial division documents has to be submitted. And it is ready documents. I can submit.
What you are telling?
The statement of truth and all that.
18. What is the order for? You are appearing for whom?
I'm the plaintiff.
Yes. What do you want?
The documents are ready for submission after
What
changing to
document?
the commercial division, my lord. After changing to the commercial division, this was filed in the non-commercial division. It was changed to the commercial division. The documents are ready for filing the statement of truth and all that.
6 minutes रह गया, कुछ नहीं है. GA3, who has filed the GA3?
GA3 is my application, my lord. My application
What
for recalling of the order
supported
dated 18th May.
Huh?
18th May recalling order. But by that,
for the plaintiff.
I'm for the plaintiff. And what has done?
What is the order? 18th order? 18th May?
18th May 2020.
Where is the order? May 2018. Who is for the defendant?
The defendant on the last occasion had appeared, my lord. The defendant has submitted that they have a counterclaim of 77 lakhs and odd. But by that order, by the 18th May order, the Honorable Justice Somin Sen has directed that the matter order, that amount may be secured by the plaintiff.
Correct.
We have done that, but no counterclaim was filed. No counterclaim was filed, and the detention statement has already been filed by the defendant. But we are paying for foregoing or recalling of their order and release of the 77 lakhs.
Upon depositing rupees 77 lakh with registrar, the original sets shall be entitled to release the original deed presently in the custody of the defendant. The registrar original sets are invest the said amount. National LIC is directed to release the original deed after the. Yes, then.
Thereafter, they have filed a return statement, but no counterclaim has been filed by them. And that is why we are paying for release of the sum that we have deposited on the pretext that they have submitted before this honorable court that there is a claim of 76 lakhs and odd. They would file that, but they have not done that. Our prayer is to release that sum, which we have already secured before the registered original site. May I submit the documents, list of documents and statement of truth?
Yes, so
we are paying for release of the 77 lakhs that we have.
Why? How it can be released?
But they have not filed any
Where is the
counterclaim.
condition that he will file the return statement counterclaim? Can you come to the order? That's why I have read thrice. After your submission, where is the order that he will file the counterclaim, and that's why you have to
I have to kindly see page 85 once. Page
Yes.
85.
Yes, I am there.
Since on the basis of the calculation produced before this court, the defendant cannot have any claim over and above rupees 77 lakhs.
Correct.
And the plaintiff is willing to secure the sum. Why have I secured the sum? Because they would file the claim. They have not filed any counterclaim.
Show me any submission that the plaintiff is defendant is going to file the counterclaim
But
of
if,
rupees 77 lakh. That's why you have been
But with
direct-
greatest of respect, if they do not file any claim, how will be they liable to
That
get the
might
claim?
be that I don't know what was the mind at the time of the court.
But if they do not give 76
Or you want to recall, you go to the appropriate court for recalling of this order. The judge is available.
But only one thing.
This court cannot recall this order.
I kindly take into note that if they do not file any counterclaim, how will their claim
That's why
start?
show me any
This is the
piece of
thing.
any sentence, any line of the sentence or any word that this 77 lakh subject to filing of the counterclaim by the defendant. What is that? Maybe you if you tomorrow you will lose the matter. You will dismiss your suit is dismissed. Automatically the defendant will take the 77 lakh because
They
the
have
loan
filed their
amount.
opposition and reply, and we have also filed a supplementary affidavit. Supplementary affidavit says that and the petitioner is a MSME unit, and the MSME unit is not liable to pay 2% foreclosure charges. And it on the face of it, it shows that the claim that they have said that 76 lakhs is bad in law. That is why this application was filed. It has to be heard by both the
Go
sides.
to the court.
This is not only for recalling, my lord. The whole thing will be decided by this application only, because, my lord, they have claimed the 76 lakhs is their claim, and this arises out of a foreclosure that we will pay 2% if we give early repayment of the loan. That was the terms. If we give early repayment of the loan, we will have to pay extra 2%. Now, plaintiff is a MSME company, and we have filed a supplementary affidavit. The notification says.
Kindly come to the prayer, quash and set aside the purported demand of the defendant to the 76 lakhs.
Yes.
They
That
are
has to
having-
be set aside by watching the.
What is your prayer? What is the suit for? Where is the suit?
This is a
What is the suit for?
suit for declaration that the demand is bad, my lord.
Then.
But that is why, my lord, this supplementary.
If your suit is demand is bad and you are asking for the interim order with the quashing the demand.
And because the supplementary, my lord, kindly see the supplementary affidavit once. I filed my supplementary affidavit in GA3.
Where is the supplementary affidavit? Yes. What is there in the supplementary affidavit?
And the notification that says MSME unit are not liable to give foreclosure charges to the banks. Kindly see page 6, my lord.
So proceed with the suit.
That is why, my lord, this application has to be heard. If this is decided that this notification is true and correct and is binding upon the banks.
Suit का है? What is the suit for? The declaration, the demand of the defendant is bad in law.
Yes.
And you wanted to cause in the interrogatory application.
My lord, why I am saying this? My lord, they have not filed any claim. They has to file a counterclaim. Orders it cannot be in the eyes of the law. It
Oh,
stands.
you come with the suit. You proceed with the suit.
But I'll do it. My lord, kindly give me some time.
Plaintiff has filed an application being GA3 of 2023, praying for quashing or set aside the purported demand of the defendant to the extent of rupees 76,11,984 on account of repayment charges for early foreclosure of the loan amount. The plaintiff has also prayed for recalling of the order dated 18th May 2018 passed by this court in TA number 8 of 2018 and release the fixed deposit amount of rupees 77 lakhs only, along with the recalling of the dated 18th May 2020 passed by this court, itna full stop. And to release the deposit amount of rupees 77 lakh, full stop. Counsel for the plaintiff submit that by an order in compliance of the order dated 18th May 2018, the plaintiff has deposited an amount of rupees 77 lakhs. 77 lakhs. But the defendant has not though the defendant has filed the written statement, but the defendant has not raised any counter claim. He submits that if the defendant has not made the counter claim, so depositing of the money by the plaintiff in terms of the order dated 18th May 2018 does not create any right upon the defendant, and thus the 77 lakhs is to be released in favor of the plaintiff. He further submit that as per the MSME scheme, the defendant bank cannot claim the 2% interest.
Yes, foreclosure charge. Foreclosure charges.
2% interest
The
over
prepayment loan charge.
over the foreclosure. Over the foreclosure of loan.
Yes.
Foreclosure of loan. But the defendant bank is claiming the said amount for the foreclosure of the loan amount.
But RBI notification.
This court has considered the prayer made in the plaint, which reads as follows: prayer A, prayer B, and prayer C. The plaintiff has filed this suit praying for a declaration that the demand made by the defendant on account of the repayment of charges at the rate of 2% plus GST is bad and illegal. Now, by interlocutory application, the plaintiff pressed for decide the demand made by the plaintiff is made by the defendant is bad, and release of the amount deposited by the plaintiff in terms of the order dated 18th May 2018. The order dated 18th May 2018 does not reflect that this court passed an order directing the plaintiff to deposit the amount of 77 lakh subject to raise the claim by the defendant by filing counterclaim. If the plaintiff's claim is this court find that the main claim of the plaintiff that the demand of the defendant is bad in law, and at this stage in this interlocutory application, if the court decide that the demand made by the defendant bank is bad in law, then nothing will be survive in the main suit. It is settled law that by way of interlocutory or application, no relief can be granted which affect the final relief. Considering the above, this court find that the application filed by the plaintiff being GA3 of 2023 does not having any merit. According, the same is dismissed.
And the documents will be kept in record, the statement of truth and affidavit in compliance, all the documents.
The affidavit, statement of truth and affidavit document.
List of documents, statement of truth, and affidavit in
has filed the statement of truth, affidavit of document, list of documents, and
compliance, affidavit in compliance in order 11.
And affidavit of compliance be kept with the record. Yes, next.
The suit may be appear.
Yes.
Suit may appear on.
Let the suit appear on 12th of November 2025. What is the stage of the suit?
Nothing has been done after transfer of the commercial.
This would have 1230, item number 6.
Like to appear for the defendant bank.
ये मनु को उसको बोला था तुम, रूपक को उसको बोला था नहीं दिया. Yes.
Plaintiff had started his argument on the last occasion. We were supposed to continue.
One day before
Vacation mode.
Mr. Aniruddha Mitra is appearing online. Mr. Aniruddha Mitra is appearing online. He's leading us in the matter.
On the last occasion, I have placed to your lordship a portion of my case.
Continue.
I leave it here.
Come after vacation.
Kind of market has hardened part because arguments have commenced.
The main suit.
Yes, yes. It's hearing going on.
Yes.
For the plaintiff has argued the matter for some time, but prays for adjournment. Accordingly, case is adjourned. It is found that the case is at the stage of final argument. Accordingly, it is found that the case is at the stage of final argument. Let the matter appear on 13th November as part heard. Answer.
Well, in the event I don't get any opportunity to address your lordship any further in any other matter, I wish your lordship a very happy puja.
Thank you. Same to you. Enjoy the vacation and happy puja to all of you as well as the Diwali also.
Madam, item number 17.
Please, your lordship. This is fixed for arguments. I will not.
May I say something? I'm led by Mr. Chatterjee Miller. So today I'll not be able to come. But substantially heard by your lordship. Rest I leave it.
No, already see.
But substantially heard. And this your lordship has heard. Mr. Kaur will definitely be.
What is the matter?
Miller, it is an eviction suit. My application, Miller, for summary judgment of eviction of the people who are occupying. My ground is trespass.
He has filed an application for deletion.
No, my application, Miller, is under Order 13A, seeking summary judgment. There is no application filed by the defendant, but they have also raised the issue whether it is a commercial dispute or not. And Miller, we have been arguing before your lordship at a great length. And interpretation of section 2G was also taken into consideration by your lordship. Miller. So this is interesting facts before your lordship. And your lordship has heard this matter.
Counsel for the parties argued the matter at length. Accordingly, but due to paucity of time, hearing could not be completed. Accordingly, case is adjourned. Let the matter appear on 14th November.
Parted.
As parted matter.
And will it be your lordship's pleasure to allot a time if 14th is, if time is there?
Then let's see if there remains, then we'll see to that.
Very well.
If but not, then automatically it will come.
But parted, Miller, I'm deeply obliged.
Yes, next.
Item number 20. 20, I appear for the plaintiff. This is the defendant's application for rejection of claim. Mr. Bagh was appearing, he had concluded his submission.
Shall I reject?
No, Malad. The only ground is suit is barred under a foreign law. Singapore Bill of Exchange.
Which
Act.
one?
Khaitan International, the Bill of Exchange sent from as per their submission.
Acha, that one.
Yes.
Who is appearing for the other side?
But Mr. Bagh was appearing for the plaintiff. He had concluded I was supposed to start. Now.
I am appearing for defendant number 2 and 3, your lordship.
The matter appear on.
My lord, there are two applications for extension of filing the written statement, my lord, GA number 6 and 7. They're formal in nature, my lord, within 120 days, but delay by 48 days. If those applications could be allowed.
No, that application for extension of time given that will be disposed of.
But I do not know. I think I have not filed any opposition to that. But if it is within 120 days, then
it is within 120 days, delay of 48 days, your lordship.
Have you filed the written statement in the department?
Yes, your lordship, we filed it on 17th June, my lord, 2025. Your lordship, my explanation, my lord, is at paragraph 6, page 4.
If it is on record within 120 days, then I have nothing to say. But I do not know whether it is taken on record.
Written statement hai kya?
Your lordship recollects there was an order on 17th June, your lordship. Leave was granted to us to submit the written statement.
That's why you have submitted, because there is no. Have you got the back page of the department's endorsement?
Your lordship, I do not find my advocate on record.
You granted to file written statement within a week, subject case. Yes, this is fine.
That file.
When you receive the writ of summons?
Your Lordship, on 1st April 2025, and we had to file the enter appearance and file by 30th April 2025. 30 days, my lord. And Your Lordship, the written statement was affirmed on 11th June. And on 17th June, Your Lordship had granted us leave, and we had got it before the department on the same day. Thereafter, my lord, we were told that since it is 30 days beyond for written statement, filing of written statement and entering appearance, my lord, formal applications had to be filed. Paragraph 6 is my explanation, Your Lordship. Two applications, separate applications, similar ground, defendant number 2 and defendant number 3.
Anutosh. Pick up my book. 30th April. अच्छा 30th अप्रैल क्या तो बोलते नहीं फाइन हुआ डिफेंड नंबर 2 का कहाँ है यार लोग उल्टा सीधा देते हैं डिफेंड नंबर 2 का कहाँ है और एक है ना ये G6 ना G6 डिफेंड नंबर 2 का The defendant number 2 has filed the present application being GA-Com 6 of 2025, praying for extension of time to file return statement. Counsel for the defendant number 2 submit that the defendant number 2 received the writ of summons on 1st of April 2025 and has entered appearance on 12th of June 2025. She submits that the defendant ought to have filed the return statement by 30th April 2025, but the same could not be filed as after receipt of the writ of summons, the defendant has contacted the advocate on record of the defendant, and the advocate on record of the defendant has instructed to bring all the relevant documents so as to enable the advocate to prepare written statement. By that time, the 30 days was over, but the defendant has affirmed the affidavit on 11th of June 2025 and with the leave of this court has filed the same on 17th of June 2025. They submit that though the defendant has not filed the written statement within the period of 30 days, but has filed the written statement within the auto period of 120 days, and accordingly she prays for acceptance of the written statement. Per contra, an advocate appearing for the plaintiff raised objection and submits that the defendant has not shown any cause why the defendant has not filed the written statement within the period of 30 days. Merely filing an application, the court cannot allow for extension of time to file written statement. The defendant has to show the reason why the defendant has not filed the written statement, but the said reason is absent in the present application. Heard the learned counsel for the respective parties peruse the materials on record. This court finds that the defendant has received the writ of summons on 1st of April 2025. The defendant ought to have filed the written statement by 30th April 2025, but it was not filed. The defendant has affirmed the affidavit of the written statement on 11th June and filed the same in the department with the leave of this court, subject to acceptance by this court on 17th of June 2025. This court finds that the defendant has filed the written statement with the leave of the court within the outer period of 120 days. Accordingly, this court also finds that the defendant has shown sufficient reason why the defendant has not filed the written statement. Accordingly, this court is of the view one opportunity is to be given to the defendant to file return statement subject to payment of cost of ₹5,000 to the High Court Legal Service Authority Committee within a period of 1 week after the ensuing puja vacation. Department is directed to accept the written statement subject to scrutiny by the department. The defendant is directed to serve the copy of the written statement within a week after puja vacation.
If there is a counterclaim, Lordship,
Counterclaim is there.
No, Your Lordship, there is no counterclaim. And my Lord, one humble request, if the cost could be waived, my Lord.
Cost should be there.
Within 120 days, Your Lordship, if the cost could be waived.
You see the law.
Yes. It's an humble request, that is why, my Lord.
3,000 करो दूसरा वाला क्या है और एक जी है ना हाँ
वही
सेम आएगा GSM
Same, Your Lordship, same ground.
Depend number 3
Yes, Your Lordship.
Depend number 3 वही 11th affirm 17 June affirm इतना 5 same आएगा
Grateful, Your Lordship.
3,000 each.
Lordship may keep mark the matter as parted, my lord, for the application for rejection of claim. The Lordship has heard, my lord.
The GACOM 4, my lord, I have concluded my submissions. It is for my learned friends now to, my lord, submit.
Complete.
After the application.
Next.
Very
Only
deeply
for my redundant submissions.
Deeply obliged.
Already 4 matters kept parted.
I understand.
Grateful, Your Lordship. Wish you happy pujas and happy Diwali.
Deeply obliged. I hope I get to wish that tomorrow, my lord. Very deeply obliged.
Let the matter appear. Let the suit appear on 12th November.
The suit as well as other pending applications. Grateful.
And connected.
Grateful.
He appear on 12th November. Yes.
21, my lord, is that matter, my lord.
Respondent number 12, my lord.
My lord, today I don't want to bother, my lord. My lord, the interim order is expiring today, my lord.
From tomorrow 10:30 onwards.
Yes.
Till the conclusion of the hearing.
Conclusion.
Whole day if I am fixing this matter for here. So that the maximum bar member will be here.
Tomorrow, my lord.
Benefited us.
Yes, for my lord, so many of them.
That's why I'm telling the total bar members will be here.
My lord, only one prayer, my lord. My lord, this has been more than substantially heard, my lord. My lord, kindly, this one.
You're worrying, I am here only.
My lord, kindly.
If that assurance is there, then
my lord, if my lord is assured, my lord will kindly just reflect that, my lord, by making it part heard, my lord, kindly.
Not even joint prayer.
My lord, join. My lord, all the parties, my lord, kindly. My lord, isn't heard 3 days, my lord, substantially.
Several.
My lord has almost heard of the suit. It's like that, the way the arguments have been made.
No,
my
only
lord,
you are argued.
Yes, my lord, but very, my lord, very substantially. Yes, my lord, everyone is very energized in this.
As per the prayer made by the counsel for the parties, case is adjourned. Let the matter appear on 11th November.
My lord will fix a time. My lord, then that can be finished, my lord. My part can be over.
Then it will go December. That is the problem.
Then my lord, I can finish my.
Then you wait for the determination.
No.
The time can be rescheduled.
My lord, kindly marks it parted, my lord.
Yes, next.
My lord, interim order has been extended, my lord. Interim order.
Till today?
Till today.
Interim order is extended till 12th November, na? Till 11 November or until further order, whichever is earlier.
My lord has kept it on 11th and the interim order is till 12th. Though,
11.
My lord kindly keeps it for 2-3 more days. That
interim order is
buffer,
extended
my
till
lord.
13th November or until further.
My lord. I'm grateful, my lord.
Only GA1. Parted with regard to the GA1 of the J1. Parted with regard to GA1. वो जितना भी है ना वो सबको GA कर दे. Yes.
Lord, I appear for the defendant. Your Lordship had sent the parties to mediation. The mediation has been successful. Parties have settled. We have also made payment of the first installment.
My lord, I appear for the petitioner plaintiff.
Yes.
This is the terms of settlement agreed in the mediation.
Order दो, पहले का order दो और suit दो. What is the suit? What was the suit for?
My lord, it is a suit for goods sold and delivered.
On account of price of goods sold and delivered.
So agreed for the 11.
Yes.
Both the parties agreed
Yes,
to pay rupees 11,40,000.
Yes, my lord.
11,40,000. 8 lakh as a principal and 2 lakh as a interest.
Yes.
And the rate of settlement. Yes, record, madam. The by which order it was sent to the media? By an order dated 25th of July 2025, this court referred the matter to mediation for settlement between the parties. The parties have appeared before the mediator and have settled their dispute. It is fine from the settlement arrived between the parties that out of the total claim of rupees 14,09,088, the defendant has agreed to accept the total amount of rupees 11,40,000, out of which 8,91,828 as principal amount and rupees 2,48,172 as interest as on 18th of August 2025. The mode of payment and the date of payment is also described in the settlement arrived between the parties. Considering the above, this court find that the parties have settled their dispute and nothing remains in the present suit. Accordingly, the settlement is accepted. Settlement arrived between the parties before the mediator dated 18th August 2025 is accepted. CS number PSCOM 810 of 2024 is disposed of. The department is directed to draw of the final decree, and the settlement arrived within parties dated 18th August 2025 before the mediator shall be made as part of the decree. As the suit has been disposed of in terms of the settlement between the parties, according all interlocutory applications also been treated as disposed of.
Grateful, my lord.
Thank
Take
you.
back may I take back the terms of settlement that I handed? Grateful.
Next.
Item number 23. I appear for the plaintiff petitioners. There was a subsisting interim order. But I find that it is being extended till 7th of August. But by another no.
November.
I'm sorry, November. Sorry. So Millard keeps it after vacation. There is
7 November.
Yes. So Millard keeps it after vacation. Millard after vacation we will play.
Let the matter appear on 7.
Yes.
It is fine that by an order dated 29th August 2025, the interim order is already extended till 7th of November 2025 or on 7th November 2025 or until further order, whichever is earlier. Let the matter appear on 7th November.
Your Lordship, if it could be kept part heard, it has been substantially.
Next.
Great. Obliged.
My lord, I am for the plaintiff petitioner, my lord, in this matter. My lord,
behalf of the defendant.
Yes.
Item number 24, my lord, I am for the plaintiff petitioner.
Yes.
My lord, I have filed application under order 13A of CPC, my lord. In this matter, my lord, the respondent has filed their opposition. And my lord, I am out of time to file my reply. My lord, I pray for 1 week time to file reply after
As per
vacation,
the
my
prayer
lord.
made by the council for the plaintiff, time to file reply is extended for a further period of 1 week after ensuing puja vacation. Let reply be filed within a week after puja vacation. List the matter on 17th November 2025.
I'm grateful. My lord, this is in regard to GA number 2, my lord, 2 of 25.
In connection with GA2. Affidavit
I'm grateful.
connection with GA number 2.
I'm grateful.
Okay, कोई आई नहीं. Yes, any parties in any matter, both the parties are ready to argue the matter here.
25, my lord. Next matter, my lord. The plaintiff is not appearing. I have made an application for refund of the return of the bank guarantee I have deposited, my lord. In the last order, my lord, it was the pleasure of your lordship to seek a report from the Registrar General or your side, my lord. It has been dismissed for default. No registration application is there.
So
And there was a direction for bank.
Yes.
Register said supposed to report.
What you want?
I want the bank
Amount back.
Yes.
Amount back.
Not amount, but the bank guarantee I have deposited the bloody register. That
Correct. That you wanted to return,
Yes.
take back
Yes.
that amount.
Yes.
15 lakh rupees.
Yes.
By an order dated 15th September 2025, this court directed the registrar original site of this court to submit report whether CS Com 26 of 2024 within bracket CS Com 339 of 2001 bracket close is restored or not. Restored or not. The registrar original site has submitted the report wherein it reveals that till date the suit has not been restored. Suit has not been restored. The plaintiff has the defendant. You are the defendant. The defendant has filed the present application, being GA Com 10 of 2025, praying for an order for allowing the defendant to withdraw the bank guarantee submitted. Bank guarantee of rupees 15. It was not invested in the interest bearing account.
Is the bank guarantee, my lord?
क्या बोला बैंक क्या withdrawal of the bank guarantee of rupees 15 lakh submitted before the registrar original site of this court in terms of the order passed by this court dated 30th May 2006, which was extended from time to time. Full stop. As per the report submitted by the registrar original site, the bank guarantee number 0999806 capital B capital G 4 times 0 168 dated 5th June 2006 for a sum of rupees 15 lakh issued by the State Bank of India, corporate accounts group branch within bracket code 9998 bracket close Reliance House, second floor, 34 Jawaharlal Nehru Road, Kolkata, was furnished, is lying before the register original site. Original site in connection with old CS number 339 of 2001. Within bracket Sarachi. What is the case to cost title?
Yes, there is a change in cost title.
Within bracket Sarachi Securities Limited versus Bajaj Tempo Limited. Bajaj Tempo Limited. When the name was changed? By which order?
My lord, once.
You are having order?
So I'm right. Vidya Ganapa.
Are you sure? By which order the name of the parties have been changed?
Order in GA8, my lord, that has been allowed.
इसमें देखो ऑर्डर है मनतोष सीएस का ऑर्डर देखो हाँ हाँ इसमें नहीं है 2022 का ऑर्डर डेटेड
GA8 2022.
हाँ
GA8 2022.
G8 CS 339 of 2001 2000 है हाँ order date 17 December 16 January 23 6 January 6 January 23 नहीं है
জেনারেল অ্যাপ্লিকেশন ছিল
नहीं है हाँ। 9 से लेकिन नहीं है तो अच्छा ठीक है चलो हाँ क्या बोला so party number na counsel for the plaintiff submitted though the initially the name of the parties of the suit was क्या नाम था सराची ना सराची सो वर्सेस सो वही होगा अमेंडमेंट फॉर्मल नेचर प्रिंट है प्रिंट भी नहीं है यू आर हैविंग द प्रिंट अमेंडेड प्रिंट ओके क्या बोला Name of the parties of the suit was Sarachi Securities Limited versus Bajaj Tempo Limited. But subsequently, by an order dated 6th of January 2023, in GA 8 of 2022, this court has allowed the amendment in the cause title of the suit by changing the name of the plaintiff and the defendant as Poonawalla Pincrop PW versus Force Motors Limited. Force Motor Limited. Considering the above, this court find that the suit has been dismissed. When it was dismissed, it was dismissed for default by an order dated 13th of March 2024. And since then, the plaintiff has not taken any steps for restoration of the suit. And as on today, there is no suit is on record. Accordingly, the defendant is allowed to, according the registrar, original side of this court is directed to release the bank guarantee number 0999806B 6 capital BG 40 4 times 0 168 dated 5th June 2006 for a sum of 15 lakhs of the State Bank of India corporates accounts group branch in favor of the defendant within a period of 1 week after ensuing puja vacation, after proper identification and acknowledgement. Puja vacation acknowledgement. Yeah. GA number GA-Com 10 of 2025 disposed of.
26.
Huh? Yeah.
Yes, Milord. Item number 26, 27, and 28, Milord. Quite a serious issue.
Serious issue?
Yes.
Then it has to be go out of the list.
Milord, needs reprimand, Milord, now. Your Lordship was pleased to pass 3 decrees in a suit, Milord, for recovery of money. It went undefended. In execution, Milord, the first order, it was filed in January. Rahul S. Shaw, Milord, mandates that it has to be completed. Execution must be completed within 6 months. Now, Milord, in February, Milord, attachment order was passed. Injunction order was also coupled with that. Thereafter, Milord, from March, affidavit of assets has been directed. Before your Lordship, Milord, your Lordship had given 3 directions. Mr. Mitra was appearing in this matter. Because every time, the same, Milord, judgment debtors were filing affidavits which were incomplete. Day before, and Milord, this examination of judgment debtor, the order is, Milord, being passed since May 2025. And today, Milord, the last order is of 8th September. I do not know, Milord, whether they are present or not.
Your Lordship, as time was not fixed, Mr. Nilkanto Shah,
time was not fixed. This is not a train or a plane.
This is not well. That is why.
Who is not well?
Mr. Nilkanto Shah.
Who is he?
Was to be examined today.
There are four judgment debtors.
This court is having all medicines. He will.
Milord, I am formally placing
this, Milord. Within 2 hours, can I send the medicine
to
Nilkanto Shah? Within 2 hours, he will be total okay. Which PS? Which PS under he is residing?
Lake Town.
Lake
Town.
Lake Town. So it is far. No, 2 hours will be.
Can direct tomorrow. He will be appearing tomorrow.
Let that be so, Milord. I will be coming to
yes,
court.
What is your submission?
Milord, my submission is, Milord, today under this situation, I have cooperated, Milord, from March 2025. Milord, I would be, Milord, making my submission in line with Order 41, Rule 3, which says in case of disobedience of any order, that is, Milord, for examination, the court may direct the person disobeying the order to be detained in civil prison for a term not exceeding 3 months, unless before the expiry of such term, the court directs his release. Now, my lord, may I kindly bring to your lordship's attention this particular observation made by the Honorable Supreme Court, my lord. Kindly have a look at paragraph 73. It takes into consideration, my lord. Actually, the Supreme Court is now giving too much of importance. And Justice Pardiwala's order, we keep on finding in live law every day. There is some meaningful judgment passed by the Honorable Supreme Court. My lord, kindly have a look at paragraph 74, which is at the second last page. Because the onus, my lord, is now getting shifted to the presiding officer who is taking up execution proceedings. And I must show to your lordship, my lord, what is the correct proposition in law. The mandatory direction contained in para 42.12 of Rahul S. Shaw require the execution proceedings to be completed within 6 months from the date of filing. This has been reiterated by the court in its order in Bhojraj Garg versus Goel Education. In view of the aforesaid, we direct all high courts across the country to call for necessary information from their respective district judiciary as regards pendency of execution petitions. Once the data is collected by each of the high courts shall thereafter proceed to issue an administrative order or circular directing respective district judiciary to ensure that the execution petitions pending in various courts shall be decided and disposed of within a period of 6 months without fail. Otherwise, the concerned, now it comes to the officer. And not following this judgment, Millard, the Punjab and Haryana High Court has
But
actually
they are answerable to the High Court. Where I will answer?
that is, of course, Millard. This again, the Supreme Court may come up with something else. So, Millard, that's why restricted myself, my submission to Order 41, Rule 3. I am asking for civil prison, Millard. That is my instruction.
Lordship, we have complied with all the.
This is a wrong submission.
What we have complied, madam?
Your Lordship, all the affidavit of assets as your Lordship directed, we have.
Why you are not paying the amount?
Your Lordship,
let the affidavit. What are the
even in the affidavit of assets? It is the partnership.
What are the assets are having?
Millard, they are.
Any amounts are there in the
No, they have suppressed that. It is a partnership firm having, Millard, a history of
only the attachment of the person only.
40 years
Not
the
the
partnership firm is running. They didn't even disclose the partner's capital. And when I brought this to your lordship's notice, Millard, your lordship said that I can examine him.
Okay. Okay, I am fixing a date. Let the examine.
And Millard,
if it will not come, then I will pass an order.
Yes, Millard. And your lordship may kindly indicate, Millard, that if they are not present, then Millard, civil prison would be the.
Though the matter is fixed today for examination of the judgment debtor, but the learned counsel for the judgment debtor submitted the judgment debtor is not well and is under medical treatment and he prays for time. The learned counsel for the decree holder relied upon the judgment in the case of Priyamal within bracket dead through the legal heirs and others versus V. Rajamani and another reported in 2025 SCC Online 507.
Not SCC Online SC.
SCC Online SC 507, wherein the Honorable Supreme Court has held that requiring the execution proceeding to be completed within a period of 6 months from the date of filing. The Honorable Supreme Court also reiterated the judgment passed in the case of Bhojraj Garg versus Goel Education and Welfare Society. Full stop. The learned counsel for the defendant assured before this judgment debtor assured before this court that on the next date fixed, the judgment debtor will be present for
the judgment debtors,
the debtors will be present before this court for their examination. Accordingly, for the interest of justice, the case is adjourned. Give the date. Let the matter appear on November 14th November at 11:30 for examination of the judgment debtors. It is made clear that on the date fixed, if the judgment debtors fail to appear before this court for any reason, the appropriate order will be passed.
Millard, may kindly indicate, Millard, civil prison is the next stage.
Appropriate order.
Very good. I'm deeply obliged.
Yeah.
And Millard, the only hurry is, Millard, the person who is, Millard, the decree holder, he is 86 years old. It's a company, husband and wife are the directors, 86-year-old and 83 years old.
Okay.
Obliged.
Any matter further?
Lordship, if I may seek leave to move item number 34 in your Lordship's today's list.
Serially, I find this.
Millard,
So many urgency is there. Yes, call the list.
My lord, I'm appearing for the my lord for the applicants, my lord. The applicant, my lord, has been roped in as a judgment debtor in the proceeding, my lord. The decree suffers by a partnership form, my lord. In application, my lord,
What
the
you want
petition,
now? Who is for the plaintiff?
my lord, I am seeking discharge, and my lord, there is an order of attachment of my bank account, my lord.
Led by Mr.
Okay, let it come after vacation.
My lord,
On behalf of the petitioner, and senior counsel is now out of station, so I'm praying for not to.
Tell the senior counsel vacation was not yet started. 2 days left. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 18th November. Yes, any urgency matter?
Number 32.
Huh?
32, my lord. Kindly fix it after vacation. I am for the
32.
32. I am for the
32, as per the prayer made by the counsel for the decree holder, case is adjourned. Let the matter appear on 19th November.
So by item 30, I am only to file my affidavit of assets.
My lord,
30. Counsel for the.
I am for the
30 you are appearing?
for the decree holder.
Your lordship kindly comes to the affidavit of asset is completely vague, your lordship. 2 chances has been given to them. Nothing has been disclosed, your lordship. One property, 46 kathas of land, no description of the property as well.
Lordship, whatever knowledge I have, I have disclosed.
Knowledge, why you not taken the total description from your client?
Lordship, whatever I could extract out of my client, I have.
It's not in terms of that.
No, your lordship, that.
Form 16.
No, your lordship, it's in terms of Form 16 because your lordship had granted me, and your lordship had also asked me. Yes. Your lordship, I have only stated in paragraph 11 that I have not suppressed any material facts. If thereafter, your lordship, the client has not, then he will face the consequences.
Kindly comes to paragraph 80. Portion of land approximately 46 kothas is in company's possession. No description of the land, whether it is
Okay,
the
you
property.
take this, you take all the, you want to examine the.
Lordship.
The counsel for the judgment debtor has filed affidavit of assets after serving the copy to the learned counsel for the decree holder. Counsel for the decree holder submits that though the judgment debtor in paragraph 8 within bracket E has mentioned about a portion of the land but has not given any description of the said property.
Your lordship.
Police, this court find that though the judgment debtor has filed the affidavit of assets, and if the decree holder is having objection with regard to the said affidavit of assets, the decree holder is free to examine the judgment debtor before.
Your lordship, one other thing, your lordship. I have come across certain documents that they have a factory land. May I bring that on record?
Okay, you bring the.
Lordship, I have no
take all this. Let the matter appear on 17th.
my lord, in the meantime, my lord, the order dated the 28th July 2015, my lord, there was a direction for a keeping a amount aside in a bank account, my lord, attaching to the PAN account, my lord. That should be continue, my lord. That should be continue, my lord.
What order dated?
28th July 2025, my lord.
28 July. Initially, it was only for 3 weeks. May it extended it.
28th July.
Yes, yes.
My lord.
28th July. Thereafter, it was not extended.
No, my lord, because since they were the filing, my lord, their affidavit of asset, but is still in not.
Interim order dated 28th July 2025 is extended till क्या date बोला 17 November 2025 or until further order, whichever is there.
Grateful.
Yes.
Lordship, I'm praying for your lordship's leave to file my written statement.
When you receive the writ of summons?
Writ of summons on 8th of August, 8th of September, 30 days expired. We affirmed it on 12th of September. Thereafter, application has been filed. It is yet to be. Just for the department. To be filed with the department.
Today you will file?
Yes, today we can file. CS Commercial 68 of 2025.
By tomorrow.
Before lordship rises.
I'm deeply obliged, your lordship.
My lord, item 31, my lord. My lord, here we have a very courageous, my lord, judgment debtor here, my lord. I am for the decree holder, my lord. 31, my lord. My lord, on 31st of July, my lord, your lordship directed, they were not appearing, my lord. Previous notices were issued, the judgment debtor was not appearing. So your lordship, my lord, directed the local concerned police station to serve notice on the judgment debtor and file a report. Report was filed, my lord, on 8th of September, my lord. If your lordship takes the report filed by the judgment, by the police, my lord, page 2 of the report, my lord, categorically states his mobile number just my lord,
Yes,
about
he was
and the
contracted to
address, new
provide the
address.
request to provide the present address, but he stated that he would provide the same. After consulting the advocate, he was communicated the order of the High Court.
He appears before the
verbally informed the present is residing in. Yes, then
new address was given, my lord. So, my lord, your lordship, my lord, directed me to serve again in the new address, which I did, my lord. Now, my lord, this is the envelope which comes back, my lord. After he, my lord, the judgment debtor going to the police station and stating his own address. Now, when I send the notice and the papers to the judgment debtor, he says it's come back as left. I'm only praying, my lord, this is my, my lord, affidavit of service.
Recorded note.
I'm only praying, my lord, a warrant now be issued, my lord. Otherwise, my lord, he'll not come to terms.
The judgment decree holder has filed the present execution case for execution of the decree passed by this court dated 10th of September 2024. After filing of the execution case, the notices were issued and the plaintiff has and the decree holder has taken steps for issuance of notice of the judgment debtor, but that same could not be served. Accordingly, this court has directed
on 31st of July,
this court by an order dated
31st of July.
ऑर्डर क्यों नहीं रखते यार तुम लोग? क्यों नहीं रहता ऑर्डर फाइल में? क्या बोला?
Oh, it's
by an order dated
28th
28th of July 2020.
28.
You are
28, my lord. I stand
28th of
corrected.
July 2025. This court directed the judgment debtor and directed the officer in charge of Jora Bagan police station or the concerned police officer in charge to नहीं क्या बोला? This court has directed the decree holder to serve by an order dated 28th of July 2025. This court directed the decree holder to serve the notice through the officer in charge of Jora Bagan police station, and the Jora Bagan police station or the concerned police in charge of the said police station is directed to file the report with regard to the service of notice upon the judgment debtor. In compliance of the order dated 28th of July 2025, the police authority has the inspector, officer in charge Jora Bagan has submitted the report.
The dated 16th August.
By giving the details of the new address of the judgment debtor. Accordingly, this court directed the decree holder to take appropriate steps for issuance of notice upon the judgment debtor at the new address as indicated in the order dated in the report of the officer of the Jora Bagan PS. The judgment the decree holder has sent the notice to the new address of the judgment debtor, but it was returned unserved with the endorsement left. This court find that the judgment debtor is avoiding the notice issued by the decree holder in spite of the direction issued by the police authority. Accordingly, this police authority full stop. This court finds that this is a fit case wherein the warrant can be issued against the judgment debtor for his appearance. The decree holder is directed to file requisites in the department for issuance of warrant against the judgment debtor within a week.
1 week after vacation,
within a week after puja vacation. Full stop. The department is directed to issue warrant upon the judgment debtor. Please the matter on 17th November 2025.
17th November. Great.
Yes. Anything?
Great, Your Lordship. I'm being led by my senior, Mr. Rashid.
Yes, Mr. Datta. Nothing.
Noted.
Yes.
Lordship, please noted.
Yes.
Lordship, item number.
My lord, one matter, my junior was there, my lord, the interim order expired on that day, my lord.
You're not telling my senior myself interim order, you are not able to.
I can, Your Lordship, but there's a precarious circumstances, Your
No,
Lordship.
let him do it, my lord. I'll not say.
Objecting.
Your Lordship, it expired on the day, on Tuesday, Your Lordship, on 23rd of September, Your Lordship. That day it was we could not come to the court. There is a.
Your Lordship, since even though the interim order has expired on 23rd, I leave it up to your Lordship.
Very grateful, my lord, for that.
Counsel for the plaintiff. Which matter? It is
Your Lordship, it's not appearing in the list, but it was supposed to be in the list. Your Lordship.
Counsel for the plaintiff mention the matter. ये देख लेना. Mention the matter and submit that. Though the interim order expired on 23rd of September 2025, but due to inadvertence, the plaintiff could not mention the matter for extension of the interim order. Now the plaintiff prays for extension of the interim order. Counsel for the defendant submit that the interim order expired in 23rd of September 2025 and it should not be extended. At the learned counsel for the parties, this court find that the plaintiff is enjoying the interim order and till 23rd of September 2025, but due to inadvertence, the plaintiff could not mention the matter for extension of the interim order. Considering the above, this court find that till the hearing of that the interim order can be extended till 12th of November 2025 or until further order is reimposed. Extension is reimposed till 12th of November 2025.
May I mention my
12th of November.
Lordship, I'm mentioning regarding the ex gratia money. Your Lordship have mentioned yesterday. Your Lordship, regarding ex gratia about the court liquidated. Your Lordship, may I? It's a very urgent. Your Lordship, because of this. This is not today, not today list. Your Lordship, but can Lordship kindly keep it today at any Lordship time permit, my Lord.
What?
My Lord, regarding ex gratia payment of the casual workers of the court officer, court liquidated. Your Lordship, that when an application was made, my Lord, but Your Lordship was pleased to say that the casual employees should have made an application, Your Lordship, but I have prepared the application will be granted, Your Lordship. But one thing I have indicated, Your Lordship, that the application was filed by them. This was the same application, was similar kind of applications filed by the official liquidator also, Your Lordship. That the assistant court liquidator, Your Lordship, make an application on behalf of the casual employees, Your Lordship, as the application was made before them, before the officer of the court liquidator, Your Lordship. Lordship, kindly keep it at least, Your Lordship, so that I can appraise Your Lordship with the.
How there is no company matter.
Yes, Your Lordship, but
So how
Lordship, yesterday.
the officers
Lordship, kindly, yes, Your Lordship, but kindly keep it tomorrow, Your Lordship.
Tomorrow also my company matter. Company
I know, my Lord, but since if Lordship not allow, my Lord, during festival, Your Lordship, these employees will be suffered, Your Lordship.
This all the things is to be seen prior to that. Why you are sleeping over the matter?
Lordship, this matter was listed in the list, Your Lordship. It was list was because of the fixed matter, my Lord. This is not could have.
Can it be available? The employees grievance can be agitated by the official liquidator or assistant official liquidator.
My Lord, if Your Lordship permits me, Your Lordship, with due respect, Your Lordship, that a similar application was made.
Maybe allowed. The court has not noted that.
Very, Your Lordship, but leave be granted to make an application. My application is ready, Your Lordship. If Your Lordship permits me, leave be file this application.
Why the leave? File it.
My Lord,
Why the leave is required?
My Lord, have to keep it by either today or by tomorrow, Your Lordship, because of this.
Sir,
urgent
how
situation.
you say my determination for only 1 day in the company?
I understand, my Lord, but because of this constant situation, my Lord, of these casual employees, Your Lordship, because during this festival, Your Lordship, kindly Lordship permits me to.
Leave granted. Be listed tomorrow at 10.
बिल तो आपका खाली हम बना के रखे थे.
Your Lordship, one small correction, Your Lordship. This order was not for yesterday. Your Lordship, hereby one date is mentioned as 12 July 2025. It will be just 2021, not 2025.
Come tomorrow at morning. Okay, give.
Your Lordship, paragraph 5. Okay.
Yes. Give. Yes.
Your Lordship, in paragraph 5, it's mentioned
Division
as
bench order dated 12 July 2021. Till the disposal of. Directed to carry out the above 2021.
Yes, Your Lordship. Paragraph 2 also mentions the same date, Your Lordship.
Not counsel for the. You are appearing for whom? Plaintiff.
Yes, Your Lordship.
Counsel for the plaintiff mention the matter for correction in the order dated 23rd September 2025 and submits that in paragraph 5, last second line, the date of the order, year of the order should be read as 2021 instead of 2025. Accordingly, in the order dated 23rd September 2025 at paragraph 5, second last line. The date shall be read as 12th July 2021 instead of 12th July 2025. हाँ क्या हुआ?
My lord, with your lordship's leave, if I may move item number 34 of your lordship's today's list. Lordship, this is my application for execution of an order and judgment passed by your lordship on 4th of September. Lordship, Lordship, the judgment was passed in an application under order.
Once you tell me what is the urgency here now?
Lordship, they had appeared post passing of the judgment. We had written to them for payment of the award of the decree granted by your lordship. Lordship, they have still not paid. If I may seek injunction on their bank account, Lordship, and deductions in terms of disclosure of affidavit of assets.
Copy has not yet been served upon us.
What copy?
The execution.
Why you not serve the copy?
Lordship, the order is of date of 4th of September.
If you will serve the copy, she will pay the amount.
Lordship, we've already intimated them via an email dated 11th September. Yet they have not.
Serve the copy, serve the copy. Yes, anything.
Your Lordship, I am appearing for the plaintiff in item number 48.
Ah.
Says this. Your Lordship, on the last occasion, both the parties have filed their suggested issues, and Your Lordship had directed us to file the affidavit of admission and denial. Your Lordship, the suit was transferred to the commercial division. After that, the defendants had filed their re-verified written statement, and no documents was annexed to it, because of which we couldn't file our affidavit of admission and denial. Your Lordship had also directed us to file the judge's brief of documents, which has already been filed. Your Lordship could kindly frame the issues.
It's a commercial division. Frame the issue now today. Where is the other side? Come after vacation.
Lordship, just one small indulgence.
It will be in the list.
Lordship, just last one small indulgence. If I serve it today, would it be your lordship's pleasure to keep the matter tomorrow? Lordship.
My lord, 1st July, my lord.
1st July.
1st July 2025, my lord.
Huh?
1st July 2025, my lord.
Affirmed.
Yes, my lord, affirmed, my lord.
When you affirmed?
Today, my lord.
My lord, I have a similar prayer in the same matter, my lord. Grateful, my lord.
Within 120 days?
Within 120 days.
Yes,
Yes.
call the list.
Item number 1.
I'm for the respondent number 2, Lordship.
For the petitioner.
Correction.
क्या हुआ?
What correction?
हैं? क्या 11 होगा? 11 September. The matter is listed as to be mentioned for correction in the order dated 11 September 2025. It is found that in the order dated 11 September 2025, the date is inadvertently recorded as 9 September 2025. Accordingly, in the date of the order shall be read as 11 September 2025 instead of 9 September 2025. Okay.
Item number 2.
Item 2 and 4, my lord, are the insurance matters that Mr. Bachawat, my lord, had argued last week. It was, my lord, arguments were made. Only to summarize what the argument was, insurance ombudsman order was there. This was that pension fund, my lord, created where the payouts are to happen after 5 years. The question was, is this digital or non-digital? Insurance ombudsman's order records the submissions of the insurer saying that this is a digital policy. Our prayer was that please make it a digital policy because today you're writing it as non-digital because the premiums are the same, the input, everything is the same. Output in digital is a little extra. There, my lord, they had made their submissions as well, the insurer. Only one question was kept to them by my lord, that is there any bar? Otherwise, I will allow it today. So there, my lord, they were to answer.
Nobody is there.
Nobody is there, my lord.
Okay, pass over. Let us see. Pass over.
2 and 4.
2 and 4 pass over.
Item number 3.
Pass over.
Item number 3. Item number
Fine.
5.
Not today.
Item number 6.
Lord, I am appearing on behalf of the petitioner, my lord. Last occasions, my lord, your lordship was pleased to direct the respondent authorities, my lord, to submit a report.
Yes, nobody is there.
My lord.
Okay, let us pass over. They will
Lord, kindly takes it up after the vacation.
after vacation.
Ma.
Okay, not today.
Item number 7.
I'm for the petition.
You are for the petitioner.
Yes, Your Lordship. The last occasion, Your Lordship would remember respondents had seek time to take instructions on a particular point. Your Lordship, they are nationalized bank, Your Lordship. They are illegally have taken possession of my property. Your Lordship has taken the point of maintainability, to which I said it's a statutory obligation because municipal.
Nobody is there. Other side. Not today. Okay, pass over. If anybody comes, then second call we'll see. Next. Pass over. Huh?
So item number 8, I am the petitioner.
Who is for the other side? New motion.
And new motion, Lordship.
Notice served.
Notice, sir, everything.
Where is your affidavit of service?
Yes. So this is the affidavit.
Matter is the Lordship, the respondent number 7 sold a land to the respondent number 8. My VC land, I filed a preemption case in the trial court. During the preemption case, the respondent 7 filed a title suit against respondent number 8. They compromise, and the degree has been passed on compromise that there is no shell, deed is void, and the.
So what you have prayed for before this court?
This I have made an application. I have represented before the
Delete in the
registration.
nature commanding respondent number 2, delete the deed recording the registered deed.
According to the suit, there is no deed. But what happened? The preemption cases goes. But on the basis of the registered deed and the ROR, they are doing. This is the practice of the contract court. Not only this case, several cases. There is no preemption case in stand. If there is no deed on the basis of the suit between them, then the register should cancel the registration number, everything, and the BLRO should cancel the ROR in the name of the respondent number 8. This is simple prayer. Otherwise, all preemption cases goes in this way.
So what is the prayer?
Prayer Lordship direction upon the registration authority and BLRO to delete their name. Delete the name of the respondent number 8 who has purchased their land.
Who is appearing? You are appearing.
My lord, respondent number 7. My lord, he has no locus stand. I'll tell you, Lordship, why.
Let him complete, my lord. According to my preemption case, I have deposited 22 lakhs. My right has been accrued. But on the basis of their this thing, I have nowhere now. This is the business of my house, the Vastu land.
So you are the owner of the particular property.
No, I am the owner.
My business, that's why preemption case has been filed.
So why how the writ petition is maintainable here?
Yes.
Because Lordship,
if the title is disputed,
my direction. So how then Lordship?
Correct. Whatever it is, if the deed is registered.
Yes.
Registration deed of register can be cancelled by the writ court.
Writ court is not jurisdiction.
Lordship, mandamus because my Lordship
cancelling the deed.
My Lordship, because my right, the preemption case.
Correct. I totally agreed with you, sir.
Then,
but you are agreed with the deed registered by the concerned authority. Correct.
Yes.
If deed is registered, so who can declare the deed as null and void?
Only the civil court, my lord.
You have to prove your right. Yes, you have a right for the property, but without your consent, the concerned authority has registered the deed in connivance with the private party. So you have a right. The deed is null and void. So who will declare the deed as a null and void? Writ court cannot. Whether the court can take your evidence and decide the disputed fact of before this court.
No. I have Lordship. I come to the Lordship, the order and their Solenama. Lordship, kindly page 62.
Solenama before the civil court.
Civil court.
Correct.
What is the Solenama? This is Bengali.
Where is the page?
It is
page number.
Ab initio.
Page number.
Page number, Lordship. Page number start from 62. It is paired portion is 64. Lordship, kindly 64. এই তফসিল দলিলখানি সম্পূর্ণ ভুয়া, void ab initio, সাজসিক, তঞ্জক, ভিত্তিহীন, অধিকার বহির্ভূত.
This is your application.
No. This is the Solenama.
This is a suit.
Sorry.
What has happened to this after this Solenama? Where is the decree?
Degree, Lordship, kindly come. Degree, page 55. Page 55.
Page 55.
Yes, Lordship.
Yes.
Lordship, kindly come. The title should can
be decreed and compromise in terms of the Solenama.
So according to deed, this order, there is no registration deed and there is no BLRO recording must be there.
What is the Solenama? What recorded in the Solenama?
Yes, according to that degree. Lordship, I am giving the Solenama page 62. This is the Solenama page 62. The deed is 62 start and the pair portion is 64.
I can't understand this Bengali language.
Oh, yes, that's why I mean that's according to there these deities they have registered that is woman's void ab initio, and the on the basis of the degree
which deed is ab initio? This which you are challenged before this court now.
is deed which has been registered. That is void ab initio.
Okay.
On the basis of the court has declared that is void ab initio and fraud and everything.
Okay. Then
And
what has happened?
what happened that on the basis of the degree has been passed.
Correct.
But still the registration office, there is number is there. On the basis of the registration, they can sold another person. And they have recorded their name as a mutation in the, before the BLRO, they have mutated on the basis of registered it. On the basis they have mutated. But should it compromise on the basis that is void everything. But still the recording is there. Still on the basis of that recording, BLRO, registration office, they can show they are doing everything. But court has passed an order that is void ab initio. This is the practice of the Contai court. No civil preemption can be stand.
If the civil court has passed an order.
So according to civil court order, lordship registration, there is no registration deed. So register should delete the name. Otherwise they can proceed. Further sale, everything will be go.
Correct.
And on the basis of the registration, BLR has mutated their name. But on the basis of the degree, there is no mutation. So mutation name should be deleted.
Correct.
This is my
You are not a party.
No, how I can? Lordship, I am
may I tell you, Lordship, in the facts, my lord. My lord, the respondent number 7.
I have defeated 20 to that.
The respondent number 7 is the owner of a land. It's an agricultural land. Now, my lord, my learned friend's client, the writ petitioner of your lordship, is the owner of the contiguous land. Now, my lord, the respondent number 7, my client, my lord, sold that land, my land, to my lord, the respondent number 8 by registered deed. Now, my lord, in terms of the Land Reforms Act, my lord, there's a preemption, section 8, my lord. My learned friend's client filed an application for preemption before the civil court on the ground that I am the contiguous owner, so it ought to have been sold to me. So therefore, this should be sold to me, and that it should be cancelled. Now, pending that application, my lord, my client, the 7, and the respondent number 8, they entered into a compromise, my lord, by which, my lord, the deed has now been cancelled by a solenama in a suit filed by the respondent number 7. So, my lord, nothing remains. Now that preemption application also becomes redundant because the sale is no more effective. So therefore, if now I am the owner of the land was recorded in the name of the respondent number 8 post this execution of this deed of sale. Now, whatever is there for corrections, only person who can apply before is the owner of the land. He is nobody because that his application of preemption has become redundant. So he cannot maintain this writ petition, and it's not maintainable at his behest.
What has happened to your preemption application? You have withdrawn or dismissed?
No, now it is pending, but
it is pending. You go and file before.
No.
Yes.
File
if it is
maintainable.
Let him go and fight it.
Saying there is no.
Correct. Your preemption suit is still pending.
No. You missed.
Your preemption suit is only because of the sale deed.
There is no sale deed according to degree.
Now the decree, you file this decree, compromise, file an application enclosing this decree before the landed court, and automatically the order will be passed.
What order will be? Preemption case will be dismissed.
Yes.
If the preemption is dismissed, my right of preemption goes on the basis of the degree. But my preemption goes, but their registration is still remain. Their recording is still even on the basis of the
domain of his application. If it is maintainable, let him file it there.
Before the concerned court. How the writ petition?
Concerned court means preemption court or suit?
Preemption court.
If preemption court I have filed,
yes,
they will show there is compromise degree, there is cancel of the deed. Yes. If deed is cancelled, preemption already goes.
If deed is cancelled, preemption will go. Then you have a right to file a suit. Declaring your title. The writ court cannot declare the title.
Declaring my title, what? So preemption is separate thing. Preemption.
Sir, if the deed is cancelled, in whose name the land will go? In whose name the land will go?
Land will.
If the deed is cancelled,
yes.
Who is the original owner of the property in question?
Now 7.
Different number 7.
7.
It will go back.
But in registration, different number 8 is there.
That is in my domain.
How you have been affected?
I am because my preemption right has been goes on the basis of the.
You go and challenge me before the preemption code.
Here, the
title, the property belongs to respondent number 7. Property belongs to respondent number 7.
earlier.
Earlier.
Now also.
But respondent number 7 and 8 in connivance with both of them entered into a sale deed or conveyance deed, whatever it may be. Conveyance deed. Then in the meantime, the respondent number 7 has filed a suit. In the suit, both have settled the dispute. And as per the settle the dispute, Sulenama has come. No, then they will not going with the deed. Deed may be declared as a null and void. That has been declared as null and void. If the deed is declared as a null and void, who will be the benefited? Respondent number 7 will be benefited. He is the original owner. So the land will go to the in the name of the respondent number 7 only, not in your name.
No, not in my name. But even the name in the respondent number 8. That is my question.
So how you are affected?
Because I have
locus.
Because my right of preemption has goes.
Right of preemption will be decided by the writ court.
No, not decided, but this is the facts. But how I can cancel this? But after
how can he cancel? You want to continue the writ petition? If you want to continue the writ petition, then I will pass appropriate order. Or you want to withdraw the suit and this writ?
No, lordship, pass an order. Because my right has goes. The registration is going on. On the basis of the
file the present application, praying for a direction upon the respondent number 2, 3, and 4, or 2, 3, 4, and 5 to rectify plus delete the deed recording as registered deed number 111206029 in book number 1, volume number 111222023, page at page number 107512 TO2 107526 dated 25th November 2022, registered before the additional district sub registrar Bhupati Nagar on the basis of the Sulenama dated 18th April 2023 and the decree dated 16th May 2023 passed by the learned civil judge, Junior Division, Second Court at Kontai in title suit number 131 of 2023 by deleting the registered deed. By recording the deed of conveyance as cancelled. Counsel for the petitioner submit that the petitioner has filed an application before whom?
Before registration authority and BLRO. The representation lordship page 77.
Before the registering authority. Now with preemption suit, where you filed?
In Kontai.
Which court?
Lordship preemption case page 39.
Well, this is second civil judge, junior division, my lord.
The petition has filed preemption suit under
Section
8 of the WBLR Act 1955 before the
second civil judge, junior division, my lord, Kontai, Purva Medinipur.
Second civil judge, senior junior division, Kontai Court, Purva Medinipur, and the same is pending before the learned court. Counsel for the petitioners submit that as the deed has been cancelled by way of a Sulenama between the respondent number 7 and respondent number 8, but the registering authorities have not recorded the deed as cancelled in terms of the Sulenama, due to which the preemption application filed by the petitioner will be affected. This court find that
representation dated lordship page 77.
This court find that the you have filed the suit earlier. Who has filed the suit? Respondent number 8.
7.
Respondent number. You have filed the suit.
Lordship. Suit
in which the Sulenama was.
Lordship, Sulenama was first.
Suit plainly is page 68.
Yes.
Who has filed that?
My lord, that has been filed by respondent number 7. My client.
The respondent number 7 had filed the suit being titled suit number 131 of 2023 before the learned civil judge, Junior Division, Second Court against the respondent number 8.
Against the respondent number 8.
Against the respondent number 8. for declaration and permanent injunction. For declaration of permanent injunction. During the pendency of the said suit, both respondent number 8 and respondent number 7 and respondent number 8 had entered into a compromise wherein both the parties agreed that the deed to be treated as cancelled. Treated as cancelled. The petitioner has filed the present application for a direction upon the registering authority for deletion and for recording the cancellation of the deed. But this court find that petitioner is neither the recorded owner of the property in question nor the purchaser of the property in question. The petitioner has filed his claim before the concerned authority and before the learned court under section 8 of the WBLR Act 1955. If the petitioner is any grievance with regard to the said landed property, he can take appropriate step before the appropriate forum. The petitioner cannot maintain this writ application for a direction upon the registering authority for recording the deed of registration as cancelled in terms of the Sulenama. This court is of the view that the Sulenama was entered between the respondent number 7 and 8, and the respondent number 7 is the recorded owner of the property, and the petitioner has no right as on date, and there is no record. So thus, as on date, on record, thus this court did not find any merit in the written the present application. According WPA numbers dismissed. It is made clear that the dismissal of the present writ application will not prevent the petitioner to take appropriate step before the appropriate court of law.
My lord, so far as respondent number 7, my lord, I undertake to file my wakalatnama in the department.
The petitioner counsel for the respondent number 7 undertake to file wakalatnama before in the department in course of the day by tomorrow.
By tomorrow.
My lord, item number 3 passed over. My lord, item 2 and 4 passed over. The other side, the advocate is here.
Let's call the first one.
2 and 4. Only before my lord, my learned senior friend was to reply. Lord, arguments were completed. Only one question was put to them. That question is recorded in my lord's last order. Lord, if that order is the order dated 18 September 2025, the second para, my lord, records the question that was put to them. All.
Yes. Oh,
if we may also, my lord, be favored with a copy of what's being.
Of course, of course. My lord, this is the insurance regulatory protection of policyholders, interest operation and allied matters of insurance regulations 2024. My lord.
Yes.
My lord, may kindly take regulation 17 first.
Seven zero.
17, my lord, at page number 23. My lord, first it is in Hindi and thereafter page number 23.
17.
70.
Yes.
Refund of premium.
Yes.
In the event of any refund of premium becomes due on account of policy cancellation or alteration of any terms and conditions. My lord, this is very important. Of the contract of insurance or otherwise, such refund shall be made only to the bank account of the policyholder, such and such. Now, my lord, may quickly take up regulation 20, which is running page 24, my lord.
Yes.
My lord, pre-look period of life and health policy. My lord, sub regulation 323. In the event a policy holder disagrees to any of the policy terms or conditions or otherwise and has not made any claim, this is in respect of a life claim in respect of the policy.
Yes.
He shall have the option to return the policy to the insurer for cancellation, stating the reasons for the same. Admitted position. Policy was sourced
to respondent number 4, which is the broking channel in non-digital mode. But firstly, I'll clear the confusion regarding the non-digital and digital sourcing. But 5th April policy received. Look, this is an admitted fact. They are not going to deny. 5th April.
Which year? 30th April, which year?
2023.
Yes.
Policy received.
Yes.
30-day pre-look period commences from the date of receipt of the policy. So till 5th of May or 4th of May, the pre-look period exists. In the event, the
4th of May, 30th April, so 30 days.
5th April, they have received it. For 30 days, it would be 4th of May.
No, the policy, when the policy has taken purchased.
My lord, the pre-look period starts from receipt of the policy.
Correct.
On 30th March 2023.
30th March, that's what I'm telling. 30th March 2023, they purchased the policy.
Issuance date.
Yes.
Receipt date of the policy is 5th April 2023.
Okay.
My lord, so the free look cancellation period commences from 5th April 2023 till 4th of May 2023. My lord, no demur raised regarding the terms and conditions of the policy. In the event there was any kind of variance of the agreed terms and conditions as per the policy brochure or any kind of representation by the broking channel, if the issue was raised during the free look period, the policy would have been cancelled and the entire premium refunded without any deductions. My lord. Now, my lord, the request comes in that we have browsed through your digital website and we have found that there is a digital mode of procuring a policy. My lord, that is the sales illustration which was placed on the earlier occasion by my learned senior friend. My lord, I like to place. This is on today's date. It's the same policy which is available on the website, and I will also again come back to the rules regarding.
Lord, if I can get a copy, my lord, of what was handed over.
My lord, regarding regulation 8 of the earlier regulations that was handed over, protection of policy holders' interests.
Yes.
My lord, may kindly see. Every insurer should ensure that the products are being offered for sale. Those are written or published prominently on its website along with benefits, features, applicable terms and conditions, premium prospectus, benefit illustration as applicable and shall update regularly. Now, my lord, I have just one copy of it. I'll provide. My lord, they have, if my lord recollects, I'll just quickly take sales illustration. My lord, page number 182 of the writ petition.
Yes.
My lord, they are.
You mean to say there is no difference, either digital or the manual?
Manual policies, certain broking channels or channel partners are given certain privileges regarding the sourcing of the policy. If it is done through a digital sourcing method or through a digital sourcing channel partner, then it is considered to be a digitally sourced policy, not a digital policy. There is nothing as such in the IRDA regulations which
That's why I ask for you.
even which my learned friend can show that there is something called a digital policy and a non-digital policy.
So why you have not taken this stand before the officer?
My lord, first and foremost, regarding this present writ petition of the petitioner Shalin Khemani, my lord, the inception of the complaint was rejected on the ground of pecuniary jurisdiction of the ombudsman to even entertain the complaint. My lord, the award which is annexed is of the writ petitioner in item number 4, which is Bhavna Kewal. Well, that is not under challenge, because if there is no inherent pecuniary jurisdiction to entertain, no award has been passed and nothing has been challenged before this court. The short issue which comes down is that, my lord, on the current date or even on the date on which the request was made and thereafter it is being considered today, the insured has already been risk covered for 2 years and they have paid premiums as well. Where they are trying to draw a comparison as per
That's why I'm asking whether there is any difference between this the online which they are telling and
that is what I've placed the policy brochure. May kindly take up. Let me kindly take up the benefit, which is at running page number 7.
Which one? This one?
The policy brochure for the Tata AIA Fortune Guarantee Plus policy. Page number 7 and 8, it's sort of in a form of a booklet. That is the reason they have got consequent page numbering on the same page.
Yes.
This is the sample illustration, or rather the illustration which they are placing reliance on. It cannot go beyond the policy document, which is advertised on the website, also made available to them through their proposal form and the policy. My lord, I have not found a single shred of any kind of regulation where this policy can be treated as a digital policy or sourced through it. My lord, very surprisingly, when I have sought instructions from the company, that the calculation which is provided at page number 182, which they have been referring, my lord, kindly take it up for one moment. My lord, the annualized premium paid in 5 years. My lord, page number 182 of the writ petition, annualized premium paid in 5 years.
Yes.
My lord, now, my lord is very well aware that most of the life insurance policies, on the basis of the policy brochure, depending on the age, the risk coverage, it is calculated by an actuary or an underwriter of the company. My lord, the policy paying term for the petitioner's policy is 7 years. Then how is this SIS even binding on the policy of the...
Not binding. They have comprising that only with regard to if the digital is there, the amount will be higher. If it's non-digital, it is not, the amount would be less. Kindly come to the 182, the first. Digital, yes. 182, digital, yes. Correct. And the amount shows 5 years, no problem. Amount shows 7 crore 62 lakhs 43,724.
Correct, my lord.
Correct. Now the second part. Digital, no.
Correct, my lord.
Digital, no. Then 7 crore 38 lakhs 43,800.
My lord, this is what I am getting at. How they are in possession of this document, because this calculation cannot be made public, because this is the underwriting that goes at the back end of the company.
No, that's
when they are
whether they have received or not received. That's why the court is asking you whether there is any benefit in the digital policy or the same benefit.
My lord, same benefit. There is nothing called a digital policy. My lord,
I appreciate nothing called a digital policy. Okay,
my lord, from 2024.
So why this has come? Why
EIS, EIS. Suppose there are policy holders having policy, a life insurance policy. They have few life insurance policies. Then they want to get it digitized. Digitization happens through a electronic insurance repository. They hand over the physical document, it is scanned, and in a DMAT format, as an insurance repository, it is stored with a account username password to access the policy as and when possible. Now, when it comes to the digital sourcing bit of it, it is entirely on the broking partner how and where they are going to underwrite through their leverage of commission from the company. It is not the company that is advertising whether there is any kind of digital or non-digital. Again, digital and non-digital is merely a sourcing channel platform.
Correct.
That does not mean that a policy, in effect,
Okay, in
digital,
that case,
non-digital cannot be
so in that case,
converted.
okay, we file an affidavit.
We'll file an affidavit. We'll file an
Because-
affidavit regarding the present policy in question, and whatever was advertised or is still advertised, because the practical difficulty on the current date, if it cannot be retrospectively taken back to 30th.
I appreciate. It has to be changed, then it has to be taken on, and
It has to be
I
cancelled.
appreciate
And
that.
if there is an existing similar policy on the present date, that can be availed by the petitioner. My lord, it is not as if that earlier policy can be converted as per their submission into a digital.
Then again the question arose.
My lord,
If-
let us file a
Then again the question arose. Suppose myself and you purchase a similar policy of the 5-year terms, and the yearly or quarterly, whatever the amount is to be paid, that are similarly. Whether you can say no, this is with regard to the what we call digital brokerage, and he will get the higher rate, and you are from the manual brokerage and directly, and he will get the less.
My lord, that is not upon the company, which is basically.
Why the company is paying the amount?
My lord, the company is paying the amount, but this higher differential is nowhere mentioned in any policy brochure. I am highly contesting the sales illustration which has been placed, my lord. But there is no authentication whether this is what has been advertised or how it has been calculated.
So if it is not whether okay, you file a affidavit disclosing
We
that.
file a detailed affidavit.
May I, my lord, only 20 seconds what we'd shown on the last date, my lord, and why affidavit was not called for on the last date, because
Correct,
it's not
correct.
required. It's, my lord, a policy where a person has to put in the premium for 5 years or 7 years. Thereafter, the policy will start giving returns.
Benefit, yes.
The premium to be paid by the both petitioners is identically the same, whether you pay it in the non-digital policy or the digital policy.
Correct.
The tenure is also the same. But in case of payout, the difference is there. That was, my lord, what we had shown. Now, when we had gone to the ombudsman first, my lord, they did not allow lawyers to be present, even though the law requires it. So the lady herself was there doing it. He was asked, please show proof that the returns are different. The same question that your lordship put today. There, my lord, so the hearing ended. Email was given saying that I went to your app and I'm taking out the screenshot from your app and giving it. Thereafter, my lord, the orders passed. 2 paragraphs of the order were shown to your lordship. First, my lord, is the submissions of the insurer. So this was their submissions before the ombudsman. They say there are 2 ways of taking a policy. The first way is if you do by manual signature, which is non-digital. Second way is if you do by OTP method, then that's digital. Next paragraph, this policy was taken by OTP method. So they acknowledge that this is otherwise a digital policy. Then the finding that's recorded without considering this aspect is that the respondent was asked to reply to the screenshot and they have doubted the veracity of it, their own app screenshot. So therefore, I am not allowing it. There, my lord, will come and show your lordship. Respondent was not asked in my presence. So behind my back, something's been asked for. Now, that happened in the case of the wife, who's the petitioner in item number 4. So the husband also, thereafter, the husband gets a notice, you give your consent and you participate. So the husband comes up saying, violation of law because lawyer is not allowed, violation of law because you've done something behind my back, natural justice. And your order itself, your submission itself shows that my policy is a digital policy. Then where's the problem in recognizing it as such? Yes. So there, the submission was made by the other side that we cannot, that there is a bar. So your lordship asked, what is the bar? Show me. That's the only question that was kept for today. The bar that they have come up before your lordship is 2 things that they show in the law. If I have to refund money after cancellation, then I have to do it. That law doesn't, that's not a bar. The second thing that was shown to your lordship is a freehold that cancellation period. In the event of cancellation or otherwise, then they will be so on and so forth. I'm not asking for cancellation. Their submission in the ombudsman order recognizes that my policy is a digital policy. All I'm asking is recognition of that fact. That's their admission. I'm going on the basis of their admission. Today, once an admission is made before a judicial authority, that cannot be taken back today on the basis of oral submissions at the bar.
Yes.
This is their submission in their order. My lord will find that at page 184 of the first petition.
Yes.
This is the ombudsman's order. My lord will find at the bottom contention of the respondent. My lord
Yes,
has
yes, I have
184.
noted
That para 3 and para 4. This is their submission. I'm going on the basis of their admission that they recognize that I'm a digital policy. All I'm asking for today is recognition of that fact. That's all. They don't come before your lordship and say that no, the person who made the submission was not authorized. That's not their submission. Once they've made that admission, all I'm seeking is recognition of that fact.
Yes.
That's the limited point in the matter.
My lord, can we refer to the
And
submissions
today-
that were recorded? My lord, I think there is a misinterpretation of whatever has been submitted, my lord. My lord, if my lord reads to application provided by insurance company and policy application sales illustration was authenticated on the basis of OTP received in the insured mobile's number. My lord, for any policy, that is the mode of verification.
Please see para 4 and 3 and 4. Read para, if
My
my lord will read
lord,
para 3 and 4
let me
together.
complete, you'll get it, sir. Please.
Please.
Policy was authenticated on the basis of OTP and no manual signature was opted by the customer.
Yes.
Well, thereafter, we would like to inform you that as per our firm, digital stands as online method of enrolling policies with the help of OTP.
That's exactly.
My lord, this is what? This is the
And?
EIS, the electronic repository where the verification is done through the OTP mode. This is not a digital policy by any chance. This is the
That's
mode
exactly
and-
what they've said.
But you have not taken that plea.
That's exactly what they've said.
Where you have taken the plea, there is no digital,
Finish
there
the
is no
sentence.
only
My
manual.
learned friend will finish the sentence.
But kindly come to the order, kindly come to the observation and conclusion, kindly come to 185. Where is your submission? What you are making the
My lord,
submission here?
My lord, may I kindly read further? As per the record of the insurance company, the complainant insured opt for e-insurance account and insured link to receive her insurance policy, all other information related to the policy through Tata AA in electronic format. Whether it's a digital policy, digital is a mode of sourcing the policy.
Where you
Which
got
has-
that sourcing the policy?
We'll see para
Digital
3 and
means-
4. He says you can either do it by OTP or by manual. He says you've done it by OTP. And this is their submission. They can't run away from their submission. This is their submission.
Now, my lord, may kindly take their policy which is annexed, my lord. My lord, page 30. My lord, page 38. Proposal form.
Yes.
My lord, kindly take up the third paragraph which deals with electronic insurance account, EIA.
Where, yes.
If you have an e-insurance account number, please provide. You have to consent whether you want to receive my insurance policy and all information related to the proposed insurance policy in electronic format. Physical copy would be sent even if proposer opts for electronic format. Look, so where is the question? Is the same policy which is to be stored in an electronic repository.
That is not the here only the question. Only the question. What is the how the difference amount will be there?
My lord,
That is not.
my
If
lord,
you
that
say that there is no difference, let
Exactly. Let that be
That you
recorded.
say,
then.
if
Let
you
that
say,
be.
that's why I'm asking you.
If
If
they
you say there is no difference either electronic or media or manual, there is no difference of the amount of the bank.
I should be entitled to the higher one if there is
illustration which we are saying that this is not authentic. Is it supported by affidavit?
Yes, it affidavit.
My lord, electronic affidavit. 65
That's exactly it.
Does it entail? It has been downloaded. It can be downloaded from any random.
Let him.
So
Is it his case that his app?
So
is
it is not your app.
It is
It
not
is
your
not your app.
My lord, how is it? My lord, kindly see where it has been downloaded from. Kindly see, my lord. Kindly see.
It is attached with my mail, of course, because I have to take the app. I can't send them my phone. They asked for it. The ombudsman asked for it.
The screenshot from the app itself.
This is
I
the
can do
screenshot.
several number of things. I can cut,
there's
copy,
very-
paste two different things and change it up.
That's why I'm asking, sir. A specific question is.
There is no difference, my lord.
There is no difference.
Let me get the higher. Let me get the higher. That's it. He'll not be agreed
no
because the
difference.
payout
There
is the
no
same.
difference, my
There
lord.
is no difference.
There is no difference.
Perfect.
So how this
My lord, if there was a separate maturity benefit, the brochure would have said otherwise. My lord, may kindly take up the brochure which I have.
My lord, we'll record this submission. My lord, there's no
Go
difference.
through. I will go through. So 182 you are disputing. This is not a correct document.
My lord,
Correct.
absolutely.
You are disputing, and you are telling that the either by the online or digital way or without the digital way, the insurance policy, as per the policy, it will be the same
My lord,
Payout.
same benefit will be
Same
get.
payout.
it is my humble submission that let it come on affidavit from
What?
the company, because this is very technical, my lord.
Eh.
This is very technical.
They've said 5 times there's no return. Let
because-
that submission be
That's why
recorded.
Because
Let
my
that
lord,
submission be recorded. Today they've said it 5 times in the last
My
15
lord,
minutes.
my lord, I need to put it on affidavit through a competent person of the company
What?
to bring it on record. It is not my call.
What?
My lord,
But then he
regardless-
shouldn't make these submissions in the first place that the returns are not different.
My lord, that is what returns are not different can depend upon several factors when issuing a policy, my lord.
Which is?
So
That's
where
not
is
their
the answer
allegation,
to my
no.
question on the last order?
My lord, the last order, if
Where
there
is the answer to my question?
if there is a difference, my lord, let us assume, my lord, what has fallen from my lord is, show me how can it be converted from non-digital to digital.
No, is there a bar
No,
for
is there a
conversion?
bar? Only
That's not the
question
question.
is
Is there a bar
Let
for
them
conversion?
show a regulation under IRDA which says that how a non-digital policy is defined or a digital policy is defined. IRDA is the umbrella organization of all insurance policies in India.
so if it is so why you have contested before the ombudsman and stating that it is not
Not
that
contested for one of the complaints.
This is not fair.
Kindly
This
see-
is really not fair.
kindly see your response to before the ombudsman. Kindly come to the paragraph 3 and 4.
Para 3 and 4. This is not fair.
This is not your case. It is not. There is no digital. There is no manual. Only one procedure is
not his
there. Where
case.
is that?
My lord,
Kindly see that.
Submissions at bar may not.
So I am
not
setting
be on
aside. I am
record.
sending again.
But
Recording of
again, we'll
submission.
go, my lord. Again, the same problem will happen. That is why, my lord, which shown on the last date, my lord, it has to be done.
my lord, let it be reverted back. Let it be considered.
That's exactly what they want.
I
Now,
am
my lord, for
recording your
10 years.
submission. There is no manual. There is no digital. Only one way of the insurance policy, and there is no digital. There is no manual, and the benefit will be the same, either the digital way or the
If
manual.
it's recorded that
Again,
the
I said
benefit is the
no
same.
digital policy. in the
That's why
first
I
place.
record. I will record. You have made the contrary
5
submission
times.
again before this court.
My lord, there
Then
is
the submission.
there is no contrary submission. My lord,
Kindly
kindly
see-
take up the submission. What they
Kindly
say.
see the paragraph 3 and 4.
If it goes back over there, my lord, this will be the 4th time I'll be going back over there.
My
And
lord,
this
see
is
the 3 and
exactly
4.
what they want me to do.
My lord, my lord.
Well,
We would
pension
like-
fund for my pension, I have to keep running. like
Paragraph
this.
number 4, my
Ah.
lord. We would like to inform you that as per our form, digital stands as online method of enrolling policies with the help of OTP.
Correct.
Correct. And sent on your mobile number, and non-digital stand as offline method of enrolling policies with the help of manual signature. So this is
And in 3 he said, he's done it by OTP.
this is the same
And no manual signature.
my lord, my lord.
Hmm.
My lord,
So that's the admission.
This is where we are going amiss, my lord. My lord, the manual policy or the physical policy,
Hmm.
when the verification happens, this is what the stand of the company is, that the digital verification of the policy.
Hmm.
It is not a issuance of a digital policy.
Hmm.
My lord, I have I have shown, my lord, from the proposal form itself that in order to digitize.
Okay, you do one thing. You do one thing. I am keeping on after vacation. You give the return notes. Your submission, I will dispose.
My lord, can we file an affidavit? Leave
No, not affidavit.
May
You
it be
give the
made
return
part
notes.
then, my lord.
You give the return notes. I will dispose of. You give the return notes because you are telling that sometime you are changing your stand. You file the return notes. I will take on.
My lord, it is not that we are changing the stand. It is being misinterpreted.
5 times. My lord asked him 5 times.
You
Every time wrong answer.
It can come 10 times also.
By
it
an
does
order
not change.
dated 18th of September 2025, this court has directed the learned advocate appearing for the insurance respondent number 3 to inform this court whether the manual policy can be converted to the digital policy. Full stop. Today, when the matter is taken up for hearing, the learned advocate appearing for the insurance respondent number 3 has relied upon the regulation in insurance regulatory and development of regulation, namely Insurance Regulatory and Development Authority of India within bracket protection of policyholder, interests, operations and allied matters of insurer bracket close regulation 2024, and submits and has relied upon the regulation 17 within bracket 1 and 20 within bracket 3. Full stop. This court has categorically put the question to the learned advocate appearing for the respondent number 3 whether there is any difference with regard to the manual or digital insurance policy. He submits that there is no policy, namely manual or digitally. He further submits that there is no difference
With regard to payout
under the payout of the amount either the digitally or manually.
This is not what I am
Manually.
submitting, but this has to be technically verified.
Full stop. Counsel for the petitioner,
Lord,
respondent number
let it
3.
be called for affidavits for this
Counsel for
technical
the
verification.
respondent
It is not in my state.
submit that this is submit that he may be allowed to file the affidavit in opposition. This court find that the matter has been heard at length, thus, and when the matter is taken up for hearing, the learned counsel for the respondent number 3 has not prayed for any direction for the affidavit in opposition. When the final hearing has been taken up for hearing, learned counsel for the respondent number 3 prays for time to file affidavit in opposition. This court declined to grant time to file affidavit in opposition, but given liberty to file the written notes of argument.
And also, my lord, that the fact that my submission is based on their admission in the
notes of argument on 29th, no, 29th. On 6th of November 2025. List the matter on 6th of November 2025 as part heard matter.
Grateful.
For filing written notes
They
of
had handed
argument.
over something today, my lord.
Filing written notes of argument by the parties.
If I may have a copy of what was handed over today.
Give the copy.
I'm great.
Item number 3.
My lord, this is that mentally ill person.
Have got the report?
Yes.
What is the report?
Report says that the selection of non-official because the members of the mental health is not available, my lord. We are making an attempt from the fathers, my lord.
So who will be responsible for this type of the patient?
My lord, the mental my lord, a board can be created in the my lord Arjikor hospital, my lord.
No member has been appointed.
No, in the Arjikor hospital there is a my lord department of
12 September. The 12 September order.
Yes.
As per the recommendation, so and so, so and so.
Because the members of the medical experts is not available. But medical expert available in Milord Arjikor Hospital, Milord, where the petitioner is being treated.
This is a chairperson.
Yes, my lord.
Recommendation chairperson West Bengal principal so consequent order of registration.
Next page, my lord, there's details is there.
Following health board has been constituted. Where is the board constituting of? Where is the name?
On the next page, one
District judge is the chairperson.
Yes.
Where is the members?
Recommendation of the chairperson, West Bengal State Mental Health Authority, the principal secretary, Department of Health and Family Services, is consequential orders of the Registrar General High Court
the Calcutta, my lord, the following mental health boards and
So who will sir, kindly come to the third column. Official members.
official members, the
Each
district magistrate and
from each district. District magistrate or his representative, no problem. And who will give the name of the representative, district magistrate? Then one psychiatrist, who will give the name of the psychiatrist? Then one medical officer, who will give the name of the medical officer? Can the district judge will go to the hospital and ask the name?
the comment is the duty of
Then,
the government, my lord, but
if the notification is there, it should be by name or by post.
we advertise an phrase, my lord. Kindly see that the selection
Milord,
of
it
the
will
non-official
take
members
much more
in
time,
most
but
districts
it
incomplete
can be
in
made
spite of
shorter,
repeated,
Milord.
in
If the
spite of repeated advertisement, my lord, the further extension of
Sir, what is the one thing is you, as per your notification, district magistrate, there is no notification. Every district is having the district magistrate. If the district magistrate is not in a position to appear in the meeting, his additional district magistrate would be there, or subdivision magistrate will be there. He can nominate. Now, second, psychiatrist. In your hospitals, the psychiatrists are available. One psychiatrist can be nominated. Why you are calling for the notify this notice has been issued for the publication?
Keep it in after vacation. I'll try.
What after what will do this
Because in the meantime,
child and not child with this
Lordship, kindly,
lunatic person?
I also appreciate my lord's agony and also the pain of the.
I am directing. Who is the authority?
Milord, my humble prayer is that, Milord, kindly come to the annexure P1. The
You are annexer.
Yes. That the member department of annexure P1 at page 11.
The municipality. AMC.
This is, Milord, this is disability has been recommended by the Arjikor Medical College and Hospital, Milord. If there is a board can be constituted in that hospital, Milord, directing the medical superintendent and vice principal of the hospital, MSVP.
What is your prayer?
Prayer is this, Milord, the mother is required to be appointed guardian for the lunatic person.
Taken care of this and the something is
It's completed a majority of district officer members.
custody of.
In which district you are coming under?
Yes.
In which district you are?
I'm in the Kolkata area, Milord.
Alipurdwar, Kuch Bihar.
No.
My lord.
Where is that?
I was treated in
Seven, my lord. Clause 7, my lord.
Clause 7.
KMC.
KMC area and the hook.
You are in KMC. The
Yes.
chief judge is already there.
Chief judge
Chief judge is already there. So this KMC, then SSKM hospital, there will be the.
Yes, SSKM hospital will be there.
So there will be a psychiatrist.
Yes.
And medical officer.
Everybody will be there.
My
Milord,
keep
best
it in after
option is
vacation,
there.
my lord.
No, why?
Yes.
Year মধ্যে ছুটির মধ্যে ট্রিটমেন্টটা হয়ে যাবে না? Milord, there is a Milord beside the SSKM, Milord, there is a mental hospital which is IOP, Institute of Psychiatry, Milord.
It is there.
Yes, Institute of Psychiatry, DLR Road, Milord. This is a Milord, this is the Milord, the Institute of Excellence in the Psychiatry.
A medical officer from
time,
any
my lord,
government,
because
and
notifications.
which is the nearest medical of your house?
This is
Which is the nearest
this is
hospital?
Arjikor.
Arjikar. Based
Arjikor.
on other medical.
Milord, IOP will be not far off.
Now it is there now. One medical officer from the government hospital in the district.
He is residing at 22 by E Lockgate Road, Kolkata 2.
So that is SSK.
And
Both. May I come on after vacation, my lord? Today.
both hospital will be near from there and from here.
My lord, may I come on reopening at the rate of reopening?
What is your instruction?
The instruction is, my lord.
Instruction is as simple as that the mental health review board has not been yet constituted.
It will take some more time.
It will take some more time at the cost of the patient.
Regarding
And
the
my
patient
prayer-
concern, my lord, regarding clause 7, the KMCs and areas, my lord, I'll come and.
Why advertisement? Kindly come to your letter.
Yes, ma'am.
The selection of non-official
That
members.
is being taken up. We're again and again the other process of the public.
Non-official members? Oh, why the non-official members?
Non-official members is the Milord, those who are the Milord, the expert. That is the Milord psychiatrist.
That you already nominated. Only the person is to be identified.
Yes.
Psychiatrist has already been nominated, but you have to only the person is to be
There,
notified.
because those mental health review board ordinarily sits in the Saturday
and they can very well constitute the mental health review board.
I'll kindly keep it.
And my lord, this is prima facie. There is a disability certificate issued by the Arjikor Medical College and Hospital. It can be even, my lord.
What is your disability?
That is, my lord, at annexure page 1, 75% disability.
Page 1.
Page annexure P1, page 11.
What is the disability?
Intellectual disorder.
Intellectual disability, ma'am.
Disabilities.
Yes,
Yes.
ma'am. Intellectual disability.
He cannot express herself.
That will be treated as an
In terms of the order passed by this court dated 18th September 2025, the learned advocate appearing for, you are appearing for? State of West Bengal has handed over the communication dated 3rd September 2025 issued by the OSD and EO, Senior Special Secretary, Department of Health and Family Welfare, Government of West Bengal, along with the order dated 22nd of September 2025. Learned Counsel appearing for the State of the West Bengal submits that the selection of non-members of MHRBs in most of the districts is incomplete, and the state is taking appropriate steps for constitution of the board. This court find that by an order dated 22nd of September 2025, as per the recommendation of the chairman of the West Bengal State Mental Health Authority, mental health review boards have been constituted at the district level. Consist of district judge of the concerned district, district magistrate or his/her representative, one psychiatrist from any government hospital in the district within bracket as nominated, and one medical officer from any government hospital in the district as nominated. This court failed to appreciate that though the district judge of the districts have been appointed as a chairperson of the MHRBs, and the government has identified the officials who will be the official members of the said committee, but only the person has to be identified. But till date, the state government failed to identify the persons who will be the members of the MHRBs committee. Board, sorry. In view of the above, the principal secretary,
my lord,
the principal secretary of health and
last rider of this
family welfare.
next page, my lord, till the selection of the non-official members.
Correct.
Yes, ma'am.
Health secretary of the which Department of Health and Family Welfare, Government of West Bengal is directed to named to identify the district magistrate or his nominee or his/her nominate, any of the psychiatrists from government hospital in the district, and one of the medical officer from the government hospital in the district for constitution of the MRBs in the state, in the district level, within a period of 4 weeks from the date of receipt of this order.
Specifically, my
this
lord,
order is passed.
My lord, in the meanwhile, my lord, petitioner mental illness can be reviewed by the Institute of Psychiatry or Arjikor.
This order is passed taking into consideration of the disability of the petitioner, not disability of the
this is the, my lord, daughter of
the patient.
Daughter of the petitioner.
Disability of the patient who is the daughter of the petitioner.
Number one.
Suffering from intellectual disabilities of 75%.
Yes.
75%. Full stop. Let the matter appear before this court on 6th of November 2025.
Meanwhile, the particular particular patient can be further reassessed in the mental hospital.
Unless and until the board is not constituted.
If this board will be going to be constituted, but
the board he has to place before the board that all the problems will be solved.
But it is not being constituted, it is not yet.
That's why you pass an order to identify.
Yes, Your Lordship.
Identify what purpose? Every district having a district magistrate or the representative.
Yes.
And psychiatrist can choose any person. And the medical officer, there are so many medical officers. Let them identify the name.
Grateful,
and send to the chairperson.
6th November, it will be for further consideration.
Grateful, man.
For the petition, Your Lordship, I had
Yes.
the last occasion, my learned friend had seek time to take instructions, Your Lordship. Lordship would come to page 40.
What is the prayer?
I'll indicate, Your Lordship. There was a lease agreement between me and my learned friend from 2011 to 2021. Between this time, bank was operating in that, commercially operating in that area. Thereafter, from 2021, there was no lease agreement. However, page 40, Your Lordship, there's an admission on part of my 40. There's an admission on page 40 by the bank, Your Lordship, for renewal of terms of lease. They have only stated these, that the rate will be increased. My prayer would be the bank is now illegally occupying the premises from 2021 till now. So either bank will execute the lease agreement or bank will, this is just an observation.
Can it be repetition?
Your Lordship, I have satisfied the
Can
point.
the writ court have taken the jurisdiction of the original civil jurisdiction?
I'll indicate, Your Lordship. Last occasion also I satisfied, Your Lordship. Firstly, the bank has been illegally occupying the premises. Thereafter, municipal taxes I have been paying, Your Lordship. Lordship would come to...
Naturally, you are the owner. You have to pay. Otherwise, you will be difficulty.
Yes, Your Lordship. The municipal taxes I am paying, although there is an illegal occupation.
Go file a suit and recover from him.
Your Lordship, just an observation. Just an observation. To that extent that there was a lease agreement, the lease agreement expired.
What do you want?
Page 40, Your Lordship. I just want bank to either agree to this or else an observation to be made that the bank is illegally occupying the premises. Just that, to that extent, Your Lordship. I had satisfied the last occasion on the point of maintainability. Just an observation to that extent.
Yes.
I only have the point of maintainability for the present.
My learned friend has
absolutely a contractual dispute.
Yes, I agree on that point, Your Lordship. On the last occasion, my learned friend has seek time to take instructions on this particular point. That whether
the bank says they will not interested to come with the agreement.
No, the bank is looking for an alternative accommodation. As soon as it is available, they will shift. But that is neither here nor there. But if my learned friend's clients is advised to proceed against us, bank will take steps. And even they are at liberty to approach us or proceed against us for recovery of
after approaching
but how the writ court can, if they are agreed, that's why on the last occasion, if they are agreed, then the court can pass an order.
That is it, Your Lordship. That is
but
only
they're not agreeing that.
That is what the observation can be, Your Lordship.
No observation. How the observation can be? I am dismissing with the liberty to take appropriate step before the
and an observation, Lordship, that there was an existence of a lease agreement and bank has for
that is agreement.
Agreement.
It starts from
page 11.
11.
Yes. Registered.
11 August 2011.
Yes.
For till
10 years. For a period of 10 years.
2021.
Yes.
Then it is over.
Yes. Since then, bank has been illegally occupying the property, and I am paying the municipal taxes. The responsibility on me. I have earlier approached this writ court on the point of taxes, Your Lordship. And the writ court has directed the municipal corporation to calculate the amount of taxes that has to be paid by me. So I have approached them ki either you execute another lease agreement, either you renew the lease agreement, or else you leave the property. I have issued a notice. The notice is
39.
Yes,
39.
And at page 41, Your Lordship. Your Lordship would see at page 41, I have indicated
that 1, 2, 3 clauses as per West Bengal Municipal Act, Section 148, the property tax shall be levied in equal shares upon the owner and the occupier. That is a predicament I'm facing right now. Since they are illegally occupying and the responsibility is on me to pay it. Though as per this act, both we have to share it proportionately.
That's correct. That's correct. As per the agreement, he has to pay his own.
Yes, yes.
But,
yes.
But
but
the
he's not
problem
paying.
has cropped up because of this page 40, where we have indicated that these are the terms which we agree to. Now they are not agreeable to.
We are agreeable.
No,
We are.
This time you are agreeable.
Then
Page
let
40,
them.
I have already conveyed my yes to
No,
the
they
lordship.
say that apart from this, we have to bear the municipal taxes and other charges.
So my learned friend is not agreeable to that. That only an observation can be made.
The petitioner has filed the present writ application, praying for a direction upon the respondent bank to pay the petitioner and pay the monthly rent of the tenanted premises. Full stop. As per the case of the petitioner, on 11th of August 2011, a deed of lease was entered between the plaintiff and the defendant, wherein the plaintiff has let out the premises to the bank for 10 years. The 10 years have been completed, but the defendant bank has neither vacated the premises nor has come forward for extension of the lease agreement. Full stop. On several requests made by the petitioner, the bank has informed with regard to renewal of terms of the lease of the premises in question. But the plaintiff is not ready for you're not ready for this amount.
At page 40, I'm agreeable.
You're ready?
Yes.
So why you're not executed?
Your lordship, they are not executing.
They have
That's the
given,
instructions.
Given this.
Kya bola? Bank has given in premises in question on the following terms. This, page 40. Full stop. Counsel for the petitioner submitted the petition is ready with the terms, but the bank is not ready to pay the municipal taxes, and that's all.
That's all.
Municipal taxes, due to which the agreement could not be finalized. Full stop. They submitted that the defendant, the respondent bank is neither paying the rent nor paying the municipal taxes, due to which the petitioner is facing difficulties and the petitioner had to pay the total municipal taxes with respect of the premises in question. The net counsel appearing for the bank has raised the point of maintainability and submit that in the writ court the disputed question cannot be decided. He submit that the bank has given the proposal to the petitioner, but the petitioner has not come forward for execution of the agreement. Consider the submission made by the counsel for the respective parties. This could find that the only grievance of the petitioner before this court that the bank has not come forward for execution of the agreement and also not paying the rent as well as the municipal taxes. This court is of the view, by sitting in the writ jurisdiction, the court cannot decide with regard to the dispute between the landlord and tenant. Accordingly, this court dismiss the writ application. However, the dismissal of the writ application will not prevent the petitioner for taking appropriate step before the appropriate forum. That's all.
Item number 9.
My lord, item number 9, I appear on behalf of the petitioner, my lord. My lord, the service has not yet been completed. Therefore, my lord may kindly be pleased to keep the matter after the vacation.
Not today.
Grateful.
Item number 10, I appear
Yes.
for the state.
Who is for the petitioner?
By flux of time, when the matter has become infructuous.
That's why he is not
Parties-
appearing.
No, non-appearing. Now, kindly see the blood, it didn't yourself.
What is the prayer?
Prayer blood for taking permission of puja in the month of April 2025. The report was, my lord, given
Grant
on
permission performing Ram Navami Puja
Ram Navami Puja. That is puja also.
of 2025.
No, 2025, 6th April, my lord, it has become infructuous. And let kindly see our report also. We have no objection. We have given the permission, everything.
Whether they have performed the Ram Navami
Lord,
or
I do
not.
not know, Lord, but
When you obtain this report,
our
4
report,
after that.
4th of April 2025. Both the parties choose their land to perform the worship of Sri Lord Ram on occasion of Ram Navami and also submitted their written representations. Annexure A4. It is pertinent to mention here that in no way the petitioner is restrained to perform their religious activities arbitrarily, whimsically, unreasonably.
When the Ram Navami was there?
In the month of April, the first page, 5th April and 6th April, at the same place. Kindly take the report note on record.
Yes, I am taking. The none appears on behalf of the petitioner. Learned counsel appearing for the state has filed the report. Let the same be kept with the record. The petitioner in the present writ application prayed for a direction upon the respondent authorities to grant of permission for performing Ram Navami Puja / worship and peaceful procession on the occasion of the Ram Navami
5th April and 6th April 2020.
on 5th and 6th April 2025. Full stop. This court considered the report submitted by the learned counsel for the state and find that it is categorically mentioned that who is the in charge officer in charge of Kalatala
Shuti police station.
Shuti police station has visited the place and came to know that the worship was done by making wooden platform on a canal which belongs to the irrigation department. It is also found that the police authority have stated that they have no objection for perform the worship of Lord Ram on the occasion of the Ram Navami. This court find that the Ram Navami was celebrated in the month of on 5th to 7th of April 2025. Now,
kindly record my submission, but this has become infructuous.
That's why. Okay, then. Learned counsel for the state submit that the Ram Navami has already they have conducted the Ram Navami.
I don't have any. Because
Counsel for
on
the
4th April we have submitted.
counsel for the state submit that the petition has prayed for.
Obviously, that's why
direction
they
for conducting
they are not
Ram Navami and Ram Navami has been over in the month of April 2025. Thus, the writ petition filed by the petitioner has become infectious. Considering the above, this court find that nothing remains in the present writ application. Accordingly, the writ application is dismissed as infractious. Report submitted by the state be kept with the record. Yes.
Even I appear on behalf of the
Item number 11, I represent the respondent bank 1 to 5.
petitioner.
What is the prayer?
Prayer, my lord, without succession certificate, not disburse the amount, deposited amount.
Who are you?
My father.
Your father was a government servant?
Government servant, school teacher.
School teacher.
Primary school teacher.
Who are you? You are the son.
Son.
Only son.
Two son. Only Orunde and Borunde. Two
Both are the petitioner here.
Petitioner only second.
Borunde.
Borunde.
What about the second petitioner?
Second petitioner. Petitioner, my lord.
Son.
Second son.
Second son.
Second son.
What about the second son?
Second son, my lord, grievance.
He has objected.
Objected.
So what can be done?
No, my lord. Petitioner Borunde writ petition filed before this honorable court due to only legal heirs equal share divided only daughter-in-law Monju the private respondent number 6 nominee as total deposited amount near about 9 lakhs. Petitioner father Rakohari De was the teacher of primary school and his pension payment was running with the savings bank account such and such account number and Punjab National Bank Mondokuli branch. Thereafter,
that is correct. What is the dispute?
Dispute, my lord.
My lord, may I cut it short, my lord? I'll just
two equal share.
The
This was the
wife of the second son
second son.
is a nominee
Nominee.
of the person who had the account. He has passed. Now, Burunde is the another son.
Another son.
Now, my lord, his wife, the private respondent's wife, is the nominee. My lord, when there was an RTI filed, my lord, regarding asking a question to us, how much is in the account, and please don't give away the amount. After the writ has been filed, my lord, no change in the status of the account has been done as per my instruction. There's a balance of 8.33 lakhs. This is for
The amount is not yet released.
no. I have not even received any intimation from
So
the other
how
private
the writ
respondent.
court can decide, sir?
Without succession certificate, not to disburse the amount. Without success.
Correct.
Without succession certificate, my
Even
payer.
the succession certificate, without succession certificate, it has been if the nominee is received, nominee is only a trustee.
Only drawing and disbursement.
You can go for the recovery.
Recovery.
If they
As per the RBI guidelines,
if the bank or authority has released the amount in favor of the private respondent and permanent respondent is enjoying the same, you go for the recovery and you can claim that amount. This is you have a Supreme Court judgment. Let us.
My lord. Kindly see that division bench judgment.
Even in the bank there is a regulation.
Yes, my lord, I was just about to place. I was about to place. I have only three.
255Z or
Yes, my lord, I have.
256Z?
Yes, my lord. I have threefold duties to ascertain, my lord. Whether the person who is claiming to be the nominee or the survivor is that person or not. That is the first. Second, my lord, whether there is an order from a competent court which directs me to give it to someone. That is the second. And the third is that even if I give it to the nominee or the survivor, I will give it to them with the disclosure that you are holding it as a trustee. So if his wife comes up to me and says that please give the amount, I will say that I'll give you the amount. As a trustee, I'll give it to you. And the petitioner, whoever the survivors are, they have the remedy.
Indemnity.
Bank is absolved from all
Bank will take the indemnity and it will release. That is
But
the law
upon my
only.
caution, when the writ was filed, we have
You
not.
go for the succession certificate. Why the- Yes, but so what can
Kindly
what is to be done?
direct the bank authority. Kindly not to disburse any.
You go to the civil suit and take an injunction over there. How the in the writ application the interim order can be passed? You go to the civil suit. Which area?
Area, my lord, Bankura, district Bankura.
Makura. Yes, go to the district judge. Succession certificate go to the district judge.
Kindly observation this point, my lord. Division bench judgment, my lord.
Yes,
Justice Nishita Matre and the Tapas
Sir,
Mukherjee.
I am disposing of this replica with the giving liberty to go approach before the appropriate court of law for grant of succession certificate. Correct? The petitioner has filed the present application, praying for a direction upon the respondent number 5, that is the branch manager, Punjab National Bank, Mandalkuli branch, not to release the deposit amount lying in the saving bank account number. Deposited amount lying in the saving bank account number 1306010101671 in the name of the deceased, namely Raka Hari Day. Counsel for the petitioner submitted. The petitioner is one of the son of the deceased Raka Hari Day. The deceased was the government teacher in the state of West Bengal. He died, leaving behind
two sons.
Orunde and
Borunde.
Two sons, namely Arunde and the Barunde.
Borunde is the petitioner.
Barunde. The respondent number 5 is the wife of the Arunde.
No, 6.
Respondent number 6 is the wife of the Arunde, who is the nominee in the service book or in the bank. The bank.
Monjude.
Nominee of
daughter-in-law.
Nominee of the deceased in the bank. Full stop. The learned counsel appearing for the respondent number 6 submit that you have applied for. Submit that he has not yet applied before the bank for release of any amount. This court find that there is a dispute with regard to the amount lying in the name of the deceased Raka Hari Day in the Punjab National Bank, Mandankuli branch. Full stop. The counsel for the petitioner has relied upon the judgment in the case of Paresh Chandra Ghosh versus the state of West Bengal and others, reported in 2014 SCC Online, Calcutta 9281, and submits that the bank cannot release the amount in the name of the nominee unless and until a succession certificate is been procured by any of the legal heirs of the deceased. Full stop. Learned counsel appearing for the bank submits that as per the record of the bank, the respondent number 6 is the nominee, but the nominee cannot be treated as a beneficiary. He can only be a trustee. Treated as a beneficiary, he can only be a trustee. If the bank is released the amount, in favor of the nominee, the nominee has no right to utilize the said amount unless the other legal heirs' shares is to be distributed. Considering the above, this court find that there is a dispute with regard to the amount lying in the name of the deceased in the Punjab National Bank, and admittedly the respondent number 6 is the nominee and the petitioner is one of the son of the deceased.
I can confirm the balance as on 11th of September. That is exactly 8 lakhs. Your Lordship would record that.
The learned counsel for the bank submit that as on
11th of September.
11th of September 2025.
There is 8,33,000
and amount of rupees 8,33,000
284.85 paise.
284.85 paise is lying in the bank in the account of the deceased. Considering this court find that there is a disputed question of fact in the present writ application which cannot be decided in the writ jurisdiction. According, the writ petition is dismissed on the ground of mentality, but it is made clear the dismissal of the writ application will not prevent the parties to approach before the appropriate court of law for obtaining succession certificate.
Only one thing, allegation I have denied.
Though the parties have not filed though this court has disposed of the writ application at the stage of motion, and no parties have not filed their affidavit in opposition. Accordingly, the allegation made in the writ application deemed to have been denied.
Affidavit kept in the record.
Affidavit of service filed by the petitioner be kept in the record. Go and file the succession certificate.
Great.
Number 12.
Well, my lord, I am praying that the matter will be taken up after vacation.
Not today. Next.
Item number 13.
I am appearing on behalf of the respondent number 5 and 6.
Who is for the petitioner?
For the state respondent.
The respondent 2.
You are appearing for
State respondent.
state respondent. What is the prayer? Withdraw an alleged notice. What is the notice? To run the manufacturing business. It is not today. Next. No petition, not today.
Item number 15.
My lord, I'm for the petitioner, my lord, due to some medical emergency, my lord.
Not today.
Item number 16.
Not today.
Item number 17. Lord, I am appearing for the petitioner.
My lord, I am appearing for respondent number 2, banking ombudsman.
Lord, I have served all. Affidavit of service is here. Lord, I am appearing for behalf of the respondent bank 3 and 4.
Banking? Bank?
Respondent bank.
You are appearing for?
Banking ombudsman, your lordship, respondent number 2.
Lord, fact in short is this. The petitioner before your lordship is a medical practitioner. Lord, is specialist in general medicine, MD. Now, Lord, on 22nd of October 2024, while you were just checking up a critical patient, at that time, he became a sufferer of cyber hack. But from his account, at first thought, 50,000 was...
Who had suffered? Who has suffered?
Petitioner, the doctor. Now, Lord, from his account, initially 50,000 was hacked. Thereafter, 59,200 was hacked.
And my lord, while there was no money in the account, his credit card attached to the bank, but therefrom the hackers took loan of 6 lakhs. My lord, in a formal way, in a such a way that it has been just spread by him, and it would be evident from the papers I have annexed to the application. And now immediately thereafter, the credit card and the bank account were blocked.
What is the prayer here?
My prayer is this, that 6 lakhs money which was siphoned, that has been returned, but since the credit card has been blocked and bank account has been blocked, they have been deducting EMI at the rate of 37% interest from 6 lakhs, and next month lesser, which has been deducted in this way. Every month they have been deducting. Bank has been deducting.
You have taken loan?
No, I have not.
So why the amount has been deducted?
Cyber hackers have siphoned the same. And while I complained it before the appropriate police station and the cybercrime station, as well as National Cyber Portal, where the money was returned to the bank, but money was not disbursed in my favor. Those were kept in the bank, and therefrom bank is deducting EMI as if I have taken the loan.
Okay.
Lordship, kindly come to page 39.
So what the red court will do here?
The deduction should be stopped, and I raised my voice before the ombudsman. Ombudsman will sought for some clearance, clarification within 3 days, which was overlooked. That's why they closed the chapter. Because of the reason I am in a position, Lord, I have been suffering every day. Lordship, kindly come to page, first Lordship, kindly come to page 39. Page 39.
Yes.
Here, Lordship, on 22nd of October, this was happened.
6 lakh, 62 lakh, and 6 lakh 29,000.
Yes.
This has been deducted.
And Lordship kindly sees that GST even has been shown there. As if they have taken GSP. I have prepared
debit card GST.
Yes.
590.
Yes.
So you are the primary customer?
I am the primary customer.
Okay.
And the money was siphoned to another account in which my son is the primary customer, and I was the account holder. Then your Lordship kindly come to page 41. Wherefrom your Lordship will find on 22nd of October 2024, my Lordship sees at the first instance 50,000 was debited. Then my Lord GST 2,264. Then my Lord again 49,400. In this way, it has been hacked.
No, this other than 6 lakh 29,000. This is further.
This was initially done. 50,000 and 49,000
initially.
This was initially. And
no. This 6 lakh 29,000 of which date?
They are
October
on
24.
the very same day.
October 24.
22nd of October.
And this
22nd of October.
Okay. This is total amount.
Total amount.
Like this, the total 6 lakh 29,000 has been taken out.
Yes.
Okay. Then
initially 50,000 and 49,000 brought from the bank account.
Correct.
While they saw that that in bank account there is no money further, then they hacked from the credit card, which is issued by the bank.
This hacking, my lord, may I just intervene for a moment? My learned senior friend has been making submission that hacking and all that. It was lodged with the criminal, a complaint was lodged on the basis of this. And this hacking which took place, this was on the basis of the OTP information provided by the petitioner directly. So that your lordship will find at page number 46, what the bank had responded. Because when he lodged the complaint with the banking ombudsman, under the banking ombudsman scheme, there is a policy by which bank has the obligation of asking for a response from the regulated entity, which is in this case the bank, Axis Bank. So Axis Bank gave this feedback, which is appearing at page number 46. If your lordship kindly reads on, with reference to your complaint lodged in CMS, the bank has submitted below mentioned observation. So and so customer of the bank disputed 2 e-commerce transactions aggregating to such and such using customer's credit card credentials. Upon interaction, customer has also disputed issuance of credit card loan of such and such, which was credited on such and such an account number such and such. The loan was cancelled by customer and the same was returned back. No transaction was processed from the loan account. As the loan was cancelled within 30 days, no foreclosure charges have been levied. No unauthorized demographic, that is mobile number and email ID changes observed in the customer's card account prior to the dispute transactions. The disputed transactions are two-factor authenticated secure transactions completed using customer's complete card credentials, that is card number, expiration date, CVV, and transaction OTPs, which are only known to the customer. As per the OTP logs received, the OTPs were sent on the customer's registered mobile phone number such and such. Hence, it can be inferred that the customer's card credentials and OTPs were compromised at the customer's end. Transaction alerts for the disputed transactions were sent on the customer's registered mobile number through SMS. An alert was generated for the below mentioned card on which an automated IVR call was initiated. Customer accepted the transaction as not fraud over the IVR transaction. During transaction analysis, it was observed that the disputed transaction is not the first CNP transaction. The customer had used the card for e-commerce transaction in the past and prior to the disputed transaction. Based on the customer complaint and above findings, possibility of credit card credentials being compromised at customer's end prior to the alleged transactions cannot be ruled out. Based on the findings, no liability is devolved on the bank. The case is concluded as fraud. Then this was the response which was sent, and your lordship will note at page number 54. If your lordship kindly turns to page number 54. This is what normally happens when a complaint is lodged and the RE gives its response, that is the regulated entity. The customer is again approached and he is asked to give his feedback on the basis of the response received from the regulated entity. The response was not received within the statutory timeline and therefore it was closed. And it was closed upon passing this reasoned order which was passed. If your lordship kindly turns to page number 54. The portion in bold, if your lordship notes it, against paragraph number 2 at the bottom. In connection with your complaint regarding such and such an account, that the complainant disclosed that he received a call from unknown number pretending to be an Axis Bank official requesting for RE KYC. The complainant shared the details through WhatsApp video call, and after that, the unauthorized transactions have been processed. It is also observed from the reply submitted by the bank regulated entity that no unauthorized demographic changes were made in the customer's card account prior to the disputed transactions. So everything was informed to him. And then your lordship will kindly turn to paragraph number 3. In view of the above, next page, we have closed your complaint under clause 16(2)(a) of the Reserve Bank Integrated Banking Ombudsman Scheme, which stipulates as follows. The Ombudsman may reject a complaint at any stage if, in his opinion, there is no deficiency in service. Then, so on the ground that there was no deficiency in service, the complaint was closed. Now, over and above that, if your lordship kindly looks into what prayers have been sought for, page 14 and 15. He's asking for only mandamus so far as the steps to be taken by Axis Bank account and so that the crime which has been committed be resolved. Now that can only be resolved by the cybercrime cell where the petitioner has lodged his complaint. He has not met the police authority party here, and although he has raised a demand for justice on the same, and he says that if your lordship now turns to page number 12, internal page number 12 of his writ petition, paragraph number 25. What has been alleged before before this honorable court? Your petitioner states that the entire inaction and or non-action on the part of Axis Bank, then says Ombudsman, police administration of the state and the police appointed for dealing with cybercrime. Now, after this, the prayers which have been sought for, if your lordship kindly looks into how this can be maintainable, because in the writ, it's a purely a disputed question whether the transaction did happen or not. It is subject to the police investigation. The Honorable Court cannot pass any order unless and until the police files his report in this regard.
Yes, sir.
Your Lordship, can you come to page 2? Who have been made parties here? She is telling that police has not been made party. My lord,
I am
state
saying
of
that
West
so far
Bengal-
as the reliefs are sought for, that is not directed against the police authority. It is the general, these are all generally drafted prayers.
State of West Bengal through the Secretary, Department of Home Affairs, Police. Then my lord, officer in charge, Diamond Harbour Police Station. Then inspector in charge, officer in charge, Cyber Crime Police Station at Poilan. Then inspector in charge and officer in charge, Cyber Crime Station, having office at Lal Bazar. All of them have been made party.
So this can be a writ for police inaction. It cannot be a writ under this forum.
While Axis Bank didn't take any
The
steps.
Axis Bank already closed your
Yes.
complaint.
Yes.
Correct. Now
Yes.
you are telling that there is a hackers. There are
Yes.
some persons. The
Yes.
investigation is to be carried out because the Axis Bank has taken a specific view that the OTP has been provided by you, and on your conversation, all the amount has been released. Subsequently, the amount now it has.
Yes.
Correct.
Yes.
Now you are telling that it is not correct. What the stand has been taken
Right.
by the Axis Bank is not correct. It is to be investigated.
Yes.
So who will investigate?
But police and cyber crime
Where is the
sections.
where is the complaint to the police authority?
Your Lordship, kindly come to one after another. I have
What is the date of the October 2024?
22nd.
No, incident was occurred when the amount was hacked.
On 22nd of October 2024.
24.
Yes.
Where is the complaint to the police? Which?
Say page 19, Lordship, kindly come to.
19.
19. Officer in charge, Diamond Harbour Police Station. Then Lordship, kindly come to next page. From Lordship will find me a page from page 22 that money was siphoned to Lord Bengaluru and Messrs Quick Seal on 22nd. Then Lordship, kindly come to 24, page 24. The officer in charge cyber crime police station, Kolkata, that is at Lal Bazar. Then Lordship, kindly come to next page.
So what has happened to this complaint?
Pardon?
What has happened to this complaint?
Milord, they have stated that we are investigating, nothing more.
Any FIR is chalked out?
Yes.
Yes, your lordship will find that at page number 37.
FIR.
I am
Page 37.
37. Yes, Lordship, kindly come to
Alipur police station. Subdivision Ali, which police
This
station?
is-
Cyber
yes,
crime.
Cyber crime police
Cyber
station.
crime. Yes, FIR has been chalked. What is the stage of the investigation?
They are saying it is under investigation. No steps. Up till now, I have got nothing. But my humble submission at this stage, let my learned friend submit an affidavit annexing all the rules of RBI. What he is orally submitting, I am not on that. He should submit everything before your lordship. What are the RBI guidelines over the matters? And Milord, my humble submission is this, that the money which is still with the Axis Bank, and I am not getting it back. No EMI. Milord, they have been claiming EMI at the rate of 37%.
Why the EMI has been deducted?
My lord, I am appearing for banking ombudsman. I am not for Axis Bank.
Appearing for Axis Bank.
OTP that he had shared,
Huh?
the OTP that he had shared,
Huh.
and the transaction that he had done genuine. In our eyes, the transaction is genuine.
Transaction is genuine, whether without any formalities, you can say that 6,20,000 is the loan amount.
My lord, he had opted the loan. I mean, he did not. He gave the OTPs. The loan was credited directly to his savings bank account, and since his savings bank account has already been compromised, the hackers took the money from his savings bank account.
Who? Hackers.
Yes.
Hackers has taken the amount
Yes,
from
but
the
the
saving
loan
bank.
is showing an outstanding in
Whatever it may be, how you can realize the interest? How you can realize the interest unless until the investigation is not been completed? Okay, Axis Bank stated that he has provided the OTP and all this, but there is a criminal case and investigation is going on. So how you are taking the interest and all these things? Okay, you freeze that amount, no problem. It is a loan amount. You are telling the loan amount, but how you can take the
if we defreeze the account, since his account has already been compromised, there is a further possibility that his account might be again compromised again further.
My lord, in a similar matter,
block the amount.
In a similar matter, Honorable Justice Subbusachi Bhattacharya, he has passed an order in WPA number 10311 of 2023. But instantly it is not with me. If our lordship give direction for affidavits on the next date of hearing, I shall place it before your lordship. But in the meantime, lordship, what I am praying for, no EMI should be deducted from the money which has been kept with them.
Where is the deduction? Where is the document that they are deducting the EMI? Where is that?
Lordship, kindly come to page 39, page 41.
Yes.
Yes.
Where is the amount deducted? Loan amount deducted, EMI deducted. Where is that?
And it against the last but 3 entry, last but the 3rd. EMI processing fee, etc.
EMI processing fee. Cash withdrawal.
Yes.
This one. Another?
In this way, it is 1 month. In this way, they have been doing right from 24th till date. Money is in bank's custody.
What is the total amount?
Total
hacked from your account?
Millard, first 50,000, then 49,400, then Millard 6 lakhs and odd. It will appear from Millard page 39. Lordship sees here 22nd of October 2020.
29,000.
Yes.
That is one. Then
Millard
99,400.
Yes.
99,400.
Where is that?
Even they charge GST.
That is an annual.
In such a manner, Millard, it has been done.
That will appear in page number 5, Millard.
Page number?
Page 5 of the writ petition. At paragraph number 6 and 6.
First, suffered loss 99,000 in 2 attempts. There is no date.
And thereafter, paragraph 7.
6,29,000.
Yes.
This amount is different and this amount is different. That is
Yes,
Your Lordship. 89,400 different and 16.
That is from Millard bank account. And this is from credit card.
From the savings bank account.
Yeah, if your Lordship kindly turns to page number 35, this will resolve the issue because 4th paragraph, the date is there, 22nd October, while I was examining a very badly infected patient, became victim of cyber fraud and suffered loss of 99,400. And the breakup is given 55,000 in one tranche and then 49,400. Together 99,400 in 2 attempts from the bank credit card number. And also hacking the credit card, attempting and causing a loan. This is the loan amount, 6,29,000. So these figures are separate.
Not to deduct the.
Well, I have to take instruction how much deduction have been made till date.
No, whatever deducted. Henceforth, not to deduct till the disposal of this application. Not to deduct.
Now, so far as the affidavit, if your Lordship is calling for an affidavit, I would like to submit only one thing. The complaints which were lodged by the petitioner, those are before your Lordship. The closure of complaint is also before your Lordship. So there is no new document which can be submitted by way of an affidavit so far as banking ombudsman is concerned. And under the statute, which is the banking ombudsman.
First it says I am restraining the bank for deducting any EMI or interest from the bank account. First, second, I will call for the report from the this cyber crime office.
Very good.
What is the stage? What is the stage of the investigation? The petitioner has filed the present application, praying for a direction upon the respondent authorities to take appropriate steps for what is your prayer?
That is why I was taking your lordship through the prayers. These are very generally worded prayers. There's no specific relief sought for.
Page 16.
That what is a prayer? Nothing.
Ad interim order of direction.
Ad interim, where is the prayer? Why can you? What prayer you are asking from?
At this stage, I am asking, my lord, prayer.
Come to the prayer first, sir.
That is what mandamus.
What you want? Your mandamus? What mandamus you are asking?
Taking appropriate steps so that grievances agitated by the petitioner suffering crimes committed by the cyber hackers using Axis Bank account and credit card of the petitioner be resolved and deduction of EMI
Grievance of the petitioner is that
against purported loan hacked by the cyber hackers from the account of the petitioner.
On 22nd of October 2024, an amount of rupees 99,400. An amount of rupees 99,400 has been deducted, 99,400 in two installment, rupees 50,000 and rupees 49,400 has been deducted by the cyber hackers from the account of the petitioner maintained in the Axis Bank. Which branch? Axis Bank?
Manton branch.
Axis Bank?
Manton
branch. Manton branch. And subsequently, an amount of rupees 6,29,000 has also been deducted from the saving bank account. From
credit card.
The 6,29,000 from
credit
the credit card.
Yes.
Of the
number, my lord, 9160.
Credit card having number
9160
100
100
yes
8254 7751
of the Axis Bank. Full stop. When the petitioner came to know that illegal deduction has been done from the account as well as credit card of the petitioner, the petitioner has made complaint to the police authorities as well as the bank. Full stop. As well as the bank. Full stop. The bank has as well as the bank. Full stop. The bank has submitted a report holding that after the inquiry, it was found that has submitted the report by closing the complaint made by the petitioner.
My lord, that will probably not be right because this page number 54, which I had placed before lordship, that's by the banking ombudsman. And what is there at page number 46 is also from RBI communicating to the petitioner the response of the bank on so.
After receipt of the report from the petitioner, the Reserve Bank of India has communicated the decision of the Reserve Bank of India to the petitioner, and subsequently the ombudsman, by an order dated 22nd of March 2025, also informed the petitioner that the complaint made by the petitioner is closed. Full stop. The grievance of the petitioner before this court now, the Axis Bank has realizing the EMI as well as the interest from the account of the petitioner, and the police authorities have not submitted any report. Though the police authorities has initiated an FIR, but till date, though the police authorities have initiated an FIR, but has not submitted but has not completed the investigation till date. Considering the above, police counsel for the petitioner further submit that the amount has been hacked, illegally debited from the account of the petitioner, but now the bank has taken into consideration that the petitioner has obtained the loan, and accordingly the bank is realizing the EMI as well as the interest accrued therein, though the petitioner has not obtained any loan. Full stop. Considering the above, this court find that till the disposal of this present application, the bank should not realize any interest or EMI henceforth till the until further order. Until further order. This could also find that where is the FIR?
FIR is yet put
Also
out.
find that on receipt of the report from the petitioner, comma, the
37.
The cybercrime police station Alipur has registered an FIR being FIR number 31 of 2024 dated 6/11/2024 but till date but the petition is not but till date no final report has been submitted. In view of the above, the officer in charge of the cybercrime station police station is Alipur South 24 Pargana is directed to submit the report before this court on the next date fix with regard to the stage of the investigation. The Axis Bank is also directed not to deduct any interest or EMI from the account of the petitioner until further order. Let the matter appear on 6th of November 2024. Affidavit of service be kept in the record. ऊपर आ जाएगा.
Item number 18.
Not today.
I'm for the rescue. I'm for the Union of India. 18.
Petition is not here.
After vacation, my lord. After.
My lord, I beg to appear on behalf of the petitioner. My lord, it's a peculiar case, my lord, where the petitioner number 1 is a company before your lordship, and my lord, the petitioner number 2 is the manager. Now, my lord, they are engaged in purchasing scrap materials from railway board. Now, my lord, what happened that while participating in the bid, it is I have mentioned in paragraph 6, the usual price of the bid, that is a few weeks earlier bid which has been allotted in my favor, that I have also annexed as annexure P3. The usual price is rupees 2,520. Now, my lord, instead of quoting rupees 2,520, by mistake I quoted it as rupees 5,000 and something odd. So, my lord, on the date of opening of the bid was March 11, 2025. After the bid was closed, I realized after submission in the computer, online submission, I realized my mistake. On March 12, that is the very next day, I sent an email to them, authorities, stating that by mistake I have quoted almost double value. So, my lord, let my quotation be cancelled. They, my lord, accepted me as a highest bidder, and they are continuously putting pressure upon me to deposit the remaining money. Now, my lord, I have time and again communicated with them. Now, since they were going to blacklist me, I have came up before your lordship on writ jurisdiction. This is the case in simplicity, my lord. And, my lord, I am guided by 2 Supreme Court decisions where, my lord, it's a bona fide mistake on my part. The authority has to consider.
Where is your tender, online tender, and where is your letter intimating that by mistake you have given the...
Yes, my lord, kindly come to, my lord, annexure, my lord, annexure P2 is, my lord, that usual, my lord, the bid sheet, annexure P2, my lord, see, my lord,
page number
27, annexure P3, page 27, my lord, the sold rate unit, that
is no page number.
Page 27, my lord.
No, say 27.
Yes, my lord.
24, after 24, there is no page. There's no page.
Lord, kindly give it for 2 minutes time. My junior will do it. If
there's no page.
Page number.
Correct the page and come next week. There's no page number.
And after 24, page number. Page number Milord, then liberty. He's do it, Milord. Liberty.
Come after. I am giving liberty, correct? Come next week. After vacation.
After vacation.
It is fine. It is fine from the record that there is no pagination after page number 24 in the writ application. Counsel for the petitioner prays for leave to paginate the documents in the writ application. According, leave is granted to the petitioner to paginate the annexes in the writ petition within a week from date. Let the matter appear on 6th November.
Milord, let the affidavit of service be kept.
Affidavit of service filed by the petition be kept with the record. Next.
My lord, this is my application. It's a pleasure, my lord, because for quite some time.
केस खत्म होगा ना, डिप्टी रजिस्ट्रार को बुलाया, भेज देना, लेके आना साथ में.
My lord, the affidavit of service is here.
You are for the petitioner?
I'm for the petitioner. My lord, it's a pleasure because for quite some time I've been trying to appear before your lordship, but I was not getting a case. But this is the first time I've got a case. My lord, the case is simpliciter. My father died, and prior to that, his wife died. And the pension account was in the bank. Now, the bank said that you need to come up with a succession certificate.
Who are you?
I'm the son, one of the sons.
How many legal heirs?
2 sons.
2 sons.
Now, the bank says, yes, I'm going to make payment, let your other brother come. Now, the other brother is not coming. So, in that case, I cannot take out the money. I need only 50%. I'm not going to take more than that. Now, the bank says, unless the court passes an order, I cannot disburse the amount to you. Well, I do not need more than the 50% that is lying. But I'll show it to your lordship where it is.
No, but that's correct. But you have to, if there is any dispute with regard to the account left by your father and you are the 2 brothers, one brother is giving objection, then succession certificate of that.
I have got a succession certificate.
After
yes.
Where is the succession
Yes,
certificate?
I'll just give it to your lordship. Yes. P4, my lord, page 16.
Page?
16.
16.
Yes. It's, my lord, at page 19, the details are there. Page 18, it starts. The details are all there. Shall I place it?
Just a minute, let me check.
Please, page 18, my lord.
Yes.
The petitioner's case is in brief that one Deepa Datta expired on 16/1/2018, leaving behind her husband, namely Chitto Govinda Datta and 2 sons, that is petition and opposite party. Thereafter, Chitto Govinda Datta has expired on 11/7/2019, leaving behind petitioner and opposite party as his legal heirs. Let Chitto Govinda Datta and let Deepa Datta were the owners of the scheduled property. After the death, petitioner and OPs are entitled to get scheduled property as legal heirs of let Chitto Gopal Datta and let Deepa Datta. Petitioner has filed his application for getting succession certificate in respect of half share of scheduled property from this court in favor of him as legal heir of let Chitto Govinda Datta and let Deepa Datta. Opposite party has appeared before this court and has filed written objections. Opposite party has stated in the written objections that petitioner.
Okay, I gone through.
Yes.
So this is a succession certificate. Then
Succession
you applied
certificate.
before the bank.
Yes.
Where is the representation?
Page, I think, 23.
Page 23.
Yes.
Then?
Now, they do not say they invite the other side. They put up an intimation at page 25, annexure P7. This is an intimation by us to them. And on the basis of an intimation at page 26.
Where is written the page of the payment account section?
Yes.
Corporate accounts pension cell.
So we are to inform you that with regret that one of our dear petitioners so-and-so expired due to belated receipt of death intimation amount of so-and-so. That is not also important, but the important part is this one, my lord.
To inform you that
Page 27. May I read it to your lordship? In reference above, we would like to inform you that your father had one pension account number so-and-so in the name of Chitto Govinda Datta in our PNB bank account. You are requested to visit branch for further debt cum settlement. This is to my brother, to Mr. Shorav Datta. He does not come. He wants to put me in pain so that I do not get my 50%. My lord. Now that is the only case here. Everything is clear. And this was in the month of April, 2nd of April 2023. I'm sorry, 27th of November 2024.
Who is appearing for the bank? Have you served the notice?
I have served the notice on all the parties. Right? On all the parties, my lord. So if the service copy ta hota hai.
Where is the track report?
Where is the track report?
Where is the track report? Is the only the receipt?
My lord, this was sent on copy party. But the substantive period of time has already elapsed. We send it in the month of April. The presumption goes in favor of us, as your lordship knows. And now I cannot get a track report also.
The petitioner has filed the present writ application, praying for a direction upon the
Punjab National Bank.
Upon the respondent number 2, the Punjab respondent. Which bank? One is
Punjab.
zonal manager, second is branch manager.
Punjab National Bank, Kunda bolo. Which one is it?
Made the Punjab National Bank as a
Number
party.
2, my lord. The branch manager, Punjab National Bank, Rampurat branch. Number 2, my lord.
To the direction upon the bank authorities. Punjab National Bank.
Yes, my lord.
Respondent number 2. 1 and 2. 1 and 2. For release of his 50% share of the amount pending in the name of his father in saving bank account, joint pension saving account number 1006010101644, along with interest in terms of the success certificate granted by the London District Delegate Rampurhat, Birbhum, in connection with succession case number 63 of 2021, dated 25th of September 2023. The counsel for the petition submit that the mother of the petitioner was predeceased to the father of the petitioner.
Yes.
The father of the petitioner died on 16th of January 20. No.
The mother
of the petitioner died on 16th of January 2018.
And father expected
Father was
11th July 2019.
11th of July 2019, leaving behind his 2 sons, namely
the petitioner and
Tamanaya Datta, the petitioner herein,
and Saurav Datta.
Saurav Datta, who is the respondent number 3 in the present date application. He submits that the father left behind one joint pension account in the name of the father and mother both.
Yes, both are only father's
Left
name.
behind one pension account being pension saving account number 100601010.
It's a joint account, my lord.
44.
Joint account.
Pension account.
Joint pension
Four,
account.
in the Punjab National Bank. Which branch?
Rampurhat.
Rampurhat branch.
Nischintapur, my lord. Rampurhat, Nischintapur branch.
Punjab National Bank, Rampur, Nischintapura branch, Rampurhat district, Birbhum. Police. After the death of the father, the petitioner has applied for release of the amount from the bank, but the bank has directed the petitioner to obtain succession certificate. The petitioner has applied for grant of succession certificate, and by an order dated 21st of July 2023, the bank and the London District Delegate within bracket Civil Judge Junior Division 2nd Court Rampurhat Birbhum has issued the succession certificate to the petitioner In the succession certificate, it is categorically mentioned that the petitioner is entitled to receive the interest or dividends and to negotiate, and both receive interest and dividends on and negotiation on and to negotiate or transfer the securities or any of them. Full stop. After the grant of succession certificate, comma, the petitioner has made a representation to the bank by disclosing the succession certificate granted by the court for release of his 50% share in the amount lying in the joint account of the father. But in spite of receipt of the said amount, the succession certificate and the request made by the petitioner, comma, the bank failed to release the said amount. The petitioner has relied upon a letter dated 23rd of September 2019 issued by the manager within bracket pension, comma, pension payment officer, wherein the said authorities has also requested the branch and to the bank authority to the Punjab National Bank for release of the amount in favor of the petitioner. Full stop. The petitioner has drawn the attention of this court to the letter dated 27/11/2024, wherein the petitioner has requested brother of the petitioner to appear to attend the bank, but the brother of the petitioner has not attended the brother of the petitioner has not attended the bank, due to which the bank is not releasing the amount. The main grievance of the petitioner is that since after the death of the father, the brother of the petitioner, one or the other reason, delaying for release of the amount, and he is not cooperating with the petitioner so that the amount can be released. Accordingly, the petitioner has obtained the succession certificate. From the succession certificate, it is categorically proved that the petitioner is the successor to receive the amount. It is the further contention of the petitioner that the petitioner is not praying for release of the whole amount in favor of
Only
the petitioner.
50%.
The petitioner is only praying for release of his 50% share in the amount lying in the account of the father.
Absolutely.
But in spite of the same, the bank is not releasing the same. Considering the above, this court finds that the petitioner has already obtained the succession certificate from the competent court of law. Though there are two legal heirs of the deceased father, but one legal heir is not coming forward, and the petitioner, being one of the legal heirs, is specifically claiming only 50% of the share lying in the account of the father. But the bank, without any reason, has not released the said 50% share to the petitioner.
Grateful.
In view of the above, the writ petition, this court finds that no purpose would be served by keeping the writ petition pending. Accordingly, the writ petition is disposed of by directing the respondent number 1 and 2 to consider the case of the petitioner in view of the succession certificate granted by the competent court of law, and to release the 50% of the share of the petitioner lying in the account of the father within a period
Joint account, man. It's a joint account.
joint account of the father within
And
a
mother.
period of
With interest, my lord.
within a period of 6 months. 50% of the amount of the petition along with the interest accrued therein within 8 weeks from the date of
I'm
receipt
grateful.
of this.
Grateful.
8 weeks from the date of receipt of this order.
Grateful.
WPA number
Grateful.
no order has to cost.
Number 21.
Not today.
Number 22.
Item number 22, I beg to appear on behalf of the petitioners.
You proceed, O Lord.
My learned senior will appear your lordship, before your lordship.
Not today.
Item number 23.
My lord, if your lordship kindly keep this matter after vacation.
23, my lord.
After vacation only come. If you want tomorrow, then I will keep tomorrow. Want tomorrow?
No, my lord, kindly keep this matter after vacation. Item number 22.
Yes, it will come after vacation.
I'm grateful.
23, my lord, for the petitioner.
Yes.
My lord, the petitioner is a Rohingya. My lord,
Rohingya.
yes,
So
your
what
lord.
do you want for the Rohingyas?
No, my lord. My lord, he was arrested on 9th October 2016. He was sentenced to 3 months in custody, which he completed in 9th January 2017. Since then, my lord, for 8 years, 9 months, he is in illegal detention.
He is in detention or in the civil
No, my lord, he is
civil
in Dum
authority?
Correctional Home.
He's still in correctional home.
Yes. My lord, I'm praying that he might be
He has not been given to the civil authority.
No, my lord. My lord, so that he can be handed over to
Correct.
UNHCR.
He has to be given the civil authority, then civil authority will request the ministry for deportation of the.
My lord, this is my affidavit of service, my lord. I am referring to Bhim Singh's judgment as well as, my lord, few judgments of our High Court.
No, not. I am calling for the report.
My lord, kindly calls for
Who
report.
are the parties here?
My lord, the Union of India and the state, your lordship.
Yes. What you are doing? Giving the free food and free stay. In spite of the completion of the sentence imposed by the competent court.
My lord, under Bhim Singh's judgment, my lord, they cannot keep me in jail indefinite. My lord, this is illegal detention, my lord, gross violation of my.
There is a post of Director General of Prison. There is no post of Director General of Prison.
Director General, no, my lord.
Maybe.
There is Director General, Inspector General of Police, that is
not.
West
There is
Bengal Correctional Services.
Correctional Service, where is
West
that?
Bengal, that is respondent number 5.
Department of
Dum Correctional Home has superintendent, your lordship.
Oh, there is a head.
My lord, the head is respondent number 5, that is DG and IG of Police,
They have-
Correctional Home Services.
Achha, that's why I'm asking.
Yes,
Correct. West Bengal
respondent number 5.
Let the report file. Let they file the report.
My lord,
Where is the conviction order?
my lord, the conviction order is at page number.
Have you?
My lord, page number
Yes, pleaded
24.
guilty.
24.
Yes, pleaded guilty.
Yes, your lordship.
24.
Yes, page 24, your lordship. Now, today is fixed for production of accused, namely Abdullah. Abdullah is the petitioner before your lordship. Filed guilty plead petition on behalf of them.
Contents of the charge is read over, explain where he pleaded guilty. What is the section? 14A. What is the section?
Yes, your lordship. 14.
Section 14 of
Yes,
Foreigners Act.
section 14, Foreigners Act.
14 foreigner only 3 months.
Only.
How it can be?
My lord,
I think not less than 3 years.
no, my lord, 14A.
That's why I'm asking 14A, but
No,
here
only
14.
Only 14. This is only 14, your lordship.
14.
Only 14, your lord.
Accused persons or how many persons? One person.
My lord, 3 persons were convicted together, but only one is before your lordship.
All 3 are in custody, still in correctional home.
My lord, there are, as per my instruction, there are more than 28 who have completed almost 10 years, 8 years illegal incarceration in Dum Correctional Home, my lord.
Pleaded guilty are accepted. The accused person convicted for the imprisonment of 3 months and also to fine 2,000 each in default for 30 days. Conviction of accused arrested in it.
But 3 months, my lord, I am after 3 months, my lord, I am for 8 years, 9 months in detention.
And prior to this conviction, how many days you are in custody?
No, my lord, that was set off. So, my lord,
That was
total,
set off.
yes, my lord.
That's why that's set off. So how many days were there?
9 years in custody. Total 9 years, my lord.
You have to file report. Why you are keeping these persons? If the sentence is over, you have no authority to keep the person in correctional home. Under what authority you are keeping? On the very day you have to inform the civil authority will take the custody of the persons. If the foreign nation, then they will make correspondence with the Home Ministry and the concerned country, and they will repatriate back. That is the provision.
But I can
What you have done? Okay, I am passing an order. Let the report become.
He also
Directly you will submit the report.
Rohingya issue, my lord. This Rohingya issue, I had the opportunity of assisting the court, Justice Amrita Sena, in this matter. The Rohingya issue, since Lordship knows Rohingya problem, even on the Supreme Court has also the occasion to deal with the Rohingya issue, my lord. And Government of India has a very important role because as whether they can be sent in the refugee rehabilitation or not. So this Union of India has taken a call. In the other matters, ASG was assisting the court that how it is to be dealt with. So, my lord, first correctional home will have to bring a report. Thereafter, in my matters, correctional home, they tried to send them before this Delhi Authority, United Nations Refugee Rehabilitation.
They cannot go correct.
Government of India has a say because Supreme Court has said that as of now, no deportation. No deportation of Rohingyas. We
Different
can't.
thing. That is the
Because
ministry
they are
will decide.
Rohingyas, they have to send somewhere.
Somewhere.
Their country will not take. Now, if they want to go back to their country, then there is a question of slaughtering and this and that human rights violation. Now, in one case, they wanted to reunite with their family members. That also whether can be allowed or not. So, Government of India and is a very important. This
You are appearing for whom?
is for the state. The state will give a report on correctional home.
Correctional home.
That how what are the attempts we have made for deportation. What are the communications we have made with the Government of India? Now, Government of India has a very important role in this matter. You can Rohingya issue.
Notice.
party and served as
Have you
well.
served?
Yes, Your Lordship. I have handed over the affidavit of
So
service.
they might be in. They might have. So
My prayer is that
one more notice to the SG's office is needed, Lordship.
my prayer is that I be handed over to you itself so that I can be sent to rehabilitation camp in Delhi, my lord.
No,
But there is judgments with regard to the same, like Punjab and Haryana High Court has also passed.
All the
similar.
Rohingya issues are kept pending even in our court also.
It cannot be kept pending indefinitely, Your Lordship. My lord, there is
No, Government of India has the pull.
kindly see the order portion, second page, Your Lordship. And the third page.
Senior government leader.
Let file the report.
Yes, Lordship.
I'm only praying for handing over to you anything.
Let the report come. Let the report come because what the decision taken by the government, what that is to be taken into consideration. The grievance of the petitioner before in the present writ application is that the petitioner is of Myanmar.
Yes, Rohingya, my lord.
Myanmar.
Rohingya or Myanmar. My lord, but they are stateless because Myanmar does not recognize them as their citizen. The Citizenship Act of Myanmar does not recognize Rohingyas as one of their nationals.
Rohingya national, and he was booked by the concerned police authority for the offence under Section 14 Foreigners Act. After the completion of the investigation, police has submitted charge sheet and the petitioner has pleaded guilty before the learned first additional judicial magistrate Basirahat on 28 December 2016, wherein the learned magistrate has accepted the guilty plea, accepted the guilty pleaded by the petitioner and convicted and sentenced to suffer 3 months simple imprisonment and also to pay fine of ₹2,000 in default to suffer further imprisonment of 30 days. Full stop. The counsel for the petitioner submitted though the London magistrate has convicted and sentenced the petitioner for 3 months and payment and directed to pay fine of ₹2,000, but the petitioner is still in custody, still in correctional home in spite of the sentence completed by the petitioner in the correctional home. Full stop. This court find that before passing any order, a report is to be called for from the Union of India, from the Ministry of Home Affairs, Government of India, as well as the Director General and Inspector General of Police, West Bengal Correctional Services, to ascertain what steps have been taken by the central government as well as the state government after the completion of the sentence imposed by the court to the petitioner who is admitted to be Rohingyas. Let the report be filed on 6th of November 2025. Leave the matter on 6th November 2025.
My lord, item number 94 is a similar case, my lord. Item number 94 of your lordship.
Let first report come.
Grateful, your lordship.
I don't know. I am for the petitioner in this matter.
I am
for the private respondent.
Though none appears on behalf of the respondent, the petition is directed to communicate this order to the concerned authority for compliance.
Well, I am for the petitioner in this matter.
My lord, I am for the private respondent. I have filed a can. My
service was not done.
Served upon my friend.
A can is there. Yes.
This is my.
What is the can?
Can is about renewal of my passport because
here, my lord.
Who are you?
I am the petitioner. I am the wife. The husband, my lord, he's been implicated in a 490 case. The trial is going on. Yes, maintenance case is also pending before the Diamond Court. No, my lord, I file an application under section 10 of the Passport Act, my lord, for impounding, my lord, his passport.
Before conviction.
My lord.
Before conviction.
No, my lord, kindly come to my lord, section my lord 2, 10 subsection E. My lord, if a criminal case is going on, my lord, he is not paying me, my lord, and if the criminal case is going on, my lord, in that case, my lord, well, since he is the captain of a ship, anytime he is left out, or nothing, no steps.
So he will not work. How the payment will be? The maintenance will be given to you. He will restrain him in India. He is not allowed to go to for the work or employment. So how he will maintain you?
Throughout India, he can work within the India.
So how you can restrain, sir? Where is the law for restraining impounding?
Kindly come to page section 10E. I do not know what application is as we have made.
Okay, let this the can be. I am allowing the can. Let he be added.
My lord, kindly consider A4 of my can. Annexure A4.
I have not been sub to the can.
Page number?
Page number 49, my lord. 49. I have applied for renewal of my passport earlier.
Not granted.
It was granted at that point of time for a limited period. Now, because of this writ, my renewal is.
No, this is for.
Kindly consider the last paragraph.
Yes.
It is my conduct reflects out here. I am present throughout. I am paying. Until and unless I go out and I cannot pay the maintenance. And apart from that, being a merchant, I am a sailor in a merchant ship. I have to comply with all the formalities with Government of India. I only get an entry and exit visa. I cannot even go and enter the country.
Correct.
My only access is to the port.
Correct.
So I'll be there. I undertake. Kindly there be a renewal of.
No, I have not been served with the can, my lord.
Okay. That's how I am.
I've served it right now.
I am allowing it. No. You will
the can application is what formal? I do not know, my lord. Nothing.
Addition of party.
No.
I am already adding party.
For renewal of my passport.
How in the can? How your application can be allowed here? Unless and until you will be a party to the or you.
No. I am the private respondent. I am the private respondent.
Okay, you file what you want.
I want to use an opposition to that their can application.
So why you not file another application before the competent court for renewal?
My lord, we have filed.
Where there is a rejection.
No, there was no rejection. It was, we were said, like, since that writ petition is.
No, the criminal case is, my lord, posted for immediate final hearing.
Since
The
there is
private respondent
writ pending, they have
has
said
filed
nothing
an
to withdraw.
application being CAN number 1 of 2025. Counsel for the petition pressed for time to file affidavit in opposition in connection with CAN 1 of 2020. Let affidavit in opposition be filed within 2 weeks after Puja vacation. Reply, if any, thereto be filed within a week thereafter. Release the matter on 27th of November 2025.
Deeply.
But only one thing, my lord, will it be your lordship's pleasure to, my lord, take up these matters tomorrow also? Because I have item number 26, my lord, where I am challenging a lookout circular.
Which one?
Item number 26, my lord.
Here?
Yes, my lord.
Writ petition tomorrow I will not take. Tomorrow I will not.
Even a